Hey, what's going on, chat? Good morning. Hope you guys are having a beautiful day already. So, time for day 2 of the court hearing. Yesterday we were on the Megyn Kelly show. Today we're going to be on the APT. We're just going to kind of bounce around back and forth on different channels here, so that we're not, leaning one way or the other. Quick disclaimer, 18 plus stream, 18 plus channel. If you are here under the age of 18, ensure that you have your parent guardian's permission to be here. If you don't, I'm going to have to ask you to leave the stream. Appreciate it, guys. This is about protecting children. So, all right, so a little bit of a recap from yesterday. In short, they had no evidence at all. At all. The best evidence that they had was a groundbreaking doorbell camera clip that they had. Actually, it was a compilation of doorbell camera clips, which proved that perhaps Tyler Robinson may have driven and parked at his house. Yeah, groundbreaking stuff. Totally showed that he pulled the trigger on Charlie. But anyways, that's all that they really had, and that was the best evidence that they had. Everything else was just hearsay. Okay. And when you have a buffoon who, a bagel, we call him Bagel, okay? Bagel hears the shot ring out September 10th, right? And he doesn't look to the Losi Center. He looks down at Charlie. Now, why would that be? Why would he look down at Charlie and not at the Losi Center where Tyler supposedly shot from, right? And then there were casings from everywhere else, and it didn't make any sense. What really doesn't make any sense is how Hull, later on in the hearing, he said that Tyler had visited the crime scene 4 separate times. 4. Twice before the shooting, once during the shooting, of course, right? And then the last time in the early hours of the 11th. Tell me how, after they cordon off the area, they secure the area, right, to get all of the evidence needed for the crime scene, to which Bagley, right, shows up, right, brings some guy with him who has a badge and a gun, doesn't know who this guy is, but brings him up with him onto the roof, because at some point he realized, it was a rifle sound. After getting confused and distracted by a bunch of weird stuff, right? Found a handgun holster somewhere in there, right? Somewhere in the courtyard. But then brings some random guy after he realizes that it was a rifle. It was a rifle sound. It was a rifle shot. Gets up to the Losi Center, and then somehow his camera footage cuts off. If you're civilian law enforcement, you know that you must have your body camera footage on at all times during incidences, right? And super sus how it just cuts out. Pretty convenient, right? But after the area is cordoned off, how is it? Because when it comes to a crime scene, you're supposed to secure that area. How is it that he was able to essentially break into a secured area, and then not only that, but get back out of that area without being noticed? How does that make any sense?
Husband told me not to.
It doesn't.
And then, after that, it's a low threshold.
Right, so
Entertain killing people.
there are a lot of weird things going on. They even brought the statements in from the medical examiner, but didn't bring in the medical examiner because the medical examiner was only, was on vacation. He was on vacation. He couldn't be bothered. So, in Utah, they have this law that allows you to bring in evidence called hearsay evidence. So literally, dude, this trial, I can guarantee you this entire trial is gonna turn out to be a trust me, bro. And they're literally going to convict Tyler Robinson on a trust me, bro kind of shit. Right? So what that would mean going forward is some really, really dark shit. If they can convict Robinson going forward of hearsay, they could potentially use that nationwide. I would imagine that's exactly what they would do because we all know how these court systems operate. Right? But what do you guys think? What do you guys think? Let's see. I want to put a poll so you guys could answer.
But for the most part, the use water. Right. So if I have to deal lines, yeah, I'm happy to show up with a brush truck and put water on something.
And I'll just put Tyler instead of.
First you hike straight uphill, and then you.
All right. Poll for the day, guys.
Oh, by at any moment you could.
Poll for the day.
And
make sure you have your pack on.
Do you guys think that they're going to convict him, or do you think he's actually going to get away with it? Because Nestor, which was also a Google trend, right? Which was also a Google trend. In a certain country, along with multiple other things, is something that we've also talked about. Some really sketchy things: the Low C Center, the exact location of the drop off with the rifle, all of these specific locations and people were searched through Google in a very, very questionable country. Why would that be? I don't know.
I agree. Everybody needs to be here, should be.
I don't know. Maybe I'm just a conspiracy theorist, right? So, but I absolutely do believe that they will 100% convict him, even off hearsay. And going forward, they're going to start using that in. Well, they're going to start pushing for that kind of proceeding in other court, in other other hearings. So, but that's a little bit of the recap from yesterday. So, we're still in the preliminary. They took a recess until today. So, also I forgot. I forgot to mention. So, the judge that is hearing this case is the same judge. Excuse me. That was initially over the bricks and minifigs case, right? Let's see, Schneider v bricks and minifigs situation. So if you guys don't know what that is about, there was a guy by the name of Mansell and his son, who was trying to sell $200,000 of Lego collections, right? And they went to a company in Oregon called Bricks and Minifigs to sell that. Well, they had an agreement to split any kind of sales, and then whatever was left over, they would return back to Mansell. Well, what ended up happening was they came. This was back in November of 2023, I believe, and then early in 2024, they came back to that same store to find out that there are new owners, right? So what I'm assuming happened is they tracked down the old owner, right, of the store, and they had reached out to Schneider, which is Reckless Ben on YouTube, right? So a very viral campaign was started to gain public support and to, right, get these missing Legos back. Essentially what happened is they went missing. $200,000 worth of Legos just goes missing. That's, come on, what? So the owner didn't like that, so then he filed a lawsuit, right? And then begins to pressure and really start to harass Reckless Ben. Yo, Zadine, welcome in, bro. Welcome in, man. Everyone, welcome in, Zadine. So then the law enforcement starts harassing him, intimidating him, right? Threatening him, all kinds of stuff. So much so that Reckless Ben, he has to flee the country to Mexico. This was brought up to me in one of my streams a couple weeks ago, I believe. I didn't really think anything of it. This is where it all connects. I didn't really think anything of it until I found out that that judge, right, that was hearing this case initially here in Utah, right, is Judge Graff Jr., right? The same judge that is hearing this case now, right? Because that judge issued a gag order, essentially, issued a gag order to Schneider and tried to have him take all of his videos and content down, covering the whole thing with bricks and minifigs. So one may wonder, you don't really do. I get that, man. I've been doing politics a long time, bro. Way before I was doing gaming content, so.
Yeah. So I just want to make sure I'm doing that.
But welcome on in, bro. Appreciate you, buddy. Probably not gonna be doing a whole lot of gaming content this week. Just gonna let you guys know that now. I will still try to do ARK Wednesday night, but we'll see how that goes. So, but I appreciate you stopping in and saying hi, man. I really appreciate the support, dude. It means a lot, so thank you. Dub to Zadine. Dub Zadine. My boy. Appreciate you, buddy. All right. Also, another thing to note, which I thought was extremely weird, was that when Erica Kirk walks in, she doesn't walk in with Charlie's family. No, she walks in with Don Trump Jr. First of all, why is Donald Trump Jr. there? And why is he also with Erica Kirk? Well, when you know that, back in 2012, Erica was running for Miss Arizona, that so happened to have been hosted by Donald Trump. And then you also know that Erica Kirk's father was in the CIA. And that she was also doing training videos for the CIA. And that she also had an orphanage, or was it an orphanage? I think it was an orphanage called, it was called something Angels, I think. In Romania, yeah. And that's real because she posed for pictures with US troops. Yo. Politics means I'm getting fucked. I just picked the color. Yeah, pretty much, dude. Yeah. When you have an international cabal, right, that is hell bent on waging a war on social class, right? Essentially, as humanity has done, right, for thousands of years, waged war, right, against status to enslave those, right, and benefit their own bloodline. It happens all the time, bro. That's all it ever sees. That's all it ever seems like. So it is 11:02 right now. It's 11:02 and starting.
Calling case number 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grunander, Ryan McBride, David Sturgill, Lauren Hunt for the state, Jeff Gray, the county attorney, as well as Chris Miller are also present.
Good morning.
Someone needs to turn their radio
Good morning,
off.
Your Honor. Good morning, Your Honor. Good morning, Your Honor.
All right.
Kathy Nestor, Michael Burt, Richard Novak, Stacy Visser here for Mr. Robinson, who's seated to my right.
Good morning, counsel. Good morning, Mr. Robinson.
I'm also eating.
And for the record, the
Meal
court
prep.
also recognizes the presence of
This is
victim
my breakfast I haven't eaten
representative,
yet.
Ms. Erica Kirk. Good morning. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during proceedings will not be permitted to re-enter until recess.
Okay, so they're just going over the rules of the court. Got it. So this is the hearing over the Charlie Kirk shooting. Okay. This guy here is Tyler Robinson, and he is the patsy for definitely not an inside job. Definitely not an inside job to frame people on the left, to convince the people on the right to keep fighting the left, because people on the right are fighting the left, the people on the left are fighting the right. It's definitely not that. Definitely not orchestrated by our greatest ally, for sure. Definitely not, okay? But yeah, he is he's pleading innocent, and this is a preliminary hearing that they're using hearsay on, in which they'll probably use hearsay on the entire case. I'm just letting you guys, I can guarantee you they're going to just use hearsay throughout the entire case. But most of the hearing yesterday was nothing but hearsay. There was one thing that they showed, and it was a doorbell camera compilation of clips, which proved absolutely nothing. So that's what's going on. They brought two people in, and both of them were like, "Yo, trust me, bro," and that was that. They couldn't get their facts straight at all. Like at all, they couldn't get their facts straight. If you guys have your coffee, drink your coffee with me. I got this one in Germany. See if I can. Yep. Got this one when I was stationed in Germany. It's a good mug. It's a really good mug. Probably throughout the day, I'll probably just make some more coffee because probably gonna need it. Along with maybe some ibuprofen. Because this is gonna be this is gonna be a massive headache for all of us here, guys.
Is it working? Can you send them a link to the
Oh, dude, you're going to Germany?
This is being streamed, so they have something to look at.
Nice, bro. What? I'm gonna silence that real quick. We'll check on it here. Okay, okay, we're still live. Cool. Yo, Amadiao, welcome back in. Did I pronounce that correctly? Amadiao. Why is that so fun? Why is that so fun to say Amadiao? Yo, that's crazy, man. Amadiao. Why does it sound like I'm saying something bad? But what part of Germany are you going to, bro? I'm going for Gamescom. Oh, nice. It's gaming convention. If the name didn't, no, it definitely didn't. No, I had no idea.
Today's the purpose of this is to ensure clarity regarding the expectations governing today's proceedings. Could you both state your name for the record?
Yes, Trent Nelson with the Salt Lake Tribune as the pool still photographer.
Make sure you guys are welcoming in Zadine and Amadiao. I'm just going to call you Ama. Is that fine? I'm going to call you Ama. So make sure you guys are welcoming in each other.
To your activities
Dozen
today.
people have pointed that out before.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
Oh, yeah?
Do you anticipate
Okay, cool.
any difficulty complying with the order or today or with
Cologne
the
or
court's
Cologne,
instructions?
whatever spelling you choose.
All right. Well, thank you. I appreciate your cooperation today.
Huh? What? Oh, okay. Okay, I see.
As we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of
Usually
the public.
a joke.
The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk.
Amadiao.
In furtherance of those important interests, all persons
You know what that reminds me
attending
of?
these proceedings are reminded that portable electronic devices.
You know what that reminds me of? It reminds me of Ahmediabad. Ahmediabad. You guys know what that is? It was a huge meme back in 2019, 2020. Yes, especially for food, okay? All right. Listen, guys. Listen, okay? You guys got to hear me out. All right? So okay. My local restaurant, right? There's a local restaurant just like 10 minutes down the street, right? And they have this burger called the Donut Burger, the Donut Bacon Burger, okay? Hear me, listen, hear me out, okay? If you put a donut and a burger together, you are going to lure me into a white van, okay? I'm disappearing. You'll see me in Venezuela, fucking mining in some coal mines or some shit. But it's worth it. It's worth it for that donut bacon burger, okay? All right. I'm a hoe for food. Okay. I'm just going to let you guys know that now.
counsel for both the defense and prosecution during yesterday's proceedings. It is evident to the court that each of you approach this matter with seriousness, preparation, and a deep commitment to your respected responsibilities. The court appreciates the care which you have taken in advocating for your positions and the respectful manner in which you have done so. Thank you. Do either party require the benefit of the record before we proceed?
The state does, Your Honor. Mr. McBride. address the
There's
court.
nothing better than
Just as a reminder, the
combining
microphones at council
as many
table are
good
turned off
tasting
to
foods
prevent
together,
the inadvertent
right,
capture
to make
of
it
any
one
communication. So
delicious,
we'd like to come
irresistible,
forward.
tasty
Thank
food,
you,
you know?
And turning to Mr. McBride.
Thank you, Your Honor. Before this hearing, the defense moved to find Article 1, Section 12 of the Utah Constitution, Rule 7B, and Rule 1102 unconstitutional as it relates to the admissibility of hearsay and reliable hearsay at this hearing. The issue was extensively briefed and argued. The court denied the defense motion to exclude the use of reliable hearsay at the preliminary hearing. That ruling is at docket number 631. In addition, defense counsel filed a standing objection on July 3rd. That's docket 678. The standing objection reasserted the arguments made in defendant's previous motion. Defendant continues to make these same objections throughout the testimony of each witness. I believe both the state and the court and everyone present knows that the defense objects to the use of hearsay or reliable hearsay at this hearing. On the point of preserving the objection, that has been done. Defense counsel has filed their motion, they filed their standing objection. Throughout the proceeding, they have continued to make objections. At this point, further objection is unnecessary to preserve the record and causes undue and unnecessary delay. This is needless delay, and we'd ask the court to acknowledge
Well, I was wanting to do that with
and
the other
record
window,
to
but-
reflect the standing
All right,
objection.
whatever.
And we also ask the court to give an instruction that continuing objections on this ground are unnecessary. Of course, if it relates to some other ground or is some item that's particular to a particular statement, that objection may be appropriate. But at this point, we feel that the repeated objections that have been made and already been ruled upon are unnecessary and cause undue delay.
Thank you, Mr. McBride. To
Oh, do
defense.
Oh, you mean like almost doxing
Good morning,
someone?
Your Honor. Michael Burt for Mr. Robinson. We have no objection to that procedure as long as the court makes a ruling that the objections are preserved. We do think it would expedite matters if we didn't have to repeat the standing objection. There may be particular objections that are not covered by the standing objection we've made, and so we ask permission to be allowed to make those objections as needed.
Thank you, Mr. Burt. Thank you to both sides. I appreciate the presentation and your argument about this. The court takes no position in regards to whether the objection is made again and again or not. I leave that to the parties. I recognize the need to expedite this, and if both sides stipulate, I will adopt the request that the standing objection as it relates to 1102, Article 1, Section 12 of the Utah Constitution, and all relevant authorities that have been cited have been noted, and the standing objection by defense is in place. However, if defense feels the need to do that in order to protect the constitutional rights of Mr. Robinson, the court will not prevent that, nor stand in its way. This court is not is acting in the role of a magistrate and will allow the parties to move forward as necessary. But as noted, I will make that note that the standing objection has been noted for all of the yesterday's proceedings and will be in place throughout the rest of the preliminary hearing. Anything further or any need for the record given the court's statement?
Not from the state.
No, Your Honor.
All right, thank you. All right, the court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. And again, I will leave it to the parties to monitor the courtroom to ensure that if a witness has come in and they shouldn't be, that they are redirected.
Yeah, make sure you're being safe at that convention, Zadine. Okay? Please make sure you're safe, okay?
And Agent Hull, you are still under oath. Mr. Sturgill?
Thank you, Judge.
And before we begin, is there a way
Brush-
to dim these
Brush Man
lights
is
just a tad
back.
like we did yesterday? Perfect. Thank you. All right. As of yesterday,
Why
there
dim
is
the lights?
also
Are you
a
gonna
water
start playing
bulb to
Fur
your
Elise?
left. And if
So
you
everyone
wouldn't
take
mind
a
just making sure
nap
that
break. What the
microphone is
fuck?
directly in front of you, we want to make sure that the record picks up your testimony today. Mr. Sturgill.
Oh, yeah?
Your
That's cool.
witness.
Thank you, Judge. Agent Hull, we're going to return to what has been marked State's Exhibit 12.1. There was reference to
What's
it
a dad?
yesterday. And I'd like to ask you again, have you reviewed that exhibit? And if you wouldn't mind, just briefly remind us what that
His mic isn't
exhibit
up?
consists of.
The exhibit is a compilation or a running of a summary of videos from UVU campus security footage obtained.
Okay.
Is
And that's what I hear. So let's go ahead and
Yeah.
stop. I'm not hearing it, so I'm going to have you repeat. Let's test it. Go ahead.
Check.
All right, I believe that. Thank you. Mr. Sturgill, if you wouldn't mind restarting.
I
so
can
the-
do that, Judge.
Thank you.
Maybe bring the mic from the base a little bit closer to you. I don't know if that'll help. All right, let's go ahead and go back to what's been marked as State's Exhibit 12.1. I'd asked you a moment ago if you'd reviewed that exhibit.
Yes, I have.
Okay. And would you just remind us
Nice.
what that exhibit consists of?
It's a compilation of videos that were part of the overall footage that was obtained from the Utah Valley University as part of the investigation.
And does that compilation video, from your point of view, capture Mr. Robinson arriving to and visiting the UVU campus
It does, yes.
on September 10th through the 11th, 2025?
Correct.
Okay, and again, I asked you this question yesterday, but did you prepare that video compilation?
I did not.
Okay, do you know who did?
The Utah County Attorney's Office.
Does that video, and I'm referring to 12.1 exhibit, State's Exhibit 12.1, does it include all of the footage collected by the SBI from UVU?
It does not, no.
Does that video, again, 12.1, include all of the footage you collected from?
Oh, also, I wanted to make a point of this real quick. They tried to use altered footage yesterday as a part of the evidence. Altered. And they didn't even have the raw footage. So they needed like a couple of days to get the raw footage. Real suspect.
I did, yes.
And I believe that has actually been admitted into evidence as State's Exhibit 12.3. Did Mr. Olson refer to that exhibit, 12.1, in his statement?
He did, yes.
Okay. 12.3. I'm going to put on your monitor State's Exhibit 12.3, and I ask that it be scroll down towards the very bottom. And I would ask that you read from the statement specifically what Mr. Olson said about State's Exhibit 12.1. And I want to narrow your focus, so I'm going to draw your attention about 3/4 down the page. There's a sentence that begins on the left margin, "I have reviewed." Do you see that?
I do, yes.
Okay, would you please read that sentence?
I have reviewed State's Exhibit 12.1, and the recordings are true and accurate, including timestamps, dates, and camera labels. The only changes are some zooms and red highlights, which were not part of the original recording.
Okay.
Would
Have
like me to-
you, I'm sorry?
Sorry, I didn't know if you wanted me to continue. Or...
No, that's good enough. Have you had a chance, well, you reviewed the raw footage yourself, is that correct?
Correct.
And does that comport with your viewpoint of that exhibit?
It does, yes.
Have you had a chance to review what's been marked as State's Exhibit 12.4?
Yes.
Okay, and when did you review that exhibit?
This morning,
And who did you review that exhibit with?
with Kimberly Durfler.
Okay, was there any conversation about that exhibit?
No, I was just shown the video.
Okay. Nobody asked you questions or suggested anything to you?
They did not know.
Why?
Did you prepare that exhibit?
I did not.
Do you know who did?
The Utah County Attorney's Office.
All right. And I'm referring specifically to what's been marked State's Exhibit 12.4.
hearsay.
What is depicted in that video?
That video is, again, a compilation of videos from the overall footage that was obtained from Utah Valley University for September 11th and September 12th.
And how does it compare to what's been marked as State's Exhibit 12.1?
It appears to be the same footage. However, on this particular version, there were no circles or blurs that had been made to the video.
How about zooming in and zooming out?
No, there was no zooming or zooming out.
Does it appear to be identical to the raw footage that you've seen that portrays this particular part of the UVU surveillance video?
It does, yes.
Judge, the state would move to admit what's been marked State's Exhibit 12.4.
And
Your Honor, we just object to the publication of this for all the reasons we argued yesterday. We think this video is going to play a big role in the trial, and to allow the public to see it now would seriously impact our ability to get a fair trial, and we're asking the court not to publish it.
thank you. And Mr. Sturgill, and to all counsel, as it will apply to all counsel, when you are moving a piece of evidence, it's the three parts, whether admissibility into the record,
Right.
to be published in the courtroom, and captured by the media. So, Mr. Sturgill, as it's your request, what are you requesting?
Judge, first of all, clearly I'd move to admit the exhibit. I'd ask, and Judge, the presumption is that this is a public record and should be published. And so the state's position is that it should be published here in the courtroom, and it should be published in such a way that the media can capture it on video.
All right.
Your Honor, can I be heard on that very briefly?
You may, if you would approach the lectern, please, and state your name.
I'm David Ryman. I represent the news media. I didn't make an appearance because the news media technically aren't parties, but as you know, they do have the right to be heard on issues like this, and I've tried to keep that to a minimum. But since this is the first one coming up today, I thought it might be helpful to just address it again. There is a presumption not just that it be published in the courtroom, as we talked about yesterday, because the participants or the spectators in the courtroom have a right to know what the court is viewing so that they can understand how you're making your decision. This seems like a very important piece of evidence. It doesn't seem like there is a basis to keep the people who are in the courtroom today from understanding why it's being introduced. It is not like the videos yesterday, and my understanding at least is, and you can correct me if I'm wrong.
Not like
but
the videos from
we didn't
yesterday.
object to the videos that weren't published yesterday that were graphic. We didn't object to the non-publication of the autopsy report. The argument here that Ms. Nestor just made is this seems really relevant, and that is precisely why it needs to be public. With the last thing I'll address is just EMC. There is a presumption.
Relevant?
It's a
You mean
rule
like the
presumption,
doorbell
not a
camera?
constitutional one, that EMC is allowed. And I think that for all of the reasons that we've briefed this for Your Honor several different ways, there needs to be a really good reason why. You know, if it's being published in a public proceeding
What do
in the
I think?
courtroom, it should not also be.
I think he will
and it should not
absolutely
also
be
be allowed to
convicted.
be,
The fact
published in
that
the media.
Utah is allowing spectral,
Thank you.
hearsay, right?
Mr.
Literally
Sturgill,
evidence
do you
based
wish
on
to
trust me,
respond,
bro.
Or
It's really
perhaps,
suspect
give a
that
little bit more
they're
detail
going to
on
convict him.
what this video purports to show.
Well, do you want me to proffer that, Judge, or have the witness?
And if you've been following this whole thing for as long as I have, I've been covering this entire thing ever since the very beginning, right? I've been talking about this for a very long time. And there's a specific narrative that they're really going to be pushing for the FBI, the media, right? Our leadership here in the U.S. They're going to do everything they can to convict him, right? Which is why this case is happening in Utah. So, they are trying to prove that Robinson did it. However, the best evidence that they have brought forward is literally just doorbell camera footage. That's it. Everything else has been hearsay. Everything else has been secondary, right? Secondary evidence, you know. Literally, trust me, bro. So,
Clarify that.
but they're going to
Mr.
convict
Nestor,
him.
Given that additional information and anything further from defense.
I wouldn't be surprised if they did.
Mr. Burt's he's the one who's been litigating all of the First Amendment issues, if he could address Mr. Ryman's argument.
Yes, Mr. Burt, if you wouldn't mind coming forward.
Because they have to do this, right? They found
Judge,
their
I wanted
guy, so they're going to push
clarify
forward.
one argument that was made by counsel for the media yesterday, and that was the rules, the Rule 4-202.02
Explain it, Chad, evidence
does not
for-
apply to the situation we're in.
Explains chat evidence for shooting. Okay, so, uh-oh. Okay, so the mainstream narrative is that Tyler Robinson is the one who shot Charlie Kirk, right? But he shot Charlie Kirk with a 30-06, and he shot him from the Low C Center, which he had a straight line. Do I happen to have a map here? I'm just going
Does
to
apply
play
here.
that.
And
while I'm
also
looking for the map
applicable
here.
is the Supreme Court's decision in the Kearns case, which we talked about when we argued the motion for denying access to the cameras. And that case, Kearns versus Tribune Corporation, 685 Pacific 2nd, 515, says that the standard the court ought to apply in determining whether an exhibit at a preliminary hearing should be sealed is one of a, quote, realistic likelihood of prejudice. And we rely on the evidentiary showing we've made in connection with our motion to exclude cameras, that there is a realistic likelihood of prejudice in this way. The court knows and has access to the media coverage up to the time when we litigated the motion concerning.
All right, so Tyler Robinson is supposedly the guy who shot Charlie, right? So September 10th, Charlie Kirk hosted an event at Utah Valley University, and he hosted it here. This is the courtyard. Around noon, a shot rang out, and I would say anywhere between 12 and 2. Shot rang out, and supposedly Tyler Robinson shot from here, right? But he got onto this building somehow and was able to reassemble a rifle. That means put on a scope that was not zeroed. Every time you put on a new scope or the same scope, you have to do something called zeroing, which means you have to make it accurate. But somehow did that, and then shot Tyler in the neck in his C2, which makes no sense because for a lot of reasons, ballistics, trajectory, stuff like that. But then shot him, ran off, and that's where a lot of the recording starts of him running with the rifle in his pants, right? While it's disassembled again, right, to fit it in his pants again, jumps off of the building, right? Literally just walks and blends in with everyone else, and then walks right off campus. Okay, so that's the narrative, and then he came back later that night, right, when this is supposed to be cordoned off and secured. Came back later that night, right, which none of the cameras caught, but somehow he went back into the early hours of the 11th, right? So, but that's supposedly what happened. He was shot with a 30-06, which I've already talked about yesterday. There's no way that could have happened, but we can get into that on break. So,
At the court
but until then,
found
I gotta
public
be.
because
I'm gonna be right
you
back.
have so many other
I gotta go to
tools
the
to
restroom,
seat a
guys.
fair and impartial jury. And we have cited that case repeatedly, and so has Your Honor, I think, recognized it in your ruling, saying pretrial publicity can coexist with the defendant's right to a fair trial. So the last thing I'll say is just that the constitutional standard that I think we're all agreeing applies here is weighty and difficult to overcome. And it is never satisfied, as we've explained, by just generalized assertions that there's a lot of publicity out there. It's got to be something really specific, and they just haven't made that showing. And I certainly don't think that a video that apparently just shows the defendant walking around the UVU campus qualifies.
Thank you. Anything further?
Judge, from the state, no, but I think I'd like to be crystal clear. You asked if there's any portion of this video that captures, and I believe you asked of the actual shooting. There's no video of that. There is video, however, and you've heard testimony related to this, where the shooter goes to the top of the Low-C building, goes out to the edge of the building, low crawls, and then leaves after what we assume is the shot being fired. That's as close as it gets. I don't know if that makes a difference, Judge. I just wanted to make the record clear, and I want to be crystal clear with Your Honor.
Thank you, I appreciate that. Clarification, as it is guiding for this court and making its ruling. I turn to Utah, well, let me pull this up. So Rule 4-202.02. I go down to, well, first it says statement of the rule. 1, presumption of public court records. Court records are public unless otherwise classified by this rule. 2, public court records include but are not limited to, and I'm going to go down to 2J, exhibits, but the judge may regulate or deny access to ensure the integrity of the exhibit, a fair trial, or interests favoring closure. And the court recognizes the importance of the constitutional rights of Mr. Robinson being upheld and protected. At the same time, the court also recognizes the importance of transparency and a proper balance to ensure that the constitutional rights of all parties are upheld. As it relates to this exhibit, I believe it's 12.4.
12.4, yes.
Based off the
Even though some of you guys that are popping in here, this isn't like your kind of content, I do appreciate you guys supporting the channel, supporting me. It really means a lot. So thank you guys.
And Exhibit 9, as those are different in nature, and those go to issues relating to Utah Constitution, Article 1, Section 28, as it relates to the Declaration of the Rights of Crime Victims. And the court also recognizes Utah Rule of Evidence 1102, as that is the foundation that's being laid for the admission of this exhibit. Having taken in consideration all factors, the court rules that Exhibit 12.4 is admitted into evidence and shall be played in the courtroom and may be broadcast by the media. We can proceed.
Thank you, Judge. Agent Hall, before we actually watch State's Exhibit 12.4, I have just a few questions. Yesterday, you testified at the very beginning of your investigation that you focused on the video that captured the shooter on the top of the Low-C building. Is that correct?
Yes.
I believe you also testified that you began by working your way, and this is what I remember you saying, so correct me if I'm wrong, but you in essence testified that you began with that video and you started working your way backward and forward with the UVU surveillance video in an effort to trace the shooter's steps on campus. Is that right?
Correct.
Okay. Would you mind explaining just in a little bit more detail what you meant by that, tracking forward and backward on that video?
Yeah, we had a known when the shooting occurred. And as the officer testified, there was a video of an individual on the roof at the time of the shooting. And so the philosophy that we applied was to take what we knew and then work that forward through the timeline and backwards through the timeline to try and establish where the individual had gone from the rooftop or how the individual had come to be on the rooftop.
And did that, for lack of a better term, did that bear fruit?
It did,
Did you
yes.
actually see from, at least in part, where he came from and where that shooter went?
Yes, more so where he came from. It was very limited after the fact.
You testified yesterday that, in reference, I believe, to what's marked State's Exhibit 21, that you believe Mr. Robinson visited campus at least 4 times on the 10th and the 11th.
Correct.
And I think you reaffirmed that today. Did you do the same, attempt that is, to track Mr. Robinson through UVU surveillance video during each of those 4 visits?
Yes.
Or those other 3 visits, I guess?
Yes, on each occasion, we attempted to follow the movements of the individual throughout campus.
And did you in fact see Mr. Robinson on campus in surveillance video that is not included in State's Exhibit 12.4?
Yes, there is additional footage of him on campus, yes.
Okay. I'm going to have displayed on your monitor. What you're going to see is a paused or a still image. And I'm going to ask if you recognize what, you see that now, Agent Hall?
I do, yes.
Okay. Do you recognize what's displayed on your monitor?
Yes, it's footage from the university that was provided to us, particularly of the parking structure.
Okay. Does it appear
Oh,
to be
I'm sure you-
State's Exhibit 12.4?
Sorry, guys.
It does, yes.
So I'm going to go ahead and I'm going to have this video run.
I'm getting some
And
stuff
if you
together.
don't mind, as it's running, I'm probably going to be asking you some questions. And so.
I'm gonna show you something.
This video has no audio, is that right?
No, there's no audio on the cameras.
Okay. Let's go ahead and start the video.
It's just not up on the screen yet. Maybe
Let's go ahead and put it on all screens. No, I appreciate. It is, so it is admitted and
Oh, is this
may
the
be
raw
published
footage?
to the screens.
Is this the unedited
and, just wanna
footage
make
that we
sure it's
have
on your
here?
Screen, Agent.
Looks like they
Alright.
did step their game up. At least they
All
have
right,
the actual
Mr.
footage
Sturgill, you may proceed.
and not
Appreciate that,
edited
Chris.
or
Thank you.
altered in any way footage.
Okay, what are we seeing here, Agent Hall?
Yeah, probably
It's
not.
a
Yeah.
vehicle is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe that this particular
Damn.
vehicle
Why can I
belongs to
not
Mr.
have
Robinson?
anything that nice?
Information
The fuck,
that
bro?
was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very
Yeah.
distinct, but
Yeah, that
predominantly
car is
the
nice.
wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red T-shirt.
But
and
what
the
does this
shorts
prove,
and the
dude?
shoes.
And do you believe you recognize who that person is?
Yes,
Who is that?
I believe that's Tyler Robinson.
All right, and where does he go from there?
That's
He
not.
heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area?
Sorry, the amphitheater is what I previously referred it to.
All right. So he goes up on campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
Okay. Where's the evidence of him with a rifle or with him stinting with a rifle? Like,
And
what's...
where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving the vehicle.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video. And he's
Right.
carrying a blue backpack.
Describe the clothing.
It's a maroon colored t-shirt with gray or olive colored shorts and then Converse shoes.
And what time did he return to campus?
Just after 10 a.m.
And does he leave the parking structure eventually?
He does, yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building and purchased some food, sat and ate the food. Then,
And
I'm sorry,
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation
Whoa.
to
Hang
the
on.
amphitheater
Hang
or
on. No. Okay, all right. Pull that
kind of
shit
on the
back up.
northeast side
Pull
of the
that shit
amphitheater.
back up.
It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus. We noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building.
You're talking about
I'm sorry?
you're talking about Luigi Mangione, right? Shooting the United Healthcare CEO. He also went to a fast food chain. Seems like we gotta start staying away from fast food for more reasons than one. Yo, Ama's got the deets. Yo, dub to Ama.
AM or just after, if I recall. I could verify from my notes if you need an exact time.
Yeah, if you don't mind. That'll help you remember, refer to it. Don't read it out loud. Just let me know when you've had a chance to look at that, would you?
So he's wearing a different shirt, different pants, different shoes, it looks like, too.
Were you able to refresh your memory as far as the time?
I was, yes.
And what time was it?
It was just prior to 11 a.m. when he walked off campus.
Okay. And before we go any further, the parking structure that he left initially, where is that parking structure in relation to the LDS Institute building?
I'm sorry, in relation to?
The LDS Institute building on campus?
I think it would be just to the north of the LDS Institute building, if I recall.
Do you recall whether it was adjacent to the LDS Institute?
Yes, it is.
Okay. All right. What do we see displayed here now? Go ahead.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
And this takes just a moment.
Wait, that's the same footage that we've seen.
And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
This is the best
The
that
shoes
they
are the
have.
same, and the images that we have are from my viewing and seeing Mr. Robinson on the video. It's the
Dude,
same
he
person.
forgot that he couldn't bend his
He's
legs. So he-
noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Okay. Now what do we see?
This is Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
Are they really going to suggest that he had a
And again, were you able
rifle
to
in
track-
his pants at
were you
that
able to
point in
track
time?
Mr. Robinson when he leaves this parking structure?
Yes, we were able to.
Okay. So when he leaves the parking structure, where does he go?
He comes up around Campus Drive. As you can see on the video here, there is a cut through there north of the Losi building, and that's Mr. Robinson coming up the sidewalk. He has the noticeable gait or limp in his walk. And then he moves south across the front of the Losi building.
On the sidewalk?
Yes, correct.
Okay.
He would be the rear of the two individuals in this particular video.
So right now, if you were to break this picture into quadrants, where would he be?
He would be in the top left quadrant, walking to the left of the image.
Now what do we see?
This is an image looking across the parking lot to the Losi building, and Mr.
Video
Robinson is
blur.
appearing on the exterior staircase, which gives access to the Losi building roof and the area where the railing was.
And again, let's break that image into quadrants. Where would he be located if you broke it into quadrants?
It's in the top right, and the individual can be seen moving under the notations that are on the video.
Okay. And what time is this?
It's just afternoon, about 12:15
On what day?
on September 10th, 2025.
What just happened, or what did we just see happen?
Oh,
The individual
also,
actually
Amma, thanks for the follow. I appreciate you joining.
building.
All right. Go ahead, sorry.
And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building to what would be the southwest corner of the building, crouching down and then crawling to the corner of the building.
And this is at what time?
I don't see
Around
anything.
12:23. I think the timestamp on the video is 12:22
On the 10th.
I don't see anything.
on September 10th, yes,
So
2025.
we're clear, this is the roof of the Losi building.
Correct.
I don't see anything.
Can you still see that individual?
Yes, you can, laying prone.
Where? I'm assuming he's supposed to be right here. But I don't, right there, that small dot?
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. Individual then stands up and then moves across the
Oh,
building
he's
to
next
the
to
north.
the tree.
Is that what we're seeing happening right now?
It is, yes. They move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Ah,
Do you see Mr. Robinson now?
I do, yes. He's just arriving at the corner of the building, almost the top center of the image.
he's the tree
What
shadow.
are we seeing now?
And Mr. Robinson
always in the
lowering and
woodline.
jumping off of the roof of the Losi building onto the grass area,
Oh, dude, how
and then
does
moving away towards Campus Drive.
no one see this? Chat, how does no
He
one
appears
see
to be
this,
carrying
man?
some kind of an object in his hand at this time.
Why would he be carrying anything? It's in his pants, right? Like dude, he just goes to
So
walking,
he's approaching,
like
Campus
he's just
Drive.
blending back in.
and again, broken into quadrants. Where is he currently?
Be in the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
What do we see now?
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive. That's the vehicle that's driven by Mr. Robinson.
And on the screen, where is that vehicle that you're referring to located, if you broke it into quadrants?
It's on the
Hey,
left
KSI,
side. On the
welcome
upper
in, man.
Side, the upper
Welcome in, bro. Everyone welcome in KSI.
Now what do we see?
That vehicle's now pulling away and heading east on 800 South.
And why do you believe that that vehicle is Mr. Robinson's vehicle?
When that vehicle was stopped, it actually made contact with an officer who was doing security detail.
Okay, and do you know who that officer is? or
Officer
was?
Goforth,
Okay, and do you know which department he works for?
Spanish Fork Police.
And did you have a conversation with Mr. Goforth regarding this interaction at that intersection?
I did, yes.
Okay, and what time was that interaction? I'm sorry, did I ask you that?
It was approximately 12:30 a.m.
On the 11th?
on September 11th, 2025.
So you talked to Officer Goforth about that contact on the corner on that, during the early morning hours of the 11th?
Correct.
And what did Officer Goforth tell you about that interaction?
It was an interaction that, I guess cop intuition, but there was something about the interaction that made him make a note of the license plate of the vehicle.
Why are we not hearing
And
from
then
him specific?
subsequently,
Bro, why are we not
when
hearing from him
information
directly?
was available that vehicle, or a vehicle matching the description of that, was involved in the incident, he ran the information that he had obtained from the stop and was able to identify that it was registered to Mr. Robinson, and he had in fact had contact with Mr. Robinson on the morning of September 11th, 2025.
The information that he ran, do you know what information when you say that, he ran information?
Yes, he ran a partial plate.
Okay. A license plate?
Correct.
And based on that partial license plate, he was able to identify the owner of that vehicle?
Yes.
And did he tell you who the owner of that vehicle was?
He did, yes.
Okay, and who did he tell you that it belonged to?
Said there were two registered owners of the vehicle, Tyler Robinson and an Amber Robinson.
Did he say anything about the person that he actually interacted with?
Yes, it was a male that he believed to be Tyler Robinson.
Okay.
Why are we not hearing from this security guy? Why are we not hearing from him?
Let's return again to what's been marked Stakes Exhibit 12.1. Again, you've reviewed that video.
Yes.
And the difference between 12.1, or what's been marked as Stakes Exhibit 12.1, and 12.4 are, if I understand you correctly, are these enhancements that we've been talking about.
Yes.
And specifically, be specific about the enhancements, and let's go one at a time.
Okay.
I think there's a reference to either red circles or red highlights. I think
Correct.
That's how Mr. Olson described it, red highlights.
Yes.
Do you know what he's, or what is he referencing by the red highlights, or what do you believe he's referencing?
I believe he's referring to red ovals or circles that were placed over the image to identify specific individuals of note.
And these red circles, are they permanent red circles? Are they temporary?
I'm
Different.
I would assume they are temporary. I'm not very technological, but I believe they would be overlaid over the image.
And that is a bad question. What I mean by that is do they appear and disappear quickly, or do they linger or last for a period of time?
They're there for a notable period, but I believe they come off the video. But
All right.
Well, if they wanted,
other than
if they wanted to bring actual evidence, why not bring the actual witnesses in? I mean, it makes sense, right? Why not bring the medical examiner in? Why not bring the security person in? Why not bring the other guy that was with Bagel, right? The guy with the badge and the gun. And Bagel said he had no idea who this guy was, but he had a badge and a gun. Why not bring any of these people in who were there, right?
do you know what that Tell us what that is.
Instead
What
of just
blurring do you
doing
see
hearsay.
in state, what's been marked as State's Exhibit 12.1 that you now don't see in 12.4?
If I recall, there were some individuals in the parking garage footage and their faces were blurred. Excuse me.
Is anything other than faces being blurred?
Not that I recall, no.
And how often do you see the blurring throughout the video?
I believe it's just in the original sequence in the parking garage.
The other than the blurring, does the blurring, other than obviously blur out part of the image, does it change or impact the accuracy in your mind of that part of the compilation video?
Not to my knowledge, no.
And then the last thing is, I believe, is there's some zooming in and zooming out that's in 12.1 that has been removed
Yes.
from 12.4. What can you tell us about the zooming in and the zooming out?
Predominantly, it's in the area that was referred to as viewing the Losi building rooftop. I believe it focuses on the area where Mr. Robinson comes up the stairs and onto the rooftop. Those portions of that particular footage were zoomed in for clarity.
Other than zooming in and zooming out, does at least that
Of which we
enhancement
didn't
of the
see.
video, does it change the content of the video,
No,
the accuracy of the video in your mind?
no.
Okay.
Yo, chat. Isn't it weird? Isn't it weird how the next day they had all of these pictures zoomed in of Tyler jumping off of that roof in that particular moment, but didn't have all of this footage until literally today? Isn't that weird? Isn't that really weird?
With the area and what's trying to be shown, they allow an opportunity for people to look at an individual who we believe to be Tyler Robinson, and also specific movements with more clarity than the original focal point gives.
So let's talk about the zooming in and the zooming out. It sounds like it's specific to the Losi rooftop, if I understand you correctly.
Yes.
Okay. And I think we've all watched that exhibit.
Correct.
4. And although you can see Mr. Robinson and his movements, is it fair to say that it's difficult to really see what's going on?
That would be fair, yes.
Okay. And the version that's in 12.1, does it facilitate at least that part of the video, seeing Mr. Robinson and tracking, I guess, his steps?
I believe so, yes.
Okay. Judge, at this point, I think in combination with yesterday, the foundation that was laid yesterday, including the written statement from Mr. Olson, which has been admitted into evidence and is, it's already been admitted to evidence. We believe there's enough foundation that at this point we'd also ask the court to admit what's been marked State's Exhibit 12.1. We think it would be beneficial for Your Honor to view it.
Ms. Nestor.
Thank you, Your Honor. We renew our authenticity objection, and we also object to for admission purposes. And then we also object to the publication for the same reasons, the fair trial issues that we raised with the unaltered version that was just submitted.
And Judge, sorry, I neglected to mention the other two. Again, Judge, we believe that the presumption is that this is a public record, that it should be not only admitted, but it should be published here in the courtroom, and it should be published in such a way that the media can have access to it.
All right. I do have a question in just directing your attention to the Utah Rule of Evidence 403, to the last phrase, the last 4 words in that. Do you wish to address that?
Judge, I'm going to have to look at 403 specifically for those last 4 words, unless you want to share that with me.
I can read that. Or
Okay, go ahead and
needlessly
read that.
presenting cumulative evidence. So the court may, let me just read the whole rule for completeness. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. I'm not looking at anything else other than that last portion. I recognize there is no jury. I am the magistrate, I am the fact finder, but just addressing that last point of Rule 403.
Right. Judge, well, I don't believe that the evidence is cumulative. I think that each of the two videos, although they portray basically the same footage.
Uh-oh. Uh-oh. Uh-oh, let's see if they're also
Playing
having an
it in the
issue.
courtroom or on television, well, for the media.
Okay,
What's
they're
going
not.
on.
Okay.
And for the public to see what's going on.
That was
And
weird.
we've displayed 12.4 on the video.
That was weird.
And unless you have very, very, very good vision or you've zoomed in on that monitor, you really can't see what Agent Hull has just described. The character of 12.1 is it simply, it enhances that at least important parts of that exhibit, and it just makes it easier to see, not only by Your Honor, but also by the public. And specifically as it relates to the zooming in and the zooming out.
Okay. Anything further from the parties as it relates to 12.1? All right, well, I will admit 12.1 into evidence, but as it relates to playing it in the courtroom or on television, well, for the media, I find that it is, well, as the fact finder, I will look at the evidence and weigh it as a magistrate is required to do, but I do not find it is I don't find it's necessary to replay this video, given the representation that it's the exact same video, the difference being enhancements made. If it was different in any way, or if it added to or subtracted from, that would be one factor. But because it's simply the same video, simply zooming in with circles or notations, the court does not find that the interest of justice requires it being played again. But it is received into evidence and will be reviewed by myself in determining a probable cause determination.
And I appreciate that, Judge. And just so we're clear, State's Exhibit 12.1 has been admitted.
It is received into evidence, yes.
And your intent is to review it in its entirety, but not here in the courtroom?
Yes.
Can I make one suggestion, Judge? Or maybe one request? I believe the most important part of the most helpful part of this video is the zooming in and the zooming out. And that is a portion that, if you want, we could isolate that and only play that portion of the video if you'd be willing to publish that portion of the video. And that's really the thrust.
He just
of
said
why
no.
We are trying to introduce that exhibit because
I see.
we believe that it's helpful to see it up close. And unfortunately, because of the way it's formatted and the way it's been recorded, there's no way any of us can zoom in and zoom out on this video to get a better look at what's going on. And that's the reason why we did what we did, but we had to memorialize it and save it, and then present it in that way rather than just present it in its raw form and then have the ability.
We had to
zoom in and
alter
out.
it just so you could see.
I understand why we're doing what we're doing.
So we want you to take a look at that
Ms.
instead.
Nestor,
That's what they're
to
saying.
the second request of not playing the whole video in its entirety, but simply the portion with the zooming in. How long is that, Mr. Sturgill?
I think it's a couple of minutes.
All right. Ms. Nestor?
We object to the prejudice of that, Your Honor, and ask the court to stand by your previous ruling on that.
All right. Thank you. I appreciate both parties. What I will do is review this video in court, and it will be displayed to the monitors at counsel table and to the court's monitor on any portion that you wish to play for me to look at, so all parties can see clearly that the court is reviewing it in court, but I do not find that it is necessary for its publication because this is the exact same video. I recognize it's zooming, but in balancing constitutional rights, there is nothing on this video from what's been represented that the public hasn't already seen. It's simply zooming in, and I don't find that that is necessary or and so in balancing the constitutional rights of all parties, I'll view it on the monitor. Council's free to view it with me as I'm looking at it, but it will not be broadcast in the courtroom or by the video camera.
I appreciate that, Judge. I respect that. I think there's a natural break where we can start. And what I'm going to ask is just we simply play the You will have this entire exhibit in evidence, though.
Thank you.
Is that right?
Yes, I will. All right, whenever you're ready. Counsel, as it relates to your monitors, just as a caution.
These guys are clowns,
you don't want
man.
it to be wished to be picked up, and I'm not saying it will. I know their camera operators being diligent in ensuring that complying by the rules.
They
but
have nothing,
in abundance of caution, this is just your moment
What's the conclusion?
to take care of your screens if you feel the need to do so.
There is no conclusion as of yet. He's going to, so Judge Graff is going to allow the evidence of the raw footage from the security cameras without it being zoomed in or altered in any way, right? Into evidence. He's going to take a look at it. So.
8.
Yes, Judge.
All right. Thank you. Having heard from both counsel, I'll go ahead and review it on my screens. It is not being displayed in the monitor in the courtroom. And you may present 12.1, the portion you wish for me to view.
Is this where he goes onto the roof? Is this?
And just for the benefit of the record, do you want to put on the record the timestamp
Yes, they are
of what
still
you're
on there,
playing, at what point you're starting and stopping? As we go, or when we finish is fine. I just want the record to be complete.
What is this video of? Is this the same footage that we saw,
Because
or
we've zoomed in, it's removed the timestamp on it. And
Well,
so-
you can just give me the
count
The
on the
count
video?
on the bottom. There's a timer at the bottom of the total length of the video, so that's fine. I'm just trying to create a record of what exactly I'm looking at.
shouldn't they already have this? You can, yeah, you can see right here. There's that walkway that leads to the building, right? Here, let me see if I can get. Yeah, we can.
Oh, I see. No, it's limitations of technology sometimes. Thank you for letting me know.
Limitation of technology. Right. Yeah. So this is what we're seeing here, I'm pretty sure. Camera is somewhere around
video is just
here.
before 6
Probably
minute
right
mark,
over here.
All right.
And it's looking this
For the record,
way,
it's
I
clear
think.
This is State's Exhibit 12.1.
Thank you.
Yeah, it's looking. It looks like it's looking this way.
I have it on my screen. It's so it looks like it's been paused at 6 minutes and 9 seconds.
Agent Hull, can you see it?
Yes.
Okay, well, let's just, I'm good with playing it. And we'll play it. Go ahead, Kimberly.
It's playing.
What is this supposed to? Why can we not see it, bro? Oh, nice. Nice. Well, congrats to Belgium. Nice. Oh, wow. 4-1? Wow. They blew them out of the water, bro. Damn, we should start picking better athletes. Yeah, yo, JD delay is crazy, man. Oh, dude, that's insane. Was seen laughing in court only feet away from Erica Kirk, who was... Oh my god, dude. Shut the fuck up, bro. You mean Erica Kirk? Crocodile Tears Erica? Are you talking... Crocodile Tears Erica Kirk? Is that who you're talking about? Yeah? Yeah, she's wiping her fucking tears with the thousands, hundreds of thousands of dollars that they made, I don't know, from the memorial in Arizona just a few days after Charlie died. Yeah, I always thought that was weird. And I don't I remember
Right, and
saying
it's been
something
paused, it
about it
looks like, at
too.
6 minutes
What,
and
like
23
right
seconds.
after it, like right after I saw it. It was really weird how they
Judge,
set up a
at
memorial,
8:23, we stopped the video.
fireworks
Oh,
everywhere and all
8:23,
kinds of shit,
That's the count on the video itself.
and was
Thank you.
selling merch there
All right.
the whole time.
Thank you, Mr. Sturgill.
That's weird, bro.
Agent Hull, you were able to watch that zoomed-in version, is that
Yes, sir.
right? Okay, and was there anything that stood out?
You know who was smirking though? Bagel. That's who it was. Bagley.
For me, on the zoomed version, it's apparent that Mr. Robinson, the individual jumping off the roof, is carrying an item.
Okay.
Oh,
And you
okay.
can see
So footage that
clear,
we've already seen.
The clothing that he's wearing. Strike that.
Mr. Sturgill, do you want to respond to the objection?
Judge, it is leading.
I'll go ahead and sustain the objection, and that you may move forward.
Is it easier to see? Strike that, Judge. I'll let the video speak for itself. Judge, I have nothing further with Agent Hull.
All right. Ms. Nestor,
Just one moment, Your Honor, if
Of
I may have
course.
the court's indulgence. Thank you. Do you want to take your...
and I was just going to suggest that. It seems like right now is a good time to take our morning break. It is 10:15. Let's come back at...
that's a good point.
Let's come back at 10:30, and we'll resume with cross-examination of Agent Hull. Court is now in recess.
All right. Okay. So I want to go ahead, silence that. Break time. All right. So what they were looking at was this footage here. This is the zoomed in footage, right? You see he's running, jumping off of the building, and then he lands. Here's where it gets weird, right? Is there a YouTube footage? All right. So this is the footage that they're talking about right here. Coming through here, right? I don't know if they're going to zoom in. They are going to zoom in. Okay. This makes no sense at all. That makes no sense. How does I mean, these guys are just looking like nothing happened, right? And there's nothing there, dude. There's nothing. I mean, look at the way the towel was just moving around, right? It doesn't even look like there's anything in the fucking towel. Supposedly, but look how much his legs are bending. There's no way. There's no way. It looks like he forgot the script, mid performance. How does no one see this, bro? How does no one see a guy literally jumping off of the roof in broad daylight like this? This doesn't make any sense at all. It makes no sense. None. All right, but this is what I wanted to show you guys. All right, take this over here. This is what I wanted to show you guys. All right, so there is a ballistics test that I've seen a number of people do. This guy's, well, I haven't seen this guy's test over it. Let's see. All right. So 30-06. Let's see what a 30-06 round does, which is what the mainstream narrative is, right? Which is what the mainstream narrative is. This is what they're saying.
Beef femur bones. So those are not easy to stop. I'm hoping this one will give us a slightly different result. And I'm going to aim towards the front left of our ballistic dummy neck, 45-degree angle, and we are shooting slightly downward as well. So I also have to hit.
So for those of you who don't know, ballistics very much, this is a ballistics gelatin dummy, and the gelatin is actually supposed to represent flesh, right? It does a pretty good job of that. You think he is innocent? He's connected some way, but I do believe that he's a patsy. 100% he's a patsy, right? And that's for all of the reasons I'm about to go through. I'm going to try and cram as much information as I can in these 15 minutes. So
the vertebrae, because that's allegedly what redirected this bullet.
I was going to say that bad. And this is also assuming that he was able to zero a rifle, right, with just putting a scope on.
Well, we definitely penetrated our water jugs, and I don't think this is going to help to stop the conspiracy theories. His head fell off.
That's what a 30-06 does. Let's watch that in slow motion. Oh, yeah. No. Nope. Yeah. That's what a 30-06 does. Okay. There's no way at all that a 30-06 was the round, all right, that lodged in his neck. No, there's no way. There's no way. All right, so let's go to...
For this round to have hit him where it hit him as an entrance wound.
All right, guys, so this is Valhalla VFT. So we'll probably be checking into their his channel here periodically throughout the day. But he's done his own analysis of it, such as I have. But and I'll get into my analysis of it here in just a few minutes. But the narrative, the official narrative, is that he was shot with 30-06 in his C2, right? Hit his C2, and then redirected because of the vertebrae and lodged in his C7 vertebrae. Well, given the trajectory of shooting from the low C center onto the quad there, this is the only trajectory that would make sense. However, that's not what we saw in the footage. He was hit right here. The wound was right here, right? So there's a big discrepancy. For him to have been hit in his C2, it would have had to blow right through his face, which is not what we saw. It's not at all what we saw, right? So there's just no possibility of him getting hit in the C2 unless it came from a different direction, which is what I talk about.
Everybody out there is
which is what I do talk about. So it looks like I'm going to have to pull that video up. So I want to go to my channel. So I'm gonna pull that up here. Give me just a second, guys. Let's see. I want to go to my history here. All right, here we go. Okay. Unless there was a different, and I do mean a different trajectory, right? Watch this.
Hey fam, welcome back. Hopefully you're doing good and having a good day. For now, this clip yesterday, and there are some things that are not lining up with what we saw live. It's dot, but pay attention for the next clip here. It's gone. Right. So what really got me questioning things was,
so that next frame, right? That very next frame, it is gone. Right? It's just gone. Right? That shows that there is a very fast velocity of some kind of object moving in a specific direction, right? And given how Charlie reacted whenever he got hit, would suggest that there was something that probably more than likely hit him from his back right side, right? That would explain how he was hit in his C2 and how it redirected because of the vertebra and lodged in his C7. However, we still have to explain the wound in his neck, right? We still have to explain that. So the only thing that I can think of that would explain the wound here are two things: a exploding mic, or perhaps maybe a 223 with a subsonic round, which means it's going to be flying a little bit slower because of the grain. Or a 22, right? A suppressed 22. Okay, those are the only things that I can think of that would ever really make any sense. But then, even then, with a 223, it would still if at the distance of up here, which is not so far away from him, that's definitely less than 100 meters. I would even say probably less than 50 meters. But that kind of impact would still carry a lot of damage, right? It would still do a lot of damage to the neck. So I would imagine that even if it was a 223, there would still be a lot of meat blown out. The only thing I can really think of is perhaps a 22, right? Or again, the exploding mic. So, but let's pay attention to this real quick.
Pay attention to this spot right here.
You guys happen to see that?
You see that? That right there. That, to me, looks very much like a suppressor. And what that
right? Yeah, so that that is an indication. This right here, this is an indication of some kind of flash, right? But not a traditional flash from an unsuppressed muzzle, but a flash from a suppressed barrel, right? So what does that mean? A a weapon that's being suppressed, right? A flash suppressant, which suppresses the fire that's coming out of the muzzle, but you still see the smoke, right? Which is an indication of what that is, right? So that would indicate that this could be the possible trajectory, because let's also remember that Bagel, he said that he found bullet casings, or he said he found yeah, casings, expended casings on other buildings. Okay, let's make a note of that, right? So why is he finding other casings elsewhere if there was only one shot that rang out, right? So that would suggest that there was something else going on, and there was all kinds of triangulation uh, that was done, and it's just it's absolutely crazy. But this is something that also came to my attention as well. Uh-oh, that's way zoomed in. There we go. All right, so the FBI had adopted the Flow 556K suppressor back in June of 2022, right? So the FBI being so hell bent on a specific narrative, right? That would suggest that there's a lot more to this. Okay, just off of that information. So there's no way that that it was a 30-06, based off of the trajectory, based off of the ballistics, based off of other video footage that we saw. Okay. Now let's see. There is also the exploding mic theory as well. Okay. Now, which would also explain the hole in his neck right here, right? So on the left is a picture of a mic that has exploded, and on the right is some fragmentation of what was found in one of the floorboards of the SUV that they put Charlie into. Right? So very, very, very similar. Which would also suggest that this was an exploded mic. Okay? So there's evidence for both, but what I really want to show you guys is this, which is way, way crazy. So it's come to my attention here very, very recently, within the past, day or so, that some of these images in the crowd, no less, but so some of these images, right? Some of these screenshots are literally from AI. It's literally done by AI, right? So you have that, and then you have literally people's faces blending into each other. You have distorted facial expressions, such as here, right? So what would that suggest? That would suggest that a lot of it, if not all of it, was all doctored up, right? And there's more and more footage to show the same thing. But one of the most obvious showings, or one of the most obvious evidence of AI in the assassination is when Charlie falls off of his chair, and then the chair is moved out of the way by one of the security members, but it clips through another object. It literally clips through another object, right? So I am under the impression that perhaps maybe the whole thing was faked, right? Also, given the fact that the security team hardly had any blood on their hands, given the amount of blood that came out of Charlie's neck, right? A lot of things are not adding up. They're not adding up at all. All right. So it just doesn't it doesn't make any sense. It doesn't make any sense at all. So we just looked at that. I want to see what.
Who is that?
I want to see what they are saying. So let's hop over to.
It's the guy in the picture doesn't even look like him. The one.
I don't think that's Tyler Robinson. Period.
Three
I don't
different
think he was at
outfits.
UVU at all.
I think, guys, if you actually look at the best pictures to put next to each other are the picture of Tyler at Dairy Queen next to the picture of the kid in the black as he's coming down the stairs.
Oh, the stairs, yeah.
Those are not they're just
not the same person.
Yeah, they're
Exactly.
literally
There's a lot of
not.
video of Tyler Robinson, so it's not difficult. And we have AI to be able to detect face, like facial recognition software. It's not even that
I honestly think it
difficult.
still looks more like Lance Twiggs than it does Tyler.
I
don't even
totally
think, I
agree.
think he's
I do
too.
too.
The guy coming through the
Lance,
parking garage
yes.
looks too skinny. Like if
And
Tyler's skinny,
I did a video where
So
there's actually.
for you guys who don't know who Lance is the furry gay lover, right, of Tyler. That's literally what they're going with, right? Apparently Tyler was gay, and Lance is supposedly his lover, right? Which I don't really believe that, but anyways, that's what the mainstream narrative is going with, right? So but Lance, here, let me see if I can pull up a image of Lance. So this is an image of Lance right there. All right. That's an image of Lance. And let's see. Here you can see that this looks a lot more like Lance than it does Tyler. Okay. So do I necessarily think that Tyler is innocent? Not necessarily, because he's a part of the operation, but I would absolutely say that he didn't kill Tyler, or he didn't kill Charlie.
Leave the SBI.
The State Bureau of Investigation?
Yes,
March of this year.
March of this year.
Yes.
So you were involved in this investigation from September to March, basically.
Yes.
And your new position at Post, what is your new position?
I'm an investigative sergeant.
So you investigate
Right.
potential wrongdoing of police officers?
Correct.
Okay. So when you were first brought into this case in September, is it my understanding from your testimony that you were not engaged in any way with this event prior to getting a call after the shooting? Is that correct?
Correct.
Does the SBI on occasion assist other agencies with preparing for big events like this or not? Is that not typically something you do?
Not something that I've ever been involved with, no.
Okay. And what time did you arrive on campus that day?
I believe it was shortly after 1:30.
So approximately an hour after Mr. Kirk had already been removed from the...
Approximately, yes.
Okay. And were you involved in in putting up any drones into the air? Were you part of that, or were you not
It's
involved in
not,
it?
no.
So how quickly after you arrived on scene did you become aware that you were actually going to be in charge of the scene?
I believe it was approximately an hour after, so what would have been approximately 2:30.
So for the first 2 hours, you were not in charge?
For the first 2 hours, I didn't arrive till 1:30, so no.
Okay. And once you came from on high that you were basically going to be in charge of the scene, what was your first priority? What were you focused on?
We were focused on, through our major crimes team and our lieutenant, putting together an investigative team and developing initial assignments and a plan as to what we were going to do moving forward.
And part of that is protecting any potential forensic evidence that may be found on the scene. That's clearly important, right?
Correct.
Preserving the scene, right?
Correct.
But it sounds like that's not really your area. That was more maybe Agent Falmina's area.
Agent Falmina was assigned to process and document the crime scenes. It was my understanding that the known scenes at that time, amid the chaos, had been contained and had been secured by the on-campus officers who were already on scene.
And what's your understanding of what the known scenes were? In other words, the area where there might potentially be evidence that you needed to process.
I know that the amphitheater area was cordoned off and managed as best it could with the number of people that were there. I was also made aware that there was a rooftop area that had been secured, and also an area off of the side of that building that had been secured by an officer.
And that building was the Losi building.
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th, yes.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
It was not. My recollection is that that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Okay, I thought you said it was an unfired bullet, and now you're saying it was a
That's correct.
cartridge?
When a weapon is cleared,
Uh-huh.
an officer would make his rifle ready, which would chamber around.
Oh, I got you.
And my understanding was that that's how that was accounted for.
So an officer claimed that bullet belonged to him or her?
No, bro.
That's my recollection, is that was how it was accounted for.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
I don't.
Was it a 30-06? Do you remember?
I don't.
Okay. Do you know where that bullet is now?
I don't.
Okay. So you had the amphitheater area that had to be preserved. And how far out
Clown,
did that
man.
stretch? The entire amphitheater, or just the area around the tent, or what?
It's really weird how a investigative officer doesn't really know a lot about this case.
When you arrived on the scene, were you aware that an individual had been taken into custody?
I had heard that, yes.
Did you ever have any interaction with that individual?
I did not.
And were you advised at any point that that person was no longer a person of interest?
Information was passed down that the individual was not considered to be a suspect in the shooting.
And when was that, time-wise?
I don't recall specifically, but I know I was on campus when I had heard.
So whoever arrested him as a potential suspect got that wrong. He wasn't the actual suspect, right?
Sorry, got what wrong?
That he was the shooter.
The person I believed to be the shooter was not the individual who was taken into custody, correct?
And then was there anybody else taken into custody as a person of interest?
There were several people who were detained for questioning and who were interviewed throughout the investigation.
And
Was that
none
the
of
three
those
separate
people were
times where Cash
ultimately-
Patel
they
was
were
like, "We
all
got him"?
ultimately cleared by you or somebody connected with you?
Correct.
And were there any other guns confiscated on the scene that day?
There were other firearms that were
Well, 2 or 3
located on the
times,
scene,
whatever.
yes.
How many guns were confiscated that day?
I don't know specifically confiscated, but I know that there was a firearm found in a backpack that was accounted for during the day.
What type of firearm was that?
It was a handgun.
Any other guns that were found on the scene?
Not that I recall.
Do you recall an individual named Noah Gonzalez being interviewed?
So you accounted for a firearm in someone's backpack, but somehow you can't account for a round that was found on another building that you just talked about?
I know that a trooper was interviewed having been on scene. I don't recall if it was Gonzalez. I don't recall the name, but I do know there was a trooper that was interviewed, yes.
Okay, and just a moment, Your Honor. And do you recall the trooper that was interviewed saying that there was actually a gun found in that holster?
I do not.
You do not?
No.
Okay. Can we pull up?
I wonder if it could have been a 9mm instead.
Exhibit hole 13 and just show it only to the witness for right now?
Could have been a 9mm. Maybe. But I'm leaning a little bit more towards 22-223 or a exploding mic. Those are the only things that make more sense. I mean, none of this makes any sense, but
Page 2 of that report. Do you recognize this report? Have you reviewed it as part of your investigation duties?
I do recognize the report now, yes.
Okay, and this is a report prepared by actually Mr. Davis, who's going to testify later in this matter. Is that right?
Correct.
Okay, and on page 2, this is the interview of Noah Gonzalez. Is that right?
That's what it stated on page 1, yes.
And he's an off-duty trooper who happened to be there that day?
Correct.
And do you see on the second paragraph, does that refresh your memory about whether Trooper Gonzalez believed there was a gun found in a holster in that area of the amphitheater?
Trooper Gonzalez included in his report that there was a gun, yes.
Okay. Thank you. Okay. When did you first personally go up to the roof of the Losi building? Do you remember the time of that?
I don't recall. I know it was dark when I went up to the roof, so it would have been later that evening.
So trooper carry
at
something
the time you went up there was already crime scene tape
that can
had
shoot
been
a 30-06
placed around it.
I do believe so. I do believe that some of the rifles that they carry are definitely could be maybe a 30-30, a 30-06 maybe, or maybe maybe an 8mm. I think that's probably going to do more with SWAT teams, but that's not like that's not an average like everyday carry. No, your everyday trooper or officer on patrol is going to carry a 9mm and a 223. Okay, which means AR style platform, which is something close to what the military uses, and a 9mm, which is the most common of handguns or most common caliber of handguns that's used when it comes to law enforcement.
September 14th, it says date created.
And that's the place where, if you could go to page 2, please.
So it could be a bullet that
Do you
was
see
cleared
down
from
at the
chamber.
bottom where you summarize Sergeant Bricker's report listing the timeline?
Well, here's the thing though. As a part of clearing your rifle, right, you have to account for that round, or else you get in a shit ton of trouble. Okay, you have to account for that. All right. Someone who's military law enforcement or who was military law enforcement, I know you have to account for every single round. Once a month, you have what's called blocking, and that's where you account for all of the rounds that you've been issued. Okay, because you get issued ammunition along with the rifles and or ammunition along with the weapons.
Is that right?
Yes, I believe he turned himself in on September 11th.
So prior to the time that Tyler Robinson turned himself in, had you all prepared a timeline?
A documented written timeline?
Yes.
Not to my knowledge. I don't know when Sergeant Bricker produced his specifically.
And isn't it fair to say that as of the moment that Tyler Robinson voluntarily surrendered to authorities in Washington County, as of that moment, you all did not know who the shooter was. Is that right?
Oh, and the camera.
We had identified a person of interest, but we did not specifically know who the shooter was at that time.
Okay.
And the camera footage of the department conveniently cuts out as
And you became
Tyler
aware that Mr. Robinson was
turns himself in.
voluntarily surrendering. How? How did you become aware of that?
That information came originally, I believe, from the Washington County Sheriff to the administration at the control center at the university on the evening of the investigation, or the second evening of the investigation.
All right, we're going to get back to that in a minute, but I just wanted to get the timeline down. All right, now I want to go back to the videos that we've seen and the question that I just asked before, which is it fair to say that nothing about the video of the individual on the roof revealed to you, you couldn't see facial features, you couldn't see what they were wearing, correct?
Of the individual on the roof?
Correct.
I know that there was a meeting to discuss perhaps a pattern on the front of the shirt that was observed when the individual was jumping off of the roof.
Okay, that's fair. But at that time, as of the 11th, before Mr. Robinson turned himself in, you all had not been able to determine that, is that right?
Excuse me. Determine who he was, or
No,
determine distinguishing features?
Determine distinguishing features of the video
Yeah.
of the person on the roof.
Yes, we had a person of interest, and those images were released to the press.
You're talking about the ones in the stairwell from the...
Correct.
From the parking garage.
Correct.
Right.
But the video on the roof was not distinguishable, fair?
That video as a standalone?
Yes.
Was not, no.
Okay. And in fact, the video on the roof, well, strike that. Is it true that you had some spectators that you interviewed that had gotten a photograph a few seconds before the shooting of someone on the roof?
Sorry, I'm not sure I understand the question.
Did you, at
It's
some
pretty
point
clear
in your
question, bro.
investigation, collect from two young men who were present at the event a video that they had taken of someone on the roof about 10 seconds before the shooting?
Yes, a video, yes, not photographs. A video was collected from an individual who had a video.
And ultimately, some screenshots were taken out of that video, is that right?
By,
By you?
not by me, no.
Okay. That's fine. It could have been someone else.
Okay.
But did you see the video that those young men took?
If you're referring to the video that is looking north and shows an individual dressed in dark clothing on the corner of the roof,
Yes.
if that is the video, I have seen that video, yes.
Did you review the interview of those young men?
I did not.
Do you know how they described the person on the roof?
I don't know if I read it or if I heard it, but my understanding was they believed it was Overwatch or some kind of a police Overwatch for the event,
Okay.
if that's my recollection.
And do you remember anything
How do you know that if you
specific
didn't
about
interview
the
them?
person's build that they discussed when they described the person on the roof?
I do not know.
Okay. There is a portion of the video after the individual jumped off the roof, which we all saw here, where the individual crosses, I believe it's Campus Drive. Is that right?
Correct?
And there's a moment where the individual waits and there's two cars that pass in front of him, right in front of him.
Correct?
And is this the moment where you are submitting that he was holding a gun in his hand?
As he crossed the road?
Yes.
From my observations, would show that he's carrying an object in his hand that's concealed or in a bag, and it is long and has the appearance, based on my training and experience, it could be a firearm.
But do you see a gun anywhere? The actual gun?
In the video?
Yeah,
No.
all right. And did anybody that was driving by on Campus Drive that day report to you or any other investigative entity, hey, we just drove by a guy with a gun who was leaving campus and he was standing right by my car?
We did not receive any reports to that effect, no.
Okay. Also, when you were revealing the timeline,
Case closed.
exactly how long was there between when the person was prone on the roof and when the shot was taken? Do you recall?
If you would like to replay the video, I can time it for you, but I don't recall. It was my guess, I would estimate between 15 and 30 seconds.
So between 15 and 30 seconds to lay flat, take a shot, and get up and
correct
run off,
himself.
right?
I think you asked how long he was prone. I
Right.
think it took longer for him to crawl into position
Okay,
and then establish a position
Oh.
and then take the shot. He appeared to be in prone for approximately 15 to 30 seconds, but the video would verify that.
okay, thank you.
So how did he reassemble a rifle in 15 seconds?
All right. I want to talk to you for just a minute about the video that was taken. And I'm not going to get into I'm not going to show it, just so that in case anybody's concerned about leaving the courtroom, I'm not going to show it. But there was a video that was taken by Mr. Ty Phillips from behind the individual that was speaking to Mr. Kirk.
Correct?
And it showed like a dead-on view of Mr. Kirk and his parts of his security team. Is that right? And then you also have video that you described that shows the back of the tent at the moment the shot happened. Is that right? Behind Mr. Kirk.
You're referring to the UVU video in the breezeway?
Yes.
We have that video, yes.
Okay. And can we pull up the last video, the last clip, 49? I want to show you, just you, this clip. That is a little clip from that video under the breezeway that's behind the tent, right?
Correct.
And just to be clear, this area behind the tent would not have been visible to anybody that was on the Losi building. Is that fair?
I can't answer that question.
Why?
Yeah, sure.
So it was a car 98.
And Ms. Nestor, as you're playing this, are you just being cognizant
Looking
if
at the rifle,
sound
guys.
is on or not?
I don't want the sound. Please.
Okay, I just wanted
not-
to
Thank you for bringing
clarify.
that. Thank you.
All right.
No sound. I just want only the witness to look at it. So can you just watch this clip for just a minute? This one little clip of behind the breezeway at the time of the shot.
So
That's fine. And
the
so just
the
as a reminder
narrative
to all
is
the parties, if it's on your monitor, please be cautious.
so the narrative is that Tyler, within 15 seconds, right, assembled the rifle that was used to shoot Charlie, right? However, if you guys know guns at all, it takes longer than 15 seconds to reassemble anything, right? Even tier 1 operators have a difficult
There
time
was no
doing
one standing directly behind the tent. Is that
that.
correct?
So
You'd have to show me it again. I wasn't specifically looking for that.
Okay.
But I can answer that question if I can view the video again.
Okay.
all right, we might have a few seconds here. Okay, so it was a car 98. Crazy that it was a car 98, but this is the rifle that was used, right? Model 98, supposedly, right? Allegedly. However, when it comes to disassembling the car 98, it is a part of the process that you remove the bolt. Okay, I've had Mausers. I know how they operate. All right, to disassemble them, you have to take out the bolt. Okay. So for him to have disassembled the rifle, because this is supposedly the rifle that he used, right, you would have to remove the bolt. Don't know why you would want to do that, but okay, whatever, right? And the fact that there's no way that this could have fit in someone's jeans. There's no way. There's no way. So really weird.
Get down off of the screen, thank you. I want to talk now about the TPUSA video that you got. That was the angle that was taken from behind Mr. Kirk while he was talking, looking out at the audience when the shot was fired. Do you remember that video?
The visual impulse videos?
Yes.
Yes.
All right. Is it true that Visual Impulse provided 4 videos?
Yeah, I believe there were 4 total videos that encompassed everything that they provided to us, yes.
But the one that you showed, that's only one of the 4 that they provided to you?
That one that was shown had a Bates number. It was an item that was provided by Utah County Attorney's Office.
Okay, but were there more that you haven't seen in this courtroom, in this prelim, that you got from?
There's the original footage.
Nothing about this really makes any sense, man.
Were there other angles that are not shown here in this prelim?
Yes.
Okay, that's what I was trying to get to. Thank you.
And this doesn't even look like a Mauser. It doesn't even look like a Mauser. Well, the bolt does. I recognize the bolt.
Were you involved
But this-
when the
this
gun
looks
was
more like a
located
Remington.
in the forest area?
I was not involved in the search for the gun, no.
Did you get notice when it was located?
Hey, bro.
From the footage that we
Move,
reviewed,
Baldy.
we identified an area that we believed could be potentially of evidentiary value, and then it was secured, and then I was notified that as a result of that search, a gun had been located, yes.
Were you involved in the processing of that gun? In other words,
I was not.
boxing it, shipping it, sending it wherever it was going to go to be
I
analyzed?
was not, no.
Okay, thank you.
You're an investigative officer. Why were you
All right,
not?
now I want to shift to the autopsy for just a moment. You were not present at the autopsy, is that right?
I was not.
Okay. So anything you know about the autopsy was not from personal observation?
No, other than from my meeting with the medical examiner and his report, no, I was not present.
Did you meet with the medical examiner after he had conducted the autopsy?
I did, yes.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have any reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you, or did he learn it from someone else?
It would be my recollection that he did not learn that from us, but I couldn't speak to how he did learn about it.
So you didn't share with him your conclusions about what happened or how Mr. Kirk was injured or anything like that?
That's my recollection.
Okay, thank you. And isn't it also true that fingerprints that were taken from Mr. Kirk
Listen up.
and autopsy photos were provided to you on a CD?
Yes.
Was there anything else provided to you from the autopsy other than that?
Other than the CD and the report?
Yes.
Not to me, no.
And they found
You did
found
mention
more
not
than
to
Tyler
you. Were
Robinson's
you aware of
DNA on the
anything else
rifle
from
too.
the autopsy going to anyone else?
I believe standard
Like
practice
4
is
different
anything
people, I
of
think.
evidentiary value that the medical examiner collects is
Or four,
transferred
four,
to a chain of
four
custody.
different sets of
And
DNA.
Are you aware of anything that was transferred after Mr. Kirk's autopsy?
I'm aware that there were items transferred for evidence, yes.
What items?
I believe some fragments of a bullet casing. I know Mr. Kirk's personal items to be returned to the family. That's all I can recall off the top of my
Do
head.
you know how many fragments from the bullets?
I don't.
Now, I'd like to talk a little bit about the Ring camera that you obtained, and you interviewed a woman named Ms. Noble, is that right? To get that Ring camera that we watched with the car on the outside?
We interviewed her to verify the authenticity of the video, yes.
And were you involved in that interview?
With Miss Noble?
His
Yes.
boyfriend.
And do you recall what they told you
Perhaps.
about what they remember seeing in and around that car that night?
I don't recall. I just know we were there to verify the video. I didn't conduct an
But
interview
we
with
don't
Miss
know.
Noble at that time.
We don't know whose DNA that belongs to because they never said anything about it. Yes, supposedly he had a boyfriend that was a furry, right? which is what I showed you earlier with Lance. Let me see if I can bring it back up again. Here, I want to play the audio here while I'm looking.
All right, do you remember that, looking at that interview? Does that refresh your recollection?
I remember reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that Ring camera, did you?
I did not.
And did they also tell you there were three other people
This is
in the
Lance
car?
Twiggs. This is supposedly his lover
Yes,
here.
I believe they thought that was the case.
So, but he plays a part in all of this because Lance looks a lot like this guy. Lance looks a lot like this guy. I mean, let's do a side by side real quick. Lance looks a lot like this guy here. Right? So, you know?
Understanding was that it may have been used in an effort to track an individual that had jumped off the roof, but I don't know for certain.
And obviously that didn't produce any results, or we would have heard about that, right?
Yeah, not that I was made aware of.
Yo, bro, I'm gonna go watch Argentina's match. Okay, that sounds awesome, bro. You have an awesome day. Make sure you guys are saying goodbye to Penny, KSI. Wish him a lovely day. See you later, bro. Appreciate you popping in. Make sure you leave a like
I would imagine
before you leave,
it'd been
okay?
at least a couple of days, if not longer.
Greatly
than
appreciate that.
Before anything was removed from the scene.
Oh, make sure if you guys are appreciating the work that we're doing here today, that you are
personally?
leaving a like,
So you're not sure when it was removed?
subscribing, following.
And were you involved in the
It helps the channel,
decision
helps
to pave
my
over
socials,
the
helps
dirt
the
that was
algorithm.
under the tent?
Greatly appreciate that, guys.
At UVU?
Uh-huh.
No,
Did you know that happened?
only because it was in the news.
All right. But you don't know when or who ordered that?
Nope.
And it's true that during the time before Mr. Robinson turned himself in, you all received lots and lots of tips from the public. Is that fair?
Correct?
You received tips of death threats that Mr. Kirk had received before, the day before the shooting? Is that right?
I'm sorry, did we receive threats that Mr. Kirk had received before the event, or?
Let me clarify. That
Thank
was a
you.
confusing question. As you were going through tips that the public was giving you, did you receive tips about online death threats that had been made against Mr. Kirk prior to his death?
There was a huge variety of tips and information and suggestions that were being provided by the public.
Okay, and a lot of those, some of those filtered through you, right?
Some of them filtered their way down to us, but predominantly that was being handled by our State Information and Analysis Center that had been set up.
Right.
And you also got multiple tips about potential suspects, people who thought they recognized people in the picture, right?
Yes, there were different calls and information provided by the public.
And you had quite a few of those.
Correct.
And then Mr. Robinson turned himself in, right?
Yes.
And is it your understanding that the individual they used to facilitate Mr. Robinson turning himself in was someone known to Mr. Robinson personally that had been connected to law enforcement?
I know he was known to the family. I don't know his connection specifically with Mr. Robinson, but I am aware that someone was used to facilitate Mr. Robinson turning himself in.
And were you aware that he was one of his Boy Scout leaders? Did you know that?
I think I had heard that at some point. There was a connection. I don't recall specifically what it was.
And Mr. Robinson, in fact, no police went to go arrest him. He drove himself, or he was driven with his parents to the Washington County Sheriff's Department, correct?
That's my understanding, yes.
And he voluntarily
That the camera
walked
footage
in.
cut out of.
That's also my understanding, yes.
That's
And
something
that
to
was
note.
the first moment you ever knew his name connected
Going
with
now.
this case.
Okay, that sounds awesome.
yeah, aside
Yo,
from the image that
appreciate
we
you,
had.
Neo. I know this isn't your content, but I really appreciate you, dude. Thank you so much. You have an awesome day. Everyone wish Neo a lovely day, guys.
And did you personally ever meet with Mr. Robinson?
I did not.
So he never
And
met
as far as you know, Mr. Robinson did what he said he was going to do. He told the police he was coming peacefully, he was coming with his parents, and that's exactly what happened.
I don't know any of the specifics of how he was arranged to turn himself in terms of what you've described. I just know that it was being facilitated with the sheriff's office.
Okay. Court's indulgence for just a moment, Your Honor.
Yes.
Yo, thanks, Neo. I appreciate you, brother. I really do appreciate you, man.
Thank you, Agent Hall. I tender the witness, Your Honor.
Thank you. Redirect by the state.
Appreciate you, bro.
Just going to go back to a few things that Ms. Nestor asked you about. First of all, the unfired bullet that you referred to. It's your understanding that that bullet was accounted for?
That's my recollection, yes.
Okay, and it possibly belonged to an officer that could have maybe been clearing his weapon.
Yes, that's what I
That's
recall being told
news
about
to
that
us.
particular item, yes.
That's new to us.
Are you aware of if on the 10th there were police officers present that were actually securing buildings and securing rooms there at UVU?
I know prior to my arrival, it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus. So there was a large, rapid response of law enforcement who were actively trying to clear, secure, and ensure that the campus was safe, if that answers the question.
The entire campus?
Yes, correct.
Okay. And what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded, but subsequently specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how were they equipped? Like
There's
what
two-
type of equipment were they?
I
There's
believe
two channels?
Most officers carry a sidearm, a handgun.
Hang on.
And most officers in this day and age are
Hang
equipped
on.
with a rifle.
We
platform as well.
gotta find this out.
When
But
you
yes,
said that,
to answer your
it was
question,
possible
yes,
that round,
that is
was
me.
from an
Yes,
officer clearing his weapon.
that is me with
What
shades
exactly
on.
do you mean
Yeah.
by that?
Our standard practice in our department is to carry a rifle cruiser ready, which
I'm
is
sorry?
we carry our rifles in a
Yeah.
situation which is called cruiser
Yeah,
ready.
that's definitely not me, bro. That look, I look. Hey, look, I look a lot prettier than that with makeup on. Okay, I look a lot prettier than that. So, you know, so select the right one. Select the right one there.
and eject the round. Sometimes in doing so, rounds are dropped or not accounted for.
Have you personally done that yourself?
We do that at training, and I've done that in the field as well, yes.
Okay. And you're aware of, is that something that's common among police officers in this situation?
I believe for most agencies, that's how they carry their weapons, but I can't speak specifically to agencies outside my own.
Do you have any idea how many officers were dedicated or sent out to clear the campus?
Oh, are you talking about the chick?
I can tell you I had to park on University Avenue and walk all the way
Yeah,
onto
that
campus.
that chick
between
kind of
hundreds
does look
police
AI,
cars,
doesn't
so
it?
I would say hundreds, if not 1,000 officers, high hundreds would have responded to the campus that day.
Now I'm going to ask you about, Ms. Nestor asked you about your observation of seeing Mr. Robinson with something in his hand. And I think she was asking you about Mr. Robinson just prior to crossing Campus Drive, following the shooting. Do you
Yeah, there's a
remember that
lot of
portion?
channels out there that's going to start
Yes, I
mimicking me
think I
here
was
very
asked whether
soon,
he had a
guys.
gun or I had seen a gun in his hand in the video.
And you said that you did see something in his hand?
Correct.
Okay, I want you to go back as far as you can remember. At what point?
I thought I was
after
unique
Mr.
enough. It
Robinson
seems like
stood up on top
it
of the
seems
OC
like I'm a
building
lot
and
more
ran across,
unoriginal than I
believe
thought.
to the northeast corner. When did
Damn.
you first notice in that video something in his hand?
The first time you can clearly notice he has something in his hand, without a doubt, is when he's on the white triangular portion on the northeast corner of the Losi building preparing to jump. It is very apparent he has an item in his hand.
Okay, and that's based on your observation of the videos?
Correct.
Okay. And is it easier to see in that enhanced video?
The zoomed version of the video makes it a lot clearer to see, yes.
Okay. And then after he drops down off of the roof of the Losi building, is there any time between that point in time and making his way to Campus Drive that you believe you see, again, something in his hand?
As Mr. Robinson lands on the grass, it's almost like he either drops it or goes into a crouched position, and then when he returns up from that, it is again clear that there is some kind of an item in his hand, yes.
Can you be more
Yeah, it's called a towel.
specific or describe in
That's
more
it.
detail?
It
what that
appears,
item might
it
be?
appears to be black, and it appears to be longer.
Okay, anything else about that item?
No.
And how does, chat, how does a towel
I believe it was
completely
Exhibit 9,
wrap an
State's
entire
Exhibit 9
rifle?
that Ms. Nestor pulled up on the screen.
Okay, here,
And
hang on.
She had you look
Hang
at
on,
that.
hang on.
And I believe what you looked at was beginning a still image, but then a few moments or a few seconds of that video. And that's the UVU tunnel video, is that right?
The breezeway underneath the Hall of Flags, yes.
And the view is from behind, where I believe you testified that Mr. Kirk was on the other side of what appears to be a banner.
Sure.
In that tunnel view.
Yes.
And on the other side of that banner is the tent and then the rest of the courtyard. Is that fair to
Correct.
say? Do you remember seeing the banner
Yes.
in the video? Okay, and
You're referring to the back of the pop-up tent?
correct, yes.
Okay, yes.
Okay. And do you remember, what do you remember about that banner?
It has some kind of an emblem on it, and it forms the back portion of the pop-up tent.
Is it opaque? Is it transparent? How would
No, you
describe
can't see through it. It's white,
Right.
and you cannot see through it, no.
And how much of the tunnel does that banner, I guess if it's opaque, obstruct?
I couldn't say. I'm assuming it's a 20 by 20 gazebo, so it would block out the area of the back of the tent that you can see. You would not be able to see through it. You would not be able to see through it from the audience side of the amphitheater.
And what about the tunnel side of that banner? Can you see through the tunnel side in the opposite direction?
You cannot, no.
Can you see Mr. Kirk on the other side of that banner?
You can't, no.
Okay. Well, we exhibited, or Ms. Nestor had you watch just, I believe, just a brief few seconds of that video. That exhibit is actually much longer than what we just looked at, or what Ms. Nestor had you look at, is that right?
Correct.
All right.
And leading up, and again, I'm referring.
So the average length of a Car 98, Mauser Model 98, is what we're looking at, because that's supposedly the rifle that was used. Is 43.7 inches, whereas a bath towel, right, standard bath towel, is 52 to 58 inches. Okay, so it could be doable, right? But not having anything to keep it wrapped would be pretty hard to do that.
Mr. Robinson entered.
Yo.
Well,
Yo.
Ms. Nestor brought that up, and I believe
Donna,
your testimony has been.
welcome in. How you
today and
doing?
Yesterday, that you witnessed Mr. Robinson enter a wooded area on at least 2 occasions. Is that fair to say?
Yes, on his
I've
second
watched
visit
EV.
to the
What's
campus,
that?
and on the visit where the incident took place.
At least on those 2 occasions, did the wooded area that he entered, were they different parts of the wooded area, or was it the same parts of the?
They appeared to be the same.
You're aware that a rifle was eventually discovered?
Yes.
And was it your understanding that that rifle was discovered in a wooded area?
It was in the wooded area where we believe Mr. Robinson entered the wooded area, yes.
And that rifle was discovered on the 10th.
Yes.
Ms. Nestor asked you about a variety of tips including threats to Mr. Kirk, I think before the event.
Yes.
And did you follow up on those tips?
After tips have been put through a process and been analyzed and screened, anything that appeared to have relevance to either the investigation or a credible threat was managed by the various entities involved, yes.
Okay. So managed by law enforcement, so.
Correct.
Did you personally follow up on any of the tips?
I don't think I personally did, but I worked closely with people who did.
I watched a few
The point
videos
is, I
about
guess, is that
shooting
those tips
and
were followed up on. Is that fair to say?
To the
other
best of
news
our
about
ability,
it
yes.
makes sense to
Okay.
those
And then Ms. Nestor also
who know anything
asked you
about
about
guns or
tips,
social
I
media.
believe,
Yeah.
Of people reporting to police that they felt like
Yeah,
they knew
exactly.
who the shooter was.
Yes.
Okay, so
Just
identities
as
of
I have
possible
talked
shooters.
about,
Correct.
Did law
you know,
enforcement follow up on those tips
none
as
of
well?
it makes sense.
They did.
None of it. So, welcome on in. Thanks for popping in here. I
Ms.
appreciate
Nestor,
you.
Finally, Ms. Nestor asked you.
Make sure you guys are saying hello
well,
to Donna. I don't know if you're popping in here from Kick
She
or
asked
not.
you whether.
But if you're new, I appreciate you.
Mr. Robinson voluntarily went to the sheriff's office down in southern Utah. Is that right?
Yes.
Okay. And that was a Washington County Sheriff's Office.
Yes.
Okay. You understood that he turned him. Well, he showed up there voluntarily. Is that right?
Correct.
What was your understanding as to why he was showing up there voluntarily?
He had informed, I believe, his immediate family that he had been involved in the shooting.
Right.
And that he wanted
Yeah.
to turn himself in.
Okay. Nothing further.
Well, given yesterday's video going over some specific Google trend searches or some specific Google search trends from a specific country, right, of the specific location of the drop off of a specific rifle, you know, and that's not it. But we will get into that here in the next break or so. Well, it's probably going to be lunch the next break, so we'll do that then.
After he stood up until you see him last, at least in that part of the video, do you notice whether he's walking or running with a limp?
He is not. From the time he left after going over the railing, when we see him,
correct,
and then leave the position, there is no longer a visible limp or gait.
Thank you.
Ms. Nestor.
Isn't it interesting how we see what the rifle he used was, but not the towel to wrap it? And how the only pictures we have are of the rifle in a box.
Allowing parties to
Isn't that
closing the
interesting?
brief recess.
Yeah, so isn't that interesting, guys? I'm trying to find out the specific towel that was used to wrap the rifle. And I'm not finding anything on it at all. I'm not finding anything on it at all. The only thing we're finding is the rifle, but it's in a box. There's no towel. Right? So, definitely some things to note. The defendant's lawyer, Nestor, was asking some pretty good questions. Okay, well, you said that there were other casings that you found. Tell us a little bit more about that. How does that make any sense, right? And it's just he couldn't. Okay, so every single time you arm up, right, when it comes to law enforcement, you are responsible for that equipment, that ammunition, the weapons that you are using. And if there's any, I do mean anything, if there's anything unaccounted for, you get into some serious trouble, right? You get into some serious shit. So you have to account for all of that. I find it interesting how there was no mention at all of a few extra casings or even just one extra casing being found. I don't remember that at all until literally today, right? Let's take a look at the Mauser here, okay? Car 98. This is what was used. Oh, well, not that. That's I believe the marksman version. So, but yeah, so it's going to take a lot longer than 15 seconds to reassemble, especially if there's no scope, right? Which you wouldn't even really need a scope at at less than 100 meters. You're really not even going to need it. You could just use the iron sights. But anyways, put the scope on there without it being zero, took a shot, hit him in the neck within 15 seconds, which doesn't make any sense at all. There's no possibility of that happening. 2 men took video footage of him up on the roof before the shot was taken. And neither of them were interviewed. As far as I understand it, right? Am I remembering wrong? I don't think I'm remembering wrong. But to disassemble the Mauser, right, you would have to remove the bolt, which means there would have to be a spent casing somewhere, because as soon as Tyler takes the shot, right, allegedly, as soon as he takes the shot, he books it out of there, right? So that's where the video footage starts of him running off of the building, right? That makes no sense at all if we take into the fact that the Mauser must be disassembled. He changed clothes, assembled the rifle, took shot, disassembled the rifle, and ran. Yes. Yeah. Exactly. None of it makes any sense. None of it. Unless there's no way, bro. There's absolutely no. Again, tier 1 operators can't even do that in less than a minute. There's no way. So imagine some kid who hardly has any experience in shooting at all. But then again, does he really have hardly any experience in shooting? Because I don't know. He's supposedly seen with a lot of different, well, a few different weapon systems. Is that an M2? It looks like an M2, like a smaller version of an M2. So yeah, this absolutely makes no sense. None at all. Oh, okay. I thought we were hearing something. Yeah, that just it really doesn't make any sense to me. I want to see what Valhalla and all those guys are saying. So let's hop over to these guys.
He can't.
Anybody can be up there.
Yeah.
Dr. Tetanus, thanks for your previous super chat. I couldn't read it. I don't know what it was, some kind of chant or something. But thanks for this one as well. Dude's using his best ASMR voice for the judge, not witness.
Yeah.
Let's see. Friends with Matt.
Trigger Smart.
Thank you, Trigger Smart, for the live stream. I'm so excited to see everyone tuning in today and all my favorite YouTubers all in one place. Subscribe. And make sure you guys check out Friends with Matt. He has some pretty funny skits and stuff that he does. He has a lot of high energy and stuff. I like some of his stuff.
Make sure you guys are also checking out their channels as well. They follow a lot of political stuff a lot closer than what I do. I do all kinds of different content. I'm sure if you guys have checked out my channel, you see all the kinds of different content that I do. So I can't dedicate the majority of my time specifically to politics. But if that's something that interests you, go ahead, guys. Go subscribe to them. Go follow them. There's some pretty sharp cookies, man.
Homies, I can promise you all that. That him even taking a shot that level of shot under that much stress and duress in 15 seconds after hitting the prone.
Absolutely, there's no
It's
way.
doable, but that most
It's
likely
hard.
you got somebody pretty well trained to be able to pull that off.
Yeah, exactly. You would absolutely have to be very, I'm talking like tier 1 operator, ready. So dub Neo, absolutely dub Neo. Welcome in, Guarded. How you doing, bro? I'm glad you popped in here. Thanks so much for popping in. Everyone, welcome in, Guarded.
Broad going down your pants. So
The only playing devil's advocate, the only other side of that is he was definitely walking slower and more methodical. So that's something to watch too.
Yep.
Zach Costello's show. Make sure you guys go check out Zach. I know a lot of you already have. And also I have an interview coming out with him. It'll be a little bit later this week on Off Script on my other channel.
You didn't get notified?
He says, ha 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 ha.
For real?
Ha. So this is the footage.
Well, like I always say, guys, make sure you hit that bell. Okay, hit that bell, hit that notification button, and what I will say, okay, what is it, 11 a.m. Eastern Standard Time is when I will be streaming until this is done. Okay, I'll go ahead and give you guys the time. 11 a.m. Eastern Standard Time is when I will be going. Well, probably a little bit before then, because I would like to do recaps of the previous day. But make sure you guys are checking that. Make sure you guys are also checking to see if you are unsubscribed from the channel as well, because YouTube is doing that, and YouTube is also hitting channels such as mine, such as Trigger Smart, Valhalla, and Jesse on Fire, all these other guys. I'm not sure who these guys are. It's first time I'm really seeing them, but or too much of them anyways. So make sure you guys are checking, because it's YouTube is playing some games right now, man, and they're really suppressing a lot of channels and a lot of this information covering this topic. All right, well, many, but this is one of them. So first thing I did was check sub, and still subbed. Cool, awesome, and notify on. Oh, weird. Yeah, man. Really got to be careful with YouTube. YouTube is playing some games right now, bro.
Yeah, that's. Yeah, I'm sure they'll come up
Where
later.
did that come from?
Well, we'll probably find out. They wouldn't have brought it up if it wasn't going to be.
Did they have a separate booth or something?
They have people over campus handing out flyers.
Oh, so they spoke with someone
Jay Jennifer, thanks for the
from
super chat.
TPUSA?
Please allow this in evidence. Any lawyer would have a field day with this footage or lack thereof, it being Tyler.
Yep.
Yeah, I mean, you have to prove it's him. Whoever this person is looking down in a way. They have sunglasses on and the hat pulled down. Clearly, they're avoiding the cameras. That makes it a lot more difficult to prove it's him.
Yeah, it does.
Yep.
It does.
In the video of Tyler, not Robinson, that's fake ass limp. He covers his face sometime before this. Someone made the exact route and pointed out the cameras, same at the parking lot to be seen. It's very, like Matt just said, very clear that he was whoever that is, purposely did not want to be recognizable.
It's really weird how they potentially knew where these cameras were. Right? It's as if they knew where these cameras were going to be, and they knew that, right? They knew to hide their face. Isn't that weird?
Weren't more shots coming. Not all of them. They just kind of like ran off. So we know Hunter was there. He hung around. He was walking around afterwards.
So
Mikey McCoy bailed very calmly.
Yeah.
Oh yeah, Mikey McCoy, he bailed super quick. We talked about him yesterday. How like within a second, as if he was already on the phone with someone, within a second, picked up his phone and made a call, and his dad answered within a second of Charlie being shot. And then as they're stuffing Charlie into the SUV, he's then booking it down the street, right? So Very, very, very telling, I would say. Absolutely telling. But that's what really stands out to me, bro. That's what really stands out to me. Oh. I thought we were okay. Maybe not.
Here's the same way, and 20 of those 6-foot-tall white kids would look exactly like that. Exactly like that. And a black hat pulled down with sunglasses and all black.
Yeah.
Fun fact, this is the reason why not the reason why, but I was told at a young age, don't get tattoos, because if you ever did something, you'll easily be able to get identified by your tattoos. So if you don't have tattoos, you can get away with doing certain things at a young age.
Well, I guess I'm fucked because I've got tattoos. But I'm not gonna have to worry about that because I don't commit any crime. So you know,
you're not wrong. Now that we're looking at it,
yeah.
Only crime I'm guilty of is having a phenomenal beard.
It's more like one of the TPUSA guys. Sorry, I didn't know their names. I think it looks more like Lance Twiggs than it does Tyler, to be honest. Always have.
Moon Goddess, thanks for the super chat and for being a member. Only thing this proves is Utah is full of idiots.
Yeah.
Shots fired. Milhog says,
damn, hey, yo, Utah.
The past
What's going on,
movies, man? But they don't think it could be real life. Well, here's your proof. Well, they believe it in every other case. They believe it in the JFK case. They believe it in the MLK case. They believe it in September, the day. But when it comes to this one, for some reason, everybody believes the government all of a sudden. It's pretty wild.
Yeah, pretty much.
Linda LaBelle says, so he jumps off the roof with a rifle and not one passing car sees this or reports it.
Yeah. I said this every time I've looked at the footage, Linda. I've said he walks right by. He walks right by people in the street. Yep. And nobody is concerned. Keep in mind.
See, I just said that earlier. And every single time I see the same thing, I'm like, how the fuck did no one see or how did no one see this guy jumping off of the roof, walking with a towel or something, walking with some really suspicious shit in his hand, right? And no one stops him. No one reports him. Nothing. Only crimes I'm guilty of was being homeless. What? No. Well, that sucks, man. I hate that for you. If you need help, let me know, dude.
Fuck is this?
Yeah,
you know what I mean?
Yeah. Friends with Matt, thanks for the super chat. I think he got this wrong, but he says Zach Costello's the most handsome YouTuber in the game right now. Howler's probably second.
Thank you.
Jesse definitely fifth. Trigger third, and Mr. Let Go fourth. Baze didn't make the list, but I think we have a couple of those switched around. But yeah, we all agree Zach is definitely the most handsome.
Damn, Baze, you didn't make the list.
Let's see. Robin Habitzel. Taking stairs one step at a time is typically due to healing, surgery, injury. No way is it the same person that runs across the building and jumps off. Interesting point of view.
Aaron, I think he's yours typically.
Is the media lawyer sitting with what? Is the media lawyer guy sitting
that
with
guy,
prosecution?
Yeah. That was weird. Why is the media guy coming up there and arguing about the way evidence should be displayed?
Yeah, that's also.
It sounds like he is an attorney, though. So maybe that's what he's there for, is to be a, advisor on the media.
I did think that was weird myself.
Basic Niche just had a comment over here. He said, obviously, Matt doesn't like dark meat. I love dark meat. If you know what I mean. Let's see. Inspector Bubbles, this is not me.
There are currently 10 to 18 gray Dodge Challengers registered on the road in Orem, Utah. Oh my God. If that's true, that's crazy. That muddies their assumption that Challengers always TRs. Yeah, and again, that's not a rare car on a college campus, especially you keep out all the kids whose rich mommies and daddies like to buy them the fancy cars. There's a ton of these on U of O campus too.
Bro, where's my Dodge Charger, bro? Where's my Dodge Charger, man? I want one.
Crown Affair. Thanks, Matt.
The
Watching
fuck?
from UK.
Great point.
Super.
Great point. Thomas Crown Affair. That's a great point.
John Daly says, why is the hearing in front of a magistrate instead of a normal judge, given the importance of this case? Is it more of a Utah fudgery? Also, where's the body cam from the Spanish Fork officer who stopped TR on 911?
Yep.
I think it's because it's a pre-hearing, right? It's not an actual jury trial yet. And so the judge is basically there as an arbiter of deciding whether or not this goes forward. As
Yeah,
a
this
trial.
is just a
Correct me if I'm wrong,
preliminary.
Matt,
This
but
is a case to decide if there's enough probable cause to go to trial.
To be a part of this case, right? Because
I believe so.
Okay.
I thought that's what they said, Aaron, but maybe not.
Yeah, and I know defense has 7 expert witnesses that are forensics and some other stuff as well.
Really?
Yep.
Okay.
6 or 7. I don't remember which number it was. Tiny Dancer Mama. The defense needs to have a lineup of 5 TR lookalikes and have the jury pick out which one they think is TR. Case closed.
Yeah.
Yep, the old lineup.
Yep.
Valerie Cheek. Thanks for this.
He's got dark meat on the mind now.
Are you dark? Are you dark?
Oh, he's thinking about some Valeries, man.
It's not meant to
Some
prejudice. Why
Valkyries.
is it so important to show both versions? Great point.
He wants some of them Norse cheeks, bro.
Zoomed in version, you can't see a weapon either, right? So I guess I think the prosecution understands that video footage does literally nothing in its current form. And so he knows he needs to somehow zoom it in to at least show something. But that'd be my guess.
JD.
Oh,
Yo,
what up,
JD?
JD? TPSA has 890 people watching. Charlie Kirk channel has 2.6. Valhalla has, I think I'm up over eight now, but together I think we're up in the 20s. So
20,
yeah, we're doing a
25.
little bit better than TPUSA.
Yeah, we're at
That is
24-8
kinda
right
sad.
now.
Shows what
We
people think
left
about
off
credibility.
with,
You know what I mean?
Yeah.
Agent Hall was
Heather Pandola. Maybe
excused
Lance was
in,
limping to try
your
and
proceeding.
simulate
Mr.
Tyler.
McBride.
Don't know.
Yes, Your Honor. We intend to call Jennifer Falmuina, but before I do that, I'd move the admission of State's Exhibit 5.1, if I can approach the bench.
Yes. Thank you.
Your Honor, there will be an objection, and we want to be heard on the objections. And I didn't know this was coming now. It could be a lengthy call.
All right. Let me just, do you wish to identify what State's Exhibit 5.1 is?
Yes, Your Honor. Exhibit
Maybe one day,
5.1
chat, we'll
is
be
a
we'll be like Valhalla,
self-authenticating
VFT, and all those
1102
guys.
statement,
Maybe one day. Maybe
issued
one day.
by
We'll just have to see.
David Engelhardt from Turning Point USA.
All right.
And
What
again, I
the
say it's a
fuck?
self-authenticating document. As you can see there, it's got the admonition on page 1.
Why was that in my For You?
The body of the 1102 statement is there on pages 1 and 2. I would say number 4 is kind of the foundational statement, paragraph 4, but the self-authentication portion is the notary acknowledgement on page 3.
Dude, some YouTuber just popped into my
Attorney
fucking
Dimissiono
For
back.
You feed,
Thank you, Your Honor.
begging people to
Thank you, Mr.
comment.
McBride.
Like, dude, don't do that, man.
So the court, obviously, because the court can decide how much of this we discuss in open court, how much we discuss at the bar, so to speak, sidebar. There's initially a fundamental relevance problem with this 1102. There are also, there are other issues.
There's a
but
relevance problem with all of it.
just to help the court parse the evidentiary issues, we should start with the relevance. There are sub-issues. There's also a problem under 1102 because if the court looks at the last paragraph of this, Mr. Engelhardt, who is the purported author, refers to himself in the third person, so it's not clear to me who actually wrote this report. And as Your Honor knows, 1102 says that prosecutors are not to assist witnesses in writing their own 1102 reports. That's not my primary concern, although I think it is an important issue because that's what the rules require. But the real question is relevance. And I guess the question is, does the court want me to do the speaking objection? Because the court said no speaking objections. Should we approach sidebar? How does the court want to handle it? The people can move their exhibits into evidence whenever they wish. I wasn't aware we were going to do it at this moment. I'm ready to proceed, but the question is how the court wants to handle these objections. I'm prepared to keep going in open court, but it's what the court referred to as a speaking objection.
No, I appreciate that. As it relates to, well, so here's my question for you, Mr. Novak. As you're, and again, I appreciate your discretion in highlighting that point. Do you anticipate your argument being of the nature that would defeat the purpose of, if the court does not admit this, that you've already let the cat out of the bag with your argument, or do you feel that you can make your argument without compromising what is in the 1102, so the purpose of if excluding it is still preserved?
I'll go as far as I think we can go, and then we'll just see. I mean, I do think, I am not trying to conceal from anybody in the courtroom or the public our concerns about relevance. So why don't I, taking the court's lead, go forward publicly with my concerns about relevance. And if we reach a moment where it feels like further argument may deprive Mr. Robinson of his fair trial rights, we can approach.
All right, we'll proceed.
Okay, so then what I'm going to do is I'm going to point out that this proposed exhibit, which is the 1102 statement of Mr. Engelhardt, is basically 4 paragraphs. The 4th paragraph identifies Mr. Engelhardt, although I say in the 3rd person, as a pastor and as an attorney who was a friend and a counselor to Mr. Kirk and was involved in leadership of Turning Point USA. So that identifies who the author is. Beyond that, it's not really relevant to any of the issues before this court. Paragraphs 1, 2, and 3, paragraph 1 talks about Turning Point USA's status with the Internal Revenue Service, the purposes of Turning Point USA within the context of the Internal Revenue Code, and sort of what I'll just refer to generically as the goals and objectives of Turning Point USA. And it also then talks in the 2nd paragraph about Mr. Kirk's relationship with TPUSA. None of this is unknown information, that he was a founder, that he was the chief executive officer, that he was the president of the board until his death. So I'm still not sure what the relevance is. I guess actually what I should say is I don't believe there is any relevance of any of this information. Paragraphs 2 and 3,
to which he never said that she would.
Are
just saying.
And actually, I'm going to preface this. My discussion of this is within the context of the rules of evidence, and there's nothing that I'm going to say here that is meant to derogate, criticize, question Mr. Engelhardt's beliefs. What he says were Mr. Kirk's beliefs. What Mr. Engelhardt says he believes are tenets of Christianity. That's not what we're talking about. What we're talking about is whether this document is admissible in this proceeding under the rules of evidence. Okay. So paragraphs 2 and 3 include not only Mr. Engelhardt's opinions, and now I'm going from relevance to opinion evidence. It's not clear to me whether it's lay opinion evidence, whether it's expert opinion evidence, but it's Mr. Englehart's opinions about a branch of Christianity, his opinions about a portion of the Bible. He quotes the Bible, and he talks about Mr. Kirk's religious beliefs. And I could go into more detail, but the court has the exhibit in front of it itself. So none of this is relevant. If the court looks at the information, that is the document which lays out the allegations against Mr. Robinson, when I use the word information, I'm talking about the court document. There are, with respect to certain counts, what Utah Code refers to as a victim targeting enhancement. That is alleged with respect to count 1. It is alleged with respect to count 2. It is alleged with respect to count 7. And may I step away just to get my laptop?
You may.
And as the court knows, but I want the record to be clear, when I refer to the what the information calls the victim targeting enhancement, that's Utah Code Section 76-3-203.14, which the code calls the victim targeting penalty enhancement. The information alleges, and this is, I'm emphasizing this, that Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's belief or perception regarding Mr. Kirk's political expression. And I'm going to focus, if I may, the court's attention on two things. One is, whose state of mind are we talking about when, or whose state of mind is the statute talking about? And what
any posts that he made online saying that he was going to take his life,
being invoked here?
Anything like that?
The latter is the state invoking Mr. Kirk's political expression, and now I'm quoting the statute, as the personal attribute that the state alleges is the gateway to this penalty enhancement. And if the court will bear with me, because there's a reason why we have these hearings in public, there are various categories for alleging, I should say, there are various categories of personal attributes, that's the phrase the legislature uses, which authorize the pursuit of a penalty enhancement. And those personal attributes are listed in the statute A through R. I'm not going to read all of them because the court knows the law, but political expression is subsection K. That is separate and distinct from the personal attribute that the legislature calls religion, which is subsection M. So what we have is an allegation that the personal attribute, which is one of the elements of this enhancement, the allegation that Mr. Robinson selected Mr. Kirk was based on his political expression. That's actually the exact same phrase, political expression, as is in the statute subsection K. The 1102 statement is predominantly about what Mr. Engelhardt describes as traditional Orthodox Christian values. that he believes in, that he believes Mr. Kirk believed in. And I understand in today's world
If he
that there
had
is,
a boyfriend?
a crossover,
A
between
furry boyfriend?
religion and politics. I think we can all
Right?
acknowledge
He
that.
would have been. He would have believed in the same things that Charlie
the
did.
information here are focused on
Really?
political expression. So I'm concerned that 1102 the 1102 statement of Mr. Engelhardt goes far beyond the scope of what would be admissible if the state has it to prove that Mr. Robinson targeted Mr. Kirk because of Mr. Robinson's belief or perception concerning Mr. Kirk's political expression. The second element of this is that the victim targeting enhancement focuses on the allegation of what is in Mr. Robinson's state of mind, not what is in Mr. Kirk's views or deeply held beliefs, sincere religious beliefs. And so the evidence that the state needs to present is not what Mr. Kirk believed or said or what TPUSA stood for. It's what was in Mr. Robinson's head, if anything.
How do we know
about
that?
Selecting Mr. Kirk because of Mr. Kirk's political expression.
What besides hearsay do we have to go on?
So why TPUSA exists, what its founding beliefs are, what its leaders' beliefs are, what Mr. Engelhardt believes Christianity is or is not relevant. And that's why we think it should not be received into evidence. There's a second level here, which is Mr. Engelhardt's statements about what is in the Bible, specifically Matthew chapter 9. And so I would just ask this court the hypothetical question. If the state asked the court to take judicial notice of a portion of the Bible in order to prove this enhancement, because I can't see where else it fits into this case, I think, if I may, the answer would be no, it's not relevant. So instead, what we have is the state trying to use the affidavit of Mr. Engelhardt pursuant to 1102 to get the court to essentially receive into evidence the same information. It doesn't really matter here in this proceeding what the book of Matthew says. It doesn't matter what Mr. Engelhardt thinks. And again, I say this with all due respect to Mr. Engelhardt, who I've never met. The book of Matthew means.
Okay, so...
Or how one reconciles...
Elaborate, bro.
...the book of Matthew as he sees it with other views on the topics that are there. I mean, I want to be careful and not suggest what other views are, because I shouldn't be testifying about different perspectives within the sort of the heading of religion. But it doesn't really matter for this proceeding what
Dude, what's
Mr.
your
Engelhardt's
point?
views are, what Mr. Kirk's religious views were, what religious views TPUSA endorses, seeks to encourage others to adopt. None of that really matters. There are multiple opinions in this 1102 from Mr. Engelhardt, and it's not clear whether the state has thought about whether it's expert opinion or lay opinion. I happen to think that it's expert opinion that is not helpful to the trier of fact in this proceeding. That's your honor. There is nothing in this that helps the court resolve with respect to the victim targeting enhancement, whether Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's beliefs or perceptions regarding Mr. Kirk's political expression. if the state comes back up here and says, no, it's lay opinion, we still have the question of whether it's helpful to this court, because the court has to decide whether there is evidence of the target enhancement in the way I think I've structured it. So it's not relevant. It's not admissible lay opinion. It's not admissible expert opinion. There are two aspects of Rule 403, one of which I'm prepared to talk about publicly and one of which I think is appropriately discussed at sidebar because it does get into undue prejudice. The 403 here is that receiving this document into evidence is going to create confusion. It's going to create chaos, not by the trier of fact, but by the future jury pool in this case. For this court to make a ruling that Mr. Englehart's opinions about religion, about TPUSA's views on religious matters, that Mr. Kurt's views on religious matters are in any way what this case is about, is going to create significant confusion. And even if this court doesn't show the 1102 in open court, or the reporters who are here don't get to see it, or if the public doesn't get to see it, receiving it into evidence in light of the victim targeting enhancement that the state drafted and charged is just going to create confusion. There may be, outside of this case, litigation where TPUSA's purposes and its mission and its adherence to its mission are important, and Mr. Englehart's opinions about that may be important in some other context, in litigation, in public discussions. It's not important here. When I say important, I'm saying it's not relevant. So there's a 403 issue with respect to confusion. There's a constitutional concern that this type of evidence being sanctioned by the court is going to suggest to the jury pool that this is a case about religion. This is not a case about religion. The state doesn't even allege this is a case about religion. The state alleges one enhancement based on Mr. Robinson's perceptions of Mr. Kirk's political expression. So I'm very concerned that this document, even being sanctioned by the court as admissible for any purpose in this proceeding, is going to interfere with Mr. Robinson's constitutional right to a fair trial, which I think is sort of an umbrella over parts of Rule 403. If at the time, if there is a trial, if Mr. Robinson is bound over, and if there is a trial, and if the state wants to proffer Mr. Engelhart for some specific evidentiary purpose that I'm missing, then we can engage in that. But it seems to me that it's, again, a mixture of lay and expert opinion, which at this stage is more prejudicial than probative. The other part of the 403 issue we can discuss at sidebar whenever the court's ready.
Thank you, Mr. Novak. Turning to the state.
That was a long-winded.
Just to give an overview, what I'm intending to do is address what Mr. Novak has presented, the state respond. I may have some questions limited to what's been presented now. Of course, that doesn't preclude addressing the second portion of that in whatever means is necessary to protect constitutional rights. But we're just focused on this portion right now.
Understood.
Thank you. Mr. McBride.
Yeah, that was a whole lot of nothing.
Your Honor, the evidence is relevant to 2 points. One is to the defendant's motive, which is not an element of the offense.
Oh, yeah,
but
yeah.
Nonetheless is powerful.
It's easy to
evidence,
tell that it's sarcasm,
persuasive
but we got you.
evidence.
We got you.
And two, it is relevant to the victim targeting enhancement, which has been described and appears in the information. The statement clarifies what Turning Point USA, what Charlie Kirk's business was. And I think as you read this statement, it's clear that Charlie Kirk presented both religious and political arguments and positions in his presentations. And that is what paragraph 3 says, that he engaged others in debate, discussion of traditional family values, Orthodox Christian views on sexuality, marriage, gender, sex, America's founding principles, political doctrines, and so forth. He often spoke specifically and attempted to persuade attendees to follow a mindset rooted in Orthodox Christian and politically conservative values.
Excuse me, Your Honor, can I lodge an objection to Mr. McBride reading the...
All right, I want to cut in real quick and show you guys this. So he brought up Matthew 9, right? And there's a few things in Matthew 9 that is being done here. So Jesus, Yeshua, or Yehoshua, which translates to Joshua in English, forgives and heals a paralyzed man. Okay? Calling of Matthew, we all know that he was at the tax booth, right? And he said, "Follow me," and Matthew did, right? Questioned about fasting, right? Raises a dead girl and heals a sick woman. Okay, heals a blind man and the mute. Or heals the blind and the mute, right? Let's see. And the worker served you, right? So, some things that's going on in Matthew 9. I'm curious as to what they're talking about in Matthew 9. They never elaborated.
Honor is not a jury. Your Honor can look at the exhibit and determine for itself whether it's relevant, whether it meets other criteria for admissibility. It's not necessary for Mr. McBride to read aloud in open court an exhibit which the court has available to it. I'm not saying that the court shouldn't read it. I'm saying that it's not admissible. I understand that the court has two roles, one under 104 and one as the magistrate, but that doesn't require Mr. McBride to read in open court the exhibit which we are discussing the admissibility of, especially where I have just expressed our concern that the exhibit has a tendency to infuse the issues in this case and create fair trial risks for Mr. Robinson.
All right, thank you, Mr. Novak. Any final thoughts before I rule on this specific issue about reading from the 1102 by Mr. McBride?
Yes, Your Honor. I have to be able to argue here. I have to be able to refer to the exhibits. I can't do my job as an attorney without being able to refer to the exhibits. If the court doesn't want this to be in public, then we've got to close this proceeding, but I have to be able to argue the exhibits. I don't know how I can make an argument without actually pointing to the language of the exhibits, unless I want to say, you know what I mean, or referring to line 13. It's just so cumbersome to do, Your Honor. And I think my job and my duty to my client, which is the state of Utah, and to their right to fairness, requires me to make a good and powerful argument, and that requires me to refer to the exhibit. And I'll submit it with that.
All right. Thank you to both of you. In looking at this, typically in court, when evidence is being taken, until it's admitted, it doesn't come in. For example, if there's a witness on the stand and one is trying to get a piece of evidence in, that witness cannot read from the document and prior to it being admitted into evidence. And so the court applies that same principle here. However, the difference is, in noting Mr. Novak was drawing points from this specifically, he mentioned Matthew, I believe, chapter 19.
Chapter 9.
And talking about certain points in here specifically, there is room for it to be mentioned in argument in order for the court to fully consider what's before it. I'm going to sustain Mr. Novak's objection and simply say, if you want to talk about it conceptually, talk about the points, you certainly may, but simply reading from it exactly saying, and I understand, I don't want to constrain either party from being able to make their full argument, but quoting from it in open court, I fear does risk issues to the constitutional rights of the parties. If the parties prefer to go into a closed evidentiary hearing on this issue in order to be unrestrained, and it appears Mr. Novak has requested that for a second portion of his argument, we certainly can do so, because I do not want to put out evidence that is not admitted in open court until the appropriate time, until the court has gone through its decision-making process on whether it should be admitted or not. So to the parties, if you feel you can move forward on this first portion of it, I'm happy to entertain that argument. If the parties feel at this point, at this juncture, that a closed evidentiary hearing is needed in order to fully explore all the issues, I will leave it to the parties, because I don't know your arguments, and I don't want to say, constrain you from saying, well, I don't know what you're going to say, but I can't read your minds, and the court will stay in its lane to ensure that it's in the proper judicial role. So the objection has been sustained. To Mr. McBride, in regards to your response, the rebuttal to the argument by Mr. Novak, what is your request?
Yes, Your Honor. I do not believe it's necessary to close this hearing. I would argue against closing the hearing on the admissibility of this exhibit. However, the court needs to rule on that issue before I launch into the fullness of my argument, because I do not want to be admonished for discussing an item that I'm asking to be admitted into evidence in public. So I would ask the court to make a ruling on the closure of the argument about the admissibility of this hearing so that I can make that argument unconstrained. And after that time, after the court rules on that, I will make my full argument.
All right, well, what I'm trying to do is, you've heard the reasoning of the court. I don't want to constrain you. If you're saying, as you stated, that you want to best represent your client, and every attorney should be doing that, that is your duty, I don't want, if you feel that closing this hearing to the public is necessary in order for you to fulfill your duty, the court will entertain that. But I can't have it both ways. If you want me to close the hearing in order for you to be fully, be able to argue freely as you feel you need to, I will entertain that. But I don't want to say, well, I'm not going to close the hearing, and then suddenly the issue is, well, I wasn't able to make a full argument. And so do you need a closed hearing to make a full argument to best represent your client?
I think defense counsel is asking to close the hearing so that the argument can be made without the public.
He's asking you what you want to do.
I do not want to close the hearing. I do not believe it's necessary to close the hearing. That's not my motion. I do, however, want to make a full argument that requires me to rely on the evidence and quote the evidence as I have done. That's my position. If I am not permitted to quote the evidence in my argument, then we need to decide whether or not this hearing should be closed. I would oppose closing it, but I do think it's necessary for me to quote the evidence.
All right. Are you able to make your full argument to the best of your ability to best represent your client by simply referring to the paragraphs and to the lines so it is clear to the court what you're talking about? There's no ambiguity without quoting it verbatim in open court.
No.
No, I don't think so.
All right.
What I say? What I say, chat?
All right, I'll hear from you as well. If you would like to come forward, again, just Mr. Reimer, just stating your full name for the record, for the clarity of the record.
Sure, thank you, Your Honor. David Ryman again for the news media. We have briefed this issue a couple different times so far. Sometimes there is a misconception that I think is running, particularly through what Mr. Novak argued, that suppression hearings, because the evidence may be suppressed or excluded, or in limine hearings, need to be
Right.
closed unless the evidence is deemed admissible. That is the opposite of the law. That has been settled since the United States Supreme Court decided Waller versus Georgia. You can see it in Kearns Tribune, which dealt with a preliminary hearing and access to a preliminary hearing where, as you know, and as we've heard repeatedly today, all kinds of evidence is presented at the preliminary hearing that may not be admissible at trial. And so the universe of the public's right of access to proceedings is not limited just to what eventually gets admitted at trial, which, you know, if there even is a trial. And we've cited the court to, you know, numerous cases on this, and I don't have the brief in front of me, and the docket is huge, and I can find it for you if you'd like. But I just wanted to correct the misimpression that the public is not entitled to hear argument and to see evidence just because it may not be admissible. Otherwise, we would never have admissibility arguments in public. And I do want to I'll just make one.
We
other
deserve
point.
transparency. That's what we need.
Kearns Tribune also speaks to this.
So we deserve.
And that is that if you do decide that there's and so let me just make two quick points. To the 403 point, just because evidence isn't admissible is not a basis to close the hearing. There may be a 403 argument. I haven't seen this document. I don't know what's in it. Maybe there is something incredibly prejudicial. You would have to make that decision. I'm at a loss. I haven't seen it. I'm happy to take a look at it and give you substantive argument, but it's the same high constitutional standard that you have to satisfy in order to close it. And then the last thing is just on the scope of any closure. Kearns Tribune speaks, and I know the court is aware of this. If you are going to close it, it needs to be as minimal as possible. And it's my experience, at least, that most of the argument about things in this context can occur in open court. And if you want to have, you know, a closed session or a sidebar or however, you have also done it in chambers. I just ask that it be as limited as possible. Thank you.
Thank you. All right, Mr. Novak, and appears like, would you like to respond to that before, and then I'll return to Mr. McBride for any final thoughts, and the court will make its ruling.
Well, I just wanted to mention the Utah Supreme Court decision in State versus Archuleta, 857 P. 2nd 234, where this state's Supreme Court reminds us that the First Amendment right of access is qualified, and that what needs to be carefully judged in light of the qualified right of access with respect to preliminary hearing exhibits, that was the issue in State versus Archuleta, is the defendant's right to a fair trial. So we're in this slightly twilight zone situation where counsel for the media is saying, even if the court has decided that the exhibits are not going to be made available for copying and inspection, and the court may decide that this exhibit is either not admissible or admissible for the court's eyes only, counsel for the media is counseling that the court permit Mr. McBride to read the exhibit verbatim in open court. And that basically defeats all of those principles. So I don't think that's the correct path. Counsel for the media is correct that the court's sealing or closure should be narrowly tailored. And the 403 issue, which we are prepared only to discuss because of the sequencing of things in this case, in this proceeding, we're only prepared to discuss at sidebar, has to do with potential future evidence that the court may receive in this hearing, or it may not. So I'm not going to address other 403 issues in open court. If the court wants to defer this entire exhibit and discussion of it until later in the proceeding, then it may be that part of the 403 argument doesn't need to be at sidebar. And I think we're all assuming that sidebar proceedings in this preliminary hearing are going to be part of the sealed transcript until some later point in time. In other words, it's not sidebarred just for the moment, it's because the transcript's going to be sealed. So it very well may be that taking this issue up at a later point in time in this proceeding eliminates the need, from our perspective, for that 403 issue to be discussed at sidebar, or at what counsel for the media says in a closed proceeding. However, I agree with the court that Mr. McBride can't have his cake and eat it too. If he wants to make his argument and he thinks that his argument requires that he read an exhibit in court, which we in good faith are saying is not admissible, then we need to have a closed proceeding. I'm not asking for a closed proceeding. I was asking the court to caution Mr. McBride not to read into evidence exhibits that are not received into evidence, because that's the same as Mr. McBride testifying.
Right.
Thank you.
Yeah.
Anything further, Mr. McBride?
Just to note, I have not made my full argument on admissibility, that's all.
All right, I appreciate the arguments by the parties. This is clearly something that's very important to you all and is important for this case, as is every piece of potential evidence. I note that Mr. Novak indicated that receiving this could create confusion for future potential jurors. And that he mentioned that it could suggest to a potential jury pool that this case is about religion. However, what is happening at a preliminary hearing is far different than what happens at a jury trial. The magistrate, myself, is the fact finder, and whether something becomes admissible at trial is far different than what is admissible at a preliminary hearing. The purposes are different, the standards are different, and different steps need to be followed. Something could become admissible at a jury trial, but given the nature of a jury trial, more steps are necessary. Under Rule 1102, one of the major differences is that reliable hearsay is allowed in a preliminary hearing under the Utah Constitution
and
under the Rules of Evidence 1102. That is far different than what would happen at a jury trial. Taking this into consideration, I look to the information, going to the very beginning, whether this is relevant. And as noted by counsel, looking to count 1, which is squarely before the court, to determine probable cause at the end of this proceeding. And the court is not weighing in whether it will reach that or not. It's not predetermining anything. But what is before this court under count 1, aggravated murder, which is a capital offense, victim targeting enhancement in violation of Utah Code Annotated 76-3-203.14 sub 2, Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression. And so, if that was not here, this enhancement, and it also goes to count 2, felony discharge of a firearm causing serious bodily injury. And I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus religious expression, that goes into different grounds, but at this point, the court finds it is relevant for consideration, and if for at the very least for argument. What the court is going to rule is that the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. that begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about the going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service and the type of business. And so there is grounds for that to occur in order for the court to consider the argument fully and making the determination whether it is relevant and should be admissible. Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court can make its determination whether State's Exhibit 5.1 is admissible or not.
Thank you. 5.1 is a general explanation of what Turning Point USA, Charlie Kirk's organization, is and was on September 10th. The exhibit describes the events that Turning Point USA holds, talking about at least 200 plus of these events featuring Charlie Kirk as a headline speaker had taken place by that time. That's in paragraph 3. That these events discussed political issues as well as religious issues. Those political issues in the portion I previously quoted talked about gender issues in particular, gender, sexuality issues, the difference, or the Christian and political view regarding marriage and families and gender identity. And that information is relevant to the motive that we are alleging in this case. And it's also relevant to the victim targeting enhancement, which is in part a motive type enhancement. And the evidence will be introduced through, or we will offer evidence through other witnesses that talks about some of the defendant's statements that indicate his gender persuasion and that he falls into some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk publicly in front of large gatherings of people debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses, that talks about that being the inference and the motive that he had, or the inference from that evidence supports that motive, which supports the victim targeting enhancement, and frankly, motive in general, which goes to identity. For that reason, Your Honor, this exhibit is relevant. I don't see the prejudicial effect, unfair prejudicial effect this would have on the fact finder. Whether or not it has, some capability of prejudicing the potential jury pool, I think that's a completely different question. I don't think it does. I think this case has already highlighted the political issues that we're talking about here, and but my job here is to present this case to the court, to you, Your Honor, for you to make a decision. This evidence is admissible for that purpose. Whether or not it's public or published for the public to see is a different question, which I'll submit. The media is very capably represented, and I'll let them make the argument on that point. But I would ask the court to admit this exhibit.
Mr. Novak?
Thank you, Your Honor. For the state to argue that this exhibit says anything about Mr. Robinson's state of mind should be rejected out of hand. This exhibit does not say anything about Mr. Robinson's state of mind, and that's what motive is, and that's what the victim targeting enhancement adopted by the legislature focuses on, is the defendant's perception. If Mr. McBride wants to propose significant redactions to this exhibit so that Your Honor, acting as a magistrate, can consider things that are narrowly tailored to what the information alleges, which is the alleged allegation is that Mr. Robinson perceived that Mr. Kirk had certain political views, that's one thing. But this document talks, and now Mr. McBride, not to be colloquial, has sort of thrown down the gauntlet. This document talks about foreign affairs, political doctrines, America's founding principles, cultural trends, and what Mr. Engelhardt refers to as Orthodox Christian views on sexuality, marriage, and gender/sex. So this document goes way beyond what the state just flagged for the entire world is their view of Mr. Robinson's motive, which has something to do with gender identity, gender ideology, and sexuality. That's what Mr. McBride has just said this case is all about. This document goes way beyond that, and that's why it's not admissible. There may, as I said, be other evidence which Mr. McBride and the state want to rely upon, which they haven't presented yet, and Mr. McBride hinted at that. So I think that it's not admissible at this point in time. I don't think it's relevant in the sense of has a tendency to make a fact of consequence more or less true. That's the definition of relevance. So how does this court go from what the state has to establish, which is motive, or well, actually the state doesn't have to establish motive. Motive is not an element of the offense. But at least with respect to the victim enhancement, according to the legislature, the question is what is in Mr. Robinson's state of mind? The other thing I want to say is that Mr. McBride did not address the admissibility of these opinions. Now, the court talked about 1102, but 1102 doesn't resolve all of the other rules of evidence. It's just a gateway for an affidavit. So what we have in this document are what I think are purport to be untested expert opinions or at least lay opinions. And the question is, under the rules of evidence, is whether this document is helpful to the court when it makes a determination about whether Mr. Robinson perceived that Mr. Kirk had certain political views. So where is the evidence that Mr. Robinson, in this document, that Mr. Robinson was aware of Mr. Kirk's political views? Where is the evidence in this document that Mr. Robinson had
opposing views and a motive to do what he did?
Disagreement with Mr. Kirk's political expression. None of that appears in this document. There may be other evidence of that we'll have to see, but there's nothing in this document which connects up with Mr. Robinson's state of mind, which is the question in the enhancement. And Mr. Engelhardt cannot, of course, express any opinion about Mr. Robinson's state of mind because he doesn't know him, and because that would be improper opinion evidence under any rule of law. So for a document to be received into evidence that quotes one very narrow piece of religious doctrine, and that involves Mr. Englehart's interpretation of what that means. I mean, Mr. Engelhardt at the top of page 2 is basically telling this court what he thinks Chapter 19 means. How could that possibly be admissible in this proceeding? And how could it possibly be admissible for the purpose of this court concluding what Mr. Kirk thought Chapter 19 of Matthew means? So it's not relevant. It's improper opinion evidence. It's definitely overbroad in terms of
did I mishear?
The evidence that the state is proffering to prove a very narrow point, and it actually doesn't get to that point, which is what was Mr. Robinson's state of mind. It also doesn't say anything that Mr. Kirk specifically said on September 10th that Mr. Robinson may or may not have heard, or anything that Mr. Kirk said before September 10th, specifically, that Mr. Robinson may or may not have heard. Nor has the state presented any evidence, and as an officer of the court, I would say I don't think that the state can present any evidence that Mr. Robinson specifically heard Mr. Kirk say a specific thing at a specific time. There are some statements which I think that the state will say are admissions by Mr. Robinson, which reference Mr. Kirk, which we will get to later. But none of those reference specific statements by Mr. Robinson about specific statements by Mr. Kirk on any specific issue that would even make a piece of this relevant. So I'm pretty sure that I've reached that point where anything more I say, I'm going to be repeating myself, and so I'm just going to stop unless the court has questions.
I don't. Thank you. Well, I do have a question as it relates to political expressions. Does religion or gender intersect with political expressions?
I think that's a great question, but probably not a question to be answered by me in this proceeding. That's actually a really, really complicated question that the state wants the court to say is a simple yes.
All right.
Because I don't want to be the expert. I mean, the court's basically asking me to testify. I'm not trying to be flippant. The court is asking me to testify about where religion and politics intersect. And that's a fascinating question. The question here is whether this document,
you can't
separate the way it's presented, the way it was written,
you can't,
is admissible under relevance and expert 701, 702 rules of evidence to prove what Mr. McBride says the state, what he acknowledges the state has to prove, which is that Mr. Robinson had a state of mind which was, let's just say, hostile to Mr. Kirk's political expression. And I don't think that this court should be deciding, based on the record before it, where, if at all, politics and religion intersect. That's. I mean, if the court needs to resolve that issue, then the court also needs to resolve the question of which religious philosophy are we talking about?
Well, Mr. Novak, I bring that up because you mentioned it. You said you cited directly to the enhancement. You said political expression, and then you went to the Bible itself. And so it appeared to the court that you put it into play. So I just wanted to get a little bit of guidance from your position. And so that's the reason for the question.
No, I totally appreciate the question. I'm not suggesting, Your Honor, that there's a problem with the question. Any question that the court asks is a question that counsel should take seriously. The legislature separates in the statute religion and political expression. The state selected the victim targeting enhancement based on political expression only. Now the state wants to bring, I didn't bring Matthew in, the state is bringing Matthew in through Mr. Engelhardt. I didn't bring the Bible to this courtroom, the state brought it. And that concerns me greatly because the state is turning this into a question of
religion,
whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride
You're the
just
one
did,
who brought
is
up
he
Matthew,
turned this
though.
case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls
Unless I missed
Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
Thank you. All right, anything further before the court makes its ruling? I appreciate the in-depth argument and the passion behind
Yeah,
the
I'm pretty sure
argument.
he's the one who brought up
You are
Matthew.
Advocating for your clients, and I respect that.
Yeah, Your Honor, I'd just say it provides context for the defendant's state of mind. That's all.
All right, in making this determination whether it's admissible or not, I'm going to start at the beginning, which is this. This is a preliminary hearing. The purpose is to determine whether the state has established probable cause to believe a crime was committed and that Mr. Robinson committed it. As it relates to this case, as I turn to relevance, I turn to the information as previously stated, and is this relevant, what is before me? And without indicating my decision on probable cause, because I am not at that point, I'm withholding all decision-making until all evidence is properly before me. And so in this ruling, it is not indicating either direction that the court is heading. However, the court finds that it is relevant as it relates to the victim targeting enhancement, as it relates to Charlie Kirk's political expression, and the court recognizes the argument made by defense in regards to state of mind. And it is because of both arguments that the court finds that the court is ruling that it is provisionally admitted into evidence. And at such point when it becomes relevant based off what Mr. Novak has talked about Mr. Robinson's state of mind about Mr. Kirk's political beliefs, then at that point, whether it is admitted or not into evidence will be decided upon. So as of right now, it is provisionally admitted. Because of that stance, it will not be published to the courtroom or media, but both parties can weigh in on that when this is brought up again and the request for it to be fully admitted is made by either party. Then the court will re-examine whether it should be published at that time to those in the courtroom and to whether that is displayed or filmed by the camera. All right, let us proceed. Well, let us proceed to lunch because it is now 12:40. It seems like a natural place to stop. I believe everyone looks
Cool, I just
like they
ordered,
need a
so-
lunch break. So let's go ahead and break for lunch. Let's go come back at 1:15. Well, I need to give you a full lunch here. I need to do my lawyer math and see what that would bring us to. So it's 12:40. Let's come back at 1:45 for lunch. All right?
So that's a whole hour.
Any party need the benefit of the record before we break for lunch?
Not from the state, Judge.
No, Your Honor.
All right. Court is in recess until 1:45.
Yeah. Very, very curious. Okay, so now they're gonna bring in religion. Okay. And here's the thing, and I always say this about religion itself, right? there are laws that we always base morality on. And what is that? Well, that's religion, right? There hasn't been a single civilization that has been remotely successful that hasn't used religion as a means of how it conducts its, let's just say, law, society, mainly to do with legalese, right? Not a single one. Not a single one, right? Especially with how it conducts, let's just say, trials, right? Trials, things that happen in the court of law, right? Because you think about this, right? Why is it illegal to lie under oath? Well, because it's lying, right? You're not being truthful. Okay, well, where do we get that sentiment from? For the majority of people, it's religion, right? It's a sin to lie. So then we use that same morality and apply it to other aspects, right? Such as politics. So the state has always relied on morality that comes from religion to base on as basis on how the state functions, right? Yeah, it was just about to mention under oath. Yep. That's just another way of saying that every country has religions. Yeah, exactly. Not that religion is important to the success of countries. That I completely agree with. I do believe that there can be successful countries, right, that do not use religion as its main as its center, I should say, right? Such as countries like Japan. Now, I would say that Japan does have a center, which is Buddhism, right? Buddhism and Christianity. However, what I would also say is that Japan isn't one of those countries that solely operates off of religion to be, right, to be that. Or its main basis on how it functions, right? So a country does not need religion to because we all can understand. We all can, even without religion, we all can understand that lying is wrong, cheating is wrong, stealing is wrong, killing is wrong. We all understand this, right? We don't need religion to say. And I've always said this: if you need religion to be a good person, you're not a good person, right? So, just wanted to throw that out there. But maybe I'm being a little bit too confrontational, but whatever. Japan is more Christian than any other religion. Is that true? Let's see. Population of Japanese that are Christian. Let's take a look at that real quick, huh? Let's see. Christians make up less than 1% to 1.5% of Japan's population. Out of approximately. Oh wait, are you talking about? Are you okay? So, are you talking about how the Japanese are more Christian than any other religion? I'm confused by what you mean. Like they're more Christian than anyone else that's Christian? Is that what you mean? But you have let's see, out of approximately 124 million people, this amounts to roughly 1 to almost 2 million Christians in Japan, right? So they are a overwhelmingly minority, if you guys will also remember, the Japanese were actually also executing Christians back in the day. Right. From what I understand is that more of their population was Christian. Well, I mean, according to AI Overview, that is not the case. It looks like this is coming from a Japanese website too, so. So yeah. I wouldn't necessarily believe that they're a majority Christian. I highly doubt that. I highly doubt that. If anything, I would say they're majority maybe atheist. Here, let's see. Population of Japan. And that is atheist. Yep. See, told you. Surveys indicate that anywhere between 57 to 86% of Japanese population identify as atheists or agnostic or religiously unaffiliated. Told you. Told you. And they're doing fine. Well, I wouldn't say fine because their birth rate isn't exactly doing great either, right? And their economics aren't really doing it. But that's also because they're under the thumb of the U.S. after World War II as well. So, you know. But again, the main point is that you cannot separate religion and politics. You just cannot do it. You can't. There's no feasible, because again, where do we get our law from, right? What's moral? What's good? What's just? What is just, right? How do we what do we base that on? Typically religion, right? Especially since America is supposedly a Christian nation, right? So I'm not saying we're not supposed to. A lot of people will argue with me and say, well, the First Amendment, you're arguing against the First Amendment. No, I'm not arguing against the First Amendment. Matter of fact, I'm arguing for the First Amendment because that's exactly the point. Like we are supposed to separate church and state. That's the whole reason for the First Amendment. However, because of who we are, right? Because of who we are as the let me say the animal thinker, right? And I put it like that because we use our brain several times more than what any other animal does. So we think, we ponder, we look for answers, about life, questions that we might have, right? So we want to understand the world around us, and for a lot of people, for the majority of people, religion is that, right? So that's why they use religion a lot. And because they use religion a lot, they also take religion and put it into politics, right? That's why you can't separate the two. So we haven't been able to do it quite yet so much, right? We haven't been able to do it quite yet. But I think, and this is just my opinion, I think a proper society is one that uses or perhaps perhaps understands the morals that religion does bring, the good teachings that religion does bring, however, does not use it as a center of how that country functions, right? Because as soon as you start getting into religion, a lot of things become pretty muddy, pretty hairy, because unfortunately religion is subjective. And a lot of people get different interpretations of what they see, hear, and read. And by that, it becomes pretty confusing right off the bat when we're talking about a direction that a country is supposed to head into as it pertains to what they what they get from their religious doctrine. Right? So, but since they're heading into Christianity, religion, right? I'm very familiar with Christianity, Judaism, and Islam. Very familiar with it. So as soon as they want to start bringing that stuff in, I'm going to be picking whatever this stuff apart. I doubt that they're going to get too far into it, but I do believe that they will use it. Okay. All right. So we're going to take a look at Matthew 19 because they brought up Matthew 19. All right. So Matthew 19, they're talking about the laws of Moses, right? Which is the theme all the way throughout the Gospels, is the laws of Moses, right? So there's a question that's brought up to Jesus, whose name is, again, Yeshua, Yehoshua, who translates to Joshua in English. Names matter when it comes to Christianity, but that's for another conversation. All right, so the question was divorce, okay? So, and I'll just say Jesus so that we all are on the same page. When Jesus had finished saying these things, he left Galilee and went into the region of Judea to the other side of Jordan. Large crowds followed, and he healed them there. Some Pharisees came to him, and they asked, "Is it lawful for a man to divorce his wife for any reason and every reason?" "Haven't you read," he replied, "that at the beginning the Creator made them male and female?" Right? This is where a lot of people have issues with this right here. Made them male and female, and said, "For this reason, a man will leave his father and mother and be united to his wife, and the two will become one flesh." So that no longer will they be one flesh. Therefore, God has joined together, and well, let no man put asunder, but let no man separate. Let no one separate. Right? That's one of the most famous, passages, perhaps. Right? Passages. I don't want to say but maybe just verses would be good. Would be good enough to say. That's Matthew 19. Let's just say 4 through 6. Okay. "Why then," they asked, "did Moses command that a man give his wife with a certificate of divorce and send her away?" Jesus replied, "Moses permitted you to divorce your wives because your hearts were hard." Right? "But it was not this way from the beginning. I tell you that anyone who divorces his wife except for sexual immorality and marries another woman commits adultery." Okay. Yeah, I tell you that anyone who divorces his wife except for sexual immorality. Oh, and marries an okay. Oh, okay, Gotcha. Okay. All right. So they are committing sexual immorality. Okay. All right. But I can guarantee you they're going to bring up this specific passage. Where's 5? Okay. I can guarantee you they're going to bring up this specific passage or this specific verse right here, because the reason for that is motive, right? Now, obviously, Charlie Christian had Christian beliefs, therefore man, woman, right? Man, the head of household. Whereas Tyler, they're going to push the argument of Tyler being a homosexual man who had a boyfriend, and they're going to say, oh, hey, well, he disagreed here, so then that was the motive for Tyler to do what he did, right? So, although I do think, and this is where I'm going to agree with the prosecution. I do agree that there needs to be motive, right? And since they are framing or they're identifying Robinson as a left-wing person who does not have the same lifestyle that Charlie did, then they would use this evidence as a means to find a motive, right? So, but here's the thing. What they now have to do is they have to prove that Tyler specifically said that he would do what he did, right? Actual evidence of that, possibly him admitting to it, and not the absolutely fabricated bullshit text messages that he sent Lance, right? Here, let me see if I can pull up some of that for you guys. All right. Okay. Let's see. Where Robinson, drop what you are doing. Look under my keyboard. When the roommate looked. Okay. Roommate, what? You're joking, right? I'm still okay, my love. Who talks like this? Who talks like this? No one refers to whoever they're romantically involved with these days as my love. Okay, this is not fucking Shakespeare. All right, but I'm stuck in Orem for a while longer yet. For a while longer yet. No one taught. Dude, this is it's like this is a Shakespearean play, bro. What the fuck? Exactly. Exactly. Bad chat GPT. 100%. Oh, dude. Let's see. Oh man. Shouldn't be long until I can come home, but I gotta grab my rifle still. It's like, dude, it's like you can tell which one sounds human and which one sounds AI. You know what I'm saying? You can tell. For whatever reason, my screen just went black. Yo, that's sus, bro. That's weird. Yo, chat, my screen just went black. And then it came right back up. What was that about, dude? That's crazy. All right, let's continue. To be honest, I had hoped to keep this secret until I died of old age. I'm sorry to involve you. No, especially while you're on the run. While you are running from the crime scene, you're texting all of this. This doesn't make any sense. You weren't the one who did it, right? I am. I'm sorry. I thought they caught the person. No, they grabbed some crazy old dude. Yeah. So some crazy old dude that literally just dropped his pants and said, "I'm the one who did it." Right? That's the guy. That interrogated someone in similar clothing. How does he know this? How does he know this? Apparently, this is all happening the same day. How does he know this if he is running away and supposedly hiding? How does he know this? It's so obvious this is faked, right? It's so obvious. I had planned to grab my rifle from my drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering. Why? Why did I do it? Yeah. Had enough of his hatred. Uh, some can't be negotiated out. Some hate can't be negotiated out. Department of Stupidity tweeted it out the same. Yes. Yeah. It makes no sense. It makes no sense at all. I mean, but then again, this is also coming from the same department whose head of the FBI was literally pulling people over, and as they were detaining people, right? Cash was literally going, "We got him. Oh, we don't got him. We got him now. Oh, we don't got him. We got him now, but we don't got him." Right? What a fucking dude! This if you cannot recognize that this is an absolute joke, okay? That all of this is fabricated. I don't know what to tell you. I don't know what to tell you. Anyone with a brain, with someone who can think for themselves, can absolutely tell that this is faked. Absolutely. If I'm able to grab my rifle unseen, I will have left no evidence. I'm going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything about them finding it. How long have you been planning this? A bit over a week. So a guy who hardly has any, well, potentially hardly has any experience performing actually has no experience with performing let's say operations, maybe like but performing something like this, right? Going in virtually undetected, right? And then also leaving virtually undetected, as we were just talking about earlier, jumping off of a roof, right? No one even seeing it, nobody even acknowledging it. I would imagine that is AI. I would argue that is AI by the fact that no one is reporting that. No one even notices someone walking there or jumping off of the building. I would say that is AI. And the fact that Bagley's body camera footage just cuts out, right? Real suspect. Really suspect. There's just, and the fact that you also see AI in the footage, right? And then also with the screenshots that I showed you guys, it has to be that all of this was faked. All of it. All of it was faked for a false flag. That's the only way that I could actually ever, explain this. Right? The clipping of the chair that Charlie was sitting in. The blending of the faces in the crowd, right? Body camera footage just cutting off. Bullet casings being found on other buildings. No one knowing, or no one seemingly seeing anyone jump off of the roof that Tyler supposedly was, right? And why is it that the camera panned? You guys saw it pan from looking at the street over to the Low C building at the exact moment that Tyler jumped off of the building. And why is it that two men, more than likely students there, who were filming that building right before the shot rings out, and they're not interrogated? And then also the another angle filming Tyler running from the roof. right? And that's not even to say him changing, disassembling a rifle, and well, yeah, that's pretty much it. Yeah, changing and disassembling a rifle all in under a minute. There's just no way, right? There are way too many inconsistencies. Way too many inconsistencies. There's just there is absolutely no way. What do you guys think? What do you guys think? Okay, so we got 4 votes. 4 votes. There's a 50-50. Okay, do you think they will convict Tyler? I asked you guys that at the beginning of the stream. So, but BRB chat. Appreciate you guys waiting Food got here, so I had to go pick that up and then use the restroom. I was holding it for a little bit, so. All right. I think he can argue for vindictive prosecution. If they don't have the evidence of if they don't have any other evidence of hate, right? Then it's going to be hard. And given the prosecution's performance so far, they've got a long way to go. But this headache probably it's probably not so far to go itself, because trying to understand these guys' logic giving me a massive headache. But there's just no way, man. All right, let's get back to reading this, and then after that, we'll check in with yeah, we'll check in with the other guys after this. Let's see. I can get close to it, but there is a squad car parked right by it. I think they already swept that spot, but I don't want to chance it. I'm wishing I had... I'm wishing I had circled back and grabbed it as soon as I got to my vehicle. I'm worried what my old man would do if I didn't bring back Grandpa's rifle. This really doesn't make any sense to me. Why would Robinson be worried about his grandpa's rifle? Also, you know, as we looked earlier, this could possibly pass depending on maybe stamps. Because a lot of the times when you see Mausers, well, not a lot of times, but there are some rifles, some weapons, I should say, that have survived from World War II, right? There are some antiques. And you can find some of them that are stamped, right? So I could potentially see an original Mauser being stamped, and that would be Grandpa's rifle, right? Why not just take it with him if he was worried about it? Yeah, exactly. Yeah, why drop it off in a location, right, where it's possible that law enforcement would be there, right? And this was in someone's backyard. This was by a chicken coop, right? Someone who attends to livestock, they're going to check that regularly. So how did no one notice some kid in their backyard drop off a rifle there? Wooded area or not? But then, this is the rifle. This doesn't make any sense, bro. This is a synthetic stock. For those of you who know about rifles, okay, what I have heard from others who are, you know, more knowledgeable than I am, Some collect Mausers, and then they essentially modernize it, right? They modernize them by just taking the bolt and the barrel and then putting them onto a synthetic stock. Which, why the fuck would you do that? When the rifle's already in a good enough condition anyways. You know what I'm saying? So, but again, this could definitely pass for grandpa's rifle, right? This other bullshit, no. You will never convince me that this would be grandpa's rifle. They're absolutely not. Absolutely not. No. A Mauser. Now, again, I have heard other people say, again, more knowledgeable than I am, right, about collecting and stuff like that, modernizing antique rifles. But I don't believe true collectors would do that, right? Like anyone who appreciates rifles, especially World War II era, they would no, absolutely not. No, they would not be modernizing a rifle. No. Anyways. Let me see. I don't even know if it had a serial number. Every firearm does. But it wouldn't trace to me. I worry about prints I had to leave on it in a bush where I changed outfits. Enfield would be grandpa's treasure. The Enfield, I'll say this, I love the Enfield. The Enfield's one sexy weapon, man. But as someone who has worked with Enfields and someone who has also had Mausers, Mosins, Garands, the Mosin's where it's at, yo. The Mosin Nagant, such a beautiful weapon, man. And if I remember correctly, the Mosin Nagant was the first bolt-action rifle. I'm going to fact-check myself on that, though. Let's see. Oh, it wasn't. Okay. It was adopted. Bolt action technology have been in the military for... Oh. Wait, what? For real? Since the 1840s, bolt action rifles were a thing? What? You're telling me that in the 1840s, right? 1841, because it said exactly 50 years. 1841, bolt action rifles were a thing. Well, let's find out. What's the first bolt action rifle? The Dre's needle gun. 1836. And this wasn't used during the war? Should be the Germans. Yep, German, Johann Nicholas. Oh, von Drees. What the fuck? I thought it was the Mosin Nagant 1891. That's what I thought. I legit thought that. Well, the more you know. Was a revolutionary muzzle-loading needle rifle that later evolved into a breech loader. Interesting. Firing paper cartridges using a long firing pin. Huh. Interesting. Let's see. Let's just say used in a military. Let's see that. The Prussian. Okay, so it was used. Okay. This adopted in the Prussian army, 1841. Damn. Have I heard of the new SSRS? No, I don't think so. Let's see. Server. No. What's the? Oh, we have the money for each soldier to get, but none for healthcare, right? Well, there is TRICARE. You do get TRICARE when you're in. And that also covers spouses and children, kids. Ooh. This is what we're talking about right here? No. Yeah, is this what we're talking about here? Do we really have to keep putting things in the AR platform? Oh, okay, then yeah. So is this going to replace the 203? What? The Barrett SSRS. That looks like a behemoth of a gun, bro. That's crazy. Before I click on a site here, it's going to replace everything. Well, it's going to blow up everything, so. That looks so stupid. That looks so stupid. Excuse me. All right. Excited to be working with Barrett, the world's premier manufacturer to mature our 30 mic support rifle system. Huh. I had no idea. That is one ugly ass gun, though. That is an ugly gun, dude. I hate the way that looks. It's like they tried to copy the Scar. It's like if Bear Creek got a hold of a Scar H. Damn. Really? What? Yo, could you imagine you show up to heaven one day? You show up to heaven one day and you explain to God why you're at the pearly gates. You're like, dog, bro, I didn't even see it coming, dude. I got sniped by a grenadier. Like, what the fuck? Dude. God's like, maybe I should rename Earth. Maybe you go to purgatory before you die, you know? Well, if it shoots 30 Mike, if it shoots 30 Mike through a fucking window, you know, a few miles away, there's no telling how many clicks that is. That's some crazy shit, dude. No, I have no idea. I will say though, the new squad weapon or oh, what is it, the XRS or something? New infantry rifle. Oh, the XM8 carbine. I do have to say though, the XM8 carbine is sexy as fuck. That's one sexy rifle, bro. Is that a 5.56 or a 308? More than likely chambered in a 5.56. And here, guys, we have another AR system, AR platform, to replace the AR platform. You know, I never really had too many things to say negatively about the M4. M4 was a good it's a it's a good weapon. The good thing about the fours that we used, the M4s that we used, was that we could choose where all of our equipment was going, such as the PEC 15s, flashlights, foregrips. But this, what is that? Is that a 6 or 7 inch barrel? Is it gonna have a fucking can on it too? No. No. No, they wouldn't give cans to regular infantry. There's no shot. There's no shot. Yeah, there's no way. There's no way. That barrel is short though. That has to be like a 6-7 inch barrel there. Maybe 8. Well, maybe it's too short. Maybe about 12. 12-inch barrel, maybe. But I would say anywhere between 8 to 12. That is a sexy rifle. That's a nice rifle, bro. But yeah, couldn't complain about the 4s. The 4s were nice too. All right, back onto the topic. Okay, let's see. Where did we leave off? Didn't have the ability or time to bring it with. That doesn't make any sense. That does not make any sense at all. He literally had it with him when he jumped off of the building. So how does that make sense that he couldn't bring it with him? That's just leaving evidence for them to find. Let's see. Might have to abandon it and hope they don't find prints. That's not how this works, bro. Not only did they find Robinson's prints, but they also found DNA, fingerprints of multiple people. Crazy. Multiple people. Right? So, and supposedly this was a rifle that was put into storage for years and years and years. Right. Now, what we've come to find out here recently is that DNA can be left on an object for months, right? But definitely nothing longer than years. So, to find multiple fingerprints from multiple different people, that's just really weird to me. That raises yet another red flag. Let's get going. Let's see. How will I explain losing it to my old man? Why would someone be concerned about that? Right? Why would someone who just committed allegedly a heinous crime be worried about their grandpa, their dad? And also, here's something I just remembered. The parents themselves, they said that they never turned Tyler Robinson in. They said that themselves. So, this doesn't make any sense. But I'll talk more about it as soon as I come back. Give me just a few seconds, guys. BRB. Okay. All right. Back at it. Let's check real quick. Okay. So what time is it? It is. It looks like it's just about time. Probably here in the next 10 minutes, I think. Okay. All right. Let's see. Only thing I left was the rifle wrapped in a towel. Okay. Here's something to note. Let's see. I want to bring this. Come on. All right. Here's something to note, right? The average towel length, right, which is supposedly a bath towel, right? It's 54 inches. Okay. So let's do length of the length of the rifle of a Mauser. Let's see total length here. Total length of a Mauser 43.7 inches. Okay. So there's about a little over 10 inches left to kind of work with there. Right? So as he's wrapping the whole thing, right, we should expect to see the rifle completely covered, right? But if we looked back at the, let's see, can we let's see if we can kind of rewind this a little bit. Oh, we can't. Well, that sucks. Why can we not? Okay, whatever. In the footage, what we could see is it looked like there was a towel, but the towel was kind of just flapping around in the wind. You know what I'm saying? Like it didn't look like someone had wrapped a towel there. I mean, but then again, it didn't really look like someone was there to begin with, right? Because if someone just heard a boom, right, people aren't just going to be walking around as if nothing ever happened, right? And especially if they see someone jumping off of a building, right? It's really surprising to me that no one stopped him, no one apprehended him, nobody did anything. And again, it's like they didn't even know he was there. So that begs the question: was he there? Was he real? Guys, are we actually in a simulation? It's settled, guys. The Earth is flat. All right. Remember how I was engraving bullets? It's weird how they were saying that there were bullets that were engraved, but we never actually saw any of them. Where are they? I didn't see any. So, what the hell? The whatever message are mostly a big meme. If I see notices bulge on Fox News, I might have a stroke. All right, I'm gonna have to leave it. Judging from today, I'd say Grandpa's gun does just fine. I don't know. I think that was a $2,000 scope. If it was a $2,000 scope, why was it treated like it was? Because if I remember correctly, it was in storage. Like in a garage kind of storage. It wasn't like in a gun cabinet or something that was supposed to be kept up, right? Am I right, chat? Am I wrong with any of that? Like it was stored in a garage and it was just put away for years and years and years, right? That's the story. For those of you who know guns, you don't do that with any weapon that you have, right? I haven't cleaned my Glock in a while, and I'm like, you gotta clean it, bro. You know, I'm jumping my ass to get that thing cleaned. I need to clean all of my weapon systems. So, anyways, delete this exchange. Who says this, bro? Who says exchange, bro? Delete my messages. Like it's no one says. No one says this, dude. No one says this. Delete this exchange, my love. Like, no, what the fuck, man? Dude, if any dude is talking like this to anybody, bro, he's not getting any attention at all. Do I have any ladies here in the chat? Like, if you had a dude, if you literally had a dude that literally called you my love, bro, I would be put off by that. All right? That's weird. My dad wants photos of the rifle. He says Grandpa wants to know who has what. The feds released a photo of the rifle, and it is very unique. Here's another thing. How does someone look at a rifle and they automatically think, oh shit, that rifle, to which it's been in storage for years and years and years, has just been posted on the news? How do you look at something like that and immediately know that it's your rifle? That doesn't make any sense, right? Especially a Mauser. Doesn't make any sense at all. He's calling me right now, not answering. Since Trump got into office, has been pretty diehard MAGA. I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. You are all I worry about, love. What? No one talks like this, dude. I'm much more worried about you. Why? That's really weird. Why would you be much more worried about your lover? That doesn't make any sense. Don't talk to the media, please. Don't take any interviews or make any comments. If any police asks you questions, ask for a lawyer and stay silent. Oh, dude, this is what is really kind of concerning to me, because if they wanted to get more info as a key witness, oh, excuse me, they would have brought Lance in. It only makes sense. Like they should have immediately questioned Lance. And I have no idea if they even did that, right? I mean, shit, the two dudes that had video footage of Tyler supposedly on the roof in prone position right before the shot rang out, and they didn't even think to interview those guys. There's a lot of holes here, man. Of course, we already know that. But so let's see. The unnamed roommate told investigators that Tyler Robinson had messaged to say that he left a confession under his keyboard after last Wednesday's shooting at Utah Valley University campus in the city of Orem. Said prosecutors, authorities have said the unnamed roommate was a biological male who was transitioning from man to woman and was in a romantic relationship with the defendant. Right, just like we were talking about earlier. Here's the full record of So this is the narrative. This is the narrative. So none of this. They need to bring in, because this is probably going to be the best piece of evidence. Right here. Right here. This is probably going to be the best piece of evidence that they can bring in to even get past the preliminary, bro. Because if they're wanting to make a religious argument, right? Then what better way to prove that point, right, than to have this Lance Twiggs person, right, to come and testify. Well, if they were a real person, if they were a real person, then they could probably do that. But didn't Lance also get immunity? Here, hang on a second. Oh, the prosecutors are expected to present surveillance videos, autopsy finding, blah 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 blah, and play video, blah 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 blah. Interview with Lance Twiggs, Mr. Robinson's former roommate and lover, that could shed a light on defendant's motive. Mr. Twiggs has received immunity. Oof. Guess we're not going to be seeing him there. So, yeah, all of this, all of it, and it's so right in our faces, bro. How sus all of this is. Yeah, bro, it's so sus. Are we back? Oh, looks like we're back. Looks like we're back, chat. Oh. All right. How's everyone doing? How's everybody doing? I know this is already another long stream today. I appreciate you guys sticking in there with us. So big shout out to you guys again for sticking with us for a while. Trust me, my back's hurting me, so I know this is rough too. Rough for me too, guys. Perhaps we're not back just yet. It's already, yeah, it's just about time to come back. Here, let's see real quick. What these guys are saying.
They put religion, beliefs, opinions, business affairs, political standing, etc. in the statement in hopes of emotionally manipulating the jury. Let's see. Example, if I'm a that or Republican, I'll find sympathy for the victim if he is also correct.
100%. 100%.
And that's why they're trying to get that thrown out.
Yep.
Yeah. But he already admitted it, but only in certain context, so we don't know when he's going to use it.
Yep. We'll have to wait and see.
I don't give a Dom. Thanks for another super. Do you think they'll submit Tyler's Chick-fil-A receipt from 19 at UVU? If they believe Tyler ate at Chick-fil-A and the video showed he paid cash, it would show the footage and be on the receipt. Correct.
Don't know about again. I got to give this dude credit for being so calm and just like hitting up fast food places after doing the most like dramatic, stressful thing of your entire life.
Yeah.
Just like, nah, I'm good, homie. I'm just gonna walk to Dairy Queen now.
Yeah, that's right. I forgot. I forgot about that. The same day that he did that, he went to Chick-fil-A.
Fucking dude ate like a cow.
Yeah, I watched the Apple TV series Smoke, which makes me think if it's TR, he could be altering his gait walk to hide, mislead his identity. That's possible, right? You want to look like somebody else.
No, I've done that before, so I can relate to that. I went to a leftist rally and I limped around the whole time, so I didn't seem threatening.
There you go.
So, yeah. Yvonne Olson liked all channels. Thanks. We appreciate that very much. Thank you for covering this.
Thank you. Thank you.
I don't give a damn. Thanks for being a member for 5 months. Card possibly approves more and DQ as second data point. Yeah, I don't give a damn. I know you. I know you're over there with Baron as well. But if you have some information, I know you put stuff on X too. But feel free to hit us up. I mean, you can email us, and we're looking for researchers and stuff too. So.
Oh, by the way, guys, if you
Here's another one.
guys
Please say allegedly.
if you guys happen to have any information for me, make sure you let me know too. I'll absolutely cover it.
It's not clear. Well, that's another big problem. Is it's like they keep saying it's very clear that that's him in the footage. No, it's not. It's very clearly a white kid in a dark hat and sunglasses.
There's no way to really show.
AJ says I'm halfway expecting this prosecutor to start quoting Nietzsche.
It is Tyler.
We are back in.
Oh, are we? Yo, what's going on with APT?
Pause her testimony.
All right,
Defense is not
we're
going
going
cross
to
at that
Associated
time,
Press, guys.
And we're going to call an FBI DNA analyst out of order. It's a defense witness, but that's to accommodate that witness's schedule. State calls Sergeant Jen Falmuina.
I'd like to come forward and be sworn in.
Calling it right now. More hearsay.
All right. After you're situated, there should be a bottle of water to your left, maybe behind the monitor. And if you wouldn't mind just bringing that microphone just a little bit closer to you so it picks up your voice for the recording. Mr. McBride, your witness.
Will you please state your name?
Yes, Jennifer Famuina.
Where do you work?
I work for the Utah Department of Public Safety.
What position do you hold there?
I am currently a sergeant within the State Bureau of Investigation.
What was your assignment September 10th, 2025?
I was assigned to oversee the crime scenes as well as the physical evidence.
And were you sergeant with the State Bureau of Investigation at that time as well?
Yes.
And do you have any kind of specialty in your assignment there?
Yes, I do. I am currently overseeing, or I am the lead over our evidence response team within our division. That includes not only conducting training, but also attending training and whatnot.
Okay. So if we...
I hope you guys brought your forks, because I'm about to eat a bunch of word salad here.
Were you called to the crime scene at Utah Valley University on September 10th of 2025?
Yes, I was.
And were there multiple scenes that you oversaw or helped to process?
Yes.
We've had some testimony about the rooftop of the Low C Center. Did you oversee the,
Yes, sir.
or are you aware of evidence that was collected in that area?
Yes, I am.
Was there a screwdriver that was collected from that rooftop?
Yes.
And do you know how that was collected and what happened to that screwdriver?
Yes, that was collected by the Utah Bureau of Forensic Services Crime Scene Response Team, or also known as our State Crime Lab.
And do you know what happened to that?
Yes, it was packaged, and then that evening there was discussion on who would take custody of the evidence, and I was there along with FBI. Then it was decided that FBI would take custody.
And did that evidence actually go to the FBI?
Yes, it did.
And was it sent for testing?
Yes, it was.
Where was it sent, do you know?
It was sent back to their, I guess, their equivalent of our crime lab.
Okay. Are there other areas there at Utah Valley University that were also processed for the presence of evidence?
Yes, there was.
Is there a wooded area that's northeast of campus?
Yes.
What was found in that wooded area?
What was found there was a long gun that was wrapped in a dark colored towel.
And you say a long gun. What does that mean, a long gun?
Sorry, that would be a rifle. So for to be more specific, it was a Mauser 98 rifle.
Do you know what caliber that was?
It was retrofitted to a 30-06 barrel.
And do you know what kind of action that had? Was that a semi-automatic, automatic, bolt action?
It was a bolt action.
What is a bolt action rifle?
I'm not too familiar with guns, but I just know there's a bolt and you have to pull it back.
Okay. And what was done with that weapon?
How's she in law enforcement? She barely knows what guns are.
And eventually, pictures were taken. It was documented in place, and then afterwards, we rendered that gun safe, and then packaged the gun as well as the towel.
What was done with the towel after it was packaged?
The towel was also provided to the FBI.
And those two items. Well, let me tie up that thread. The gun. What was done with the gun?
The gun was packaged. It was taken to FBI custody. Then eventually it was provided to the ATF lab.
Okay. So the gun went to the ATF lab. Is that correct?
Yes.
The towel went to the FBI lab.
Yes.
And the screwdriver went to the FBI lab.
Yes.
Did you receive reports back from testing that had been done on those items?
Yes, I did.
I'd like to show you State's Exhibit 31.
Bro, she leads in investigations and critical domestic violence, bro. And she hardly knows what firearms are. She hardly knows anything about firearms. I don't believe that. I don't believe that, man.
It's connected to the defense computer right now. Is there any way to switch it? Thank you.
What was that noise?
Okay, I'm showing you here on the screen State's Exhibit 31. Do you recognize that?
Yes, I do.
What is that?
This is the FBI report that was provided to me by the FBI that documents DNA testing.
And does that include testing that was done on the screwdriver that we've spoken about and the towel that we have spoken about?
Yes, it does.
Okay, what I'd like you to do, Kimberly, if you'd please just scroll down so that Sergeant Falmuina can observe this exhibit. If I can have just a moment. And can you see who that report is signed by?
Yes.
Who's that?
Amanda Baker, I'm assuming is how you pronounce your last name.
Is that, in fact, the report that you received documenting the testing results on these items and some other items from
Yes.
the FBI?
Sorry, yes.
And does it appear to be in an accurate condition as to how you received it?
Yes.
I'd move the admission of State's Exhibit 31.
Defense?
No additional objections.
All right, so I'll note the standing objection, and as it relates to admission, what is your request as to publication?
I'd move this admission and its publication both to the court and to the public.
All right. Anything further, Mr. Burt? No. All right. The court will admit State's Exhibit 31 into evidence and allow publication of this exhibit to the gallery and to the monitor on screen in the courtroom and for the camera to broadcast.
Okay, if you'll go to, Kimberly, if you'll scroll down to, still on page 1, where the screen will show items 7 and 8. Lines that say item 7, that line?
Yes.
And will you read that portion of the report that describes what item 7 is?
Item 7, TOW from around Mauser rifle, serial number 8863.
And there's also some other identification numbers. Is that the towel that you found with the rifle that day?
Yes, it is.
On September 10th?
Yes.
Item 8, will you read what that says is a description of item 8?
Item 8, screwdriver from perch.
And is that the screwdriver that you described that was collected from the rooftop?
Yes.
Okay. If we can go to page 3 of 6, please. Will you, item 7, sub 1, will you please read the result there from the title item 7 until the word contributors?
And would you mind repeating that, but with the microphone? I want to make sure that the record picks up your objection. All right. Either way, if you want to come up, that's fine, Mr. Burke.
Judge, the objection is that her reading to the court what's in the report is cumulative, since we have the analysts here who will be testifying to what the report says and what it means. So you've got the report in evidence. We don't need this witness's reading the report to the court. So it's a 403 cumulative objection.
Mr. McBride, do you wish to respond?
My point is only to draw your attention, Your Honor, to the relevant results that will be discussed by the other expert, as well as the results of the items we've discussed, the towel and the screwdriver. That's all.
All right. The court will overrule the objection and allow a brief overview of it, not going line by line, page by page. So if it is brief, I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes. Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 7 sub 1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver?
They took a screenshot,
right?
so we'll
Yes.
do that too.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Okay, thank you. A couple of foundational questions before we finish for now. First off, do you know who Twiggs is?
Yes.
Who is Twiggs?
Twiggs is Lance Twiggs. He was a roommate of Mr. Tyler Robinson.
And do you know if Lance Twiggs's DNA was obtained for comparison in this test?
Yes, it was.
And how was that DNA obtained?
It was obtained by law enforcement officers.
And was that by a buccal swab?
Yes.
What is a buccal swab?
A buccal swab is basically like a Q-tip or a swab that we'll just place in someone's mouth and just scrub the inside of their mouth to obtain the cells.
And then that Q-tip is then packaged and sent to the lab for testing and comparison?
Yes.
And was the defendant, Tyler Robinson's DNA, also collected in the same manner?
Yes, it was.
Okay. Thank you. Nothing else.
Right. Mr. Burt, cross-examination.
Your Honor, I'd like to reserve the right to cross-examine after the witness completes her testimony after the following.
Oh, would you mind grabbing the microphone? I just want to make sure what you say is on the record.
With the court's permission, I'd like to reserve the right to cross-examine on the area she testified about until she's completed her testimony.
Okay, okay, I see what you're saying. Any input, Mr. McBride?
Your Honor, that's what we expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so should I have the sergeant step down or?
Yes.
Okay. Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the party?
Yes, to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right? Thank you.
Okay.
All right, Mr. Burt, turning to you.
Your Honor, out of order, the defense would be calling Amanda Baker.
All right, Ms. Baker.
Why are they telling her to leave? Oh. Because they took her
All right, Ms.
DNA?
Baker, if you wouldn't mind coming forward right up here by the bailiff and being sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth.
Dude,
So help
you're
you
in
God.
court, bro. Turn
All right,
your
Ms. Baker,
shit
if you wouldn't
off,
mind
man.
Being seated at the witness stand.
Put your shit on fucking vibrate, dude.
Once you're
It's not
situated,
that hard.
there should be a water bottle for you if you'd like behind the monitor. And after you're seated, if you wouldn't mind just pulling that microphone close to you so it picks up your voice, okay?
Okay.
Mr. Burt, your witness.
Your Honor, we're going to need the monitor switched over to our side if we could. While we're doing that, good afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled Bakker.
And Ms. Baker, what do you do for a living?
I am a forensic examiner in the DNA casework unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that location?
A little more than 10 years.
And just in general, what are your duties?
My duties are to manage a case. When a case comes into the DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Ms. Baker, in this case, were you requested by the state of Utah to do certain testing?
Yes, I was.
And when were you called upon to do that testing?
That was September of 2025.
And do you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit receives evidence for analysis, is it true that the turnaround time is about 200 days?
It depends. We've wavered between 90 days and over 200 days. I would say on average, it's somewhere between 180 and 200 days.
However, did this case come in on what's called a priority 1 level?
Yes, it did. And what that means is we worked 24 hours a day, 7 days a week until examinations were complete.
And is it true that you were still you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high-profile nature of this case, an item of evidence would be submitted to the lab. It would be inventoried by our evidence management group and then sent to the various units for testing, for example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files?
Yes, I do.
And document your examination in other ways?
Yes.
Do you have your case file with you?
Yes, I do.
Okay. And in your case file, are there notes of conversations that you have with people that are relevant to your testing?
Yes, that's called our communication log.
Now, do you have your case file there in front of you?
Yes, I do.
I think the pages are numbered. So I'll ask you to go to page 22 of your case file notes.
Okay.
And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication communication entry on September 13th, 2025. All spoke with FBI Special Agent Folger and Utah SBI SA Dave Hull. Gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
And you told them that, quote, Robinson was included as a possible contributor to the DNA from the towel and the screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right. I'd now like to direct your attention, if I could, to exhibit number, State's Exhibit 31, which is in evidence, and I think it's our tab 2. And that's in evidence, so if you could display that on the screen.
Mr. Bird, are you requesting it to be displayed to just your screens or to all screens?
No, since it's in evidence, Your Honor, I'd like it displayed to the public.
Okay, let's go ahead and put it on the main monitor as well.
Okay, could you go to page 6, please? And highlight the third paragraph. This is your report dated September 15th, 2025, correct?
Yes, that is correct.
So this is 2 days after you had the conversation with the agents as to what your results were.
That is correct, yes.
And in your report that you wrote 2 days later, you included this language that's highlighted there, correct?
That is correct.
This report conforms to the Department of Justice uniform language for testimony and reports for forensic DNA examinations. Correct?
Yes.
Okay. Now, I'd like you, if you could, to take a look at that standard that you referenced. And then I believe is that, and this will be just to the witness, not to the public.
Okay.
Calling up tab 7. Do you see that on your screen?
Yes, I do.
Do you recognize this document?
Yes, I do.
And tell the court what this is.
This document is the approved standards for scientific testimony and reports for autosomal DNA testing.
And is this the document that you were referencing in your report?
One of them, yes.
And is it a true and accurate statement of what the policy of the FBI is in regard to reporting DNA in a case of this type?
Yes.
I move that document into evidence, Your Honor.
So is it just this page or all the pages? Because it says one of 6.
Yes, so this would be the entire document.
Mr. McBride?
I don't see the relevance of this document. I object on relevance grounds.
Mr. Burt?
Your Honor, the document is referenced in a report, and it defines the parameters of what her opinion means. So I think it's very important for the court to understand the limitations of the opinions being expressed.
And just for my understanding, when you say in her report, are you referring to State's Exhibit 31?
That's correct.
All right, Mr. McBride, any further thoughts?
No, I'll submit it.
All right, so State's Exhibit, well, I'm sorry, how am I labeling this exhibit for the defense?
Your Honor, we have our exhibits organized by witness, and we would be submitting to the court electronic copies of these under named witnesses. So this would be Baker 7.
All right, Defense Exhibit Baker 7 is admitted into evidence, and as it relates to publication, what is your request, Mr. Burt?
Your Honor, I would ask that this be published since the report is published, and this is important to understanding the limitations of the report.
And so published in the courtroom and on the monitor for the media?
Yes,
Okay.
correct.
Any thoughts, Mr. McBride?
No objection.
All right, it will be admitted and published both in the courtroom and on the monitor for the video camera.
Okay, so this document has various subjects, correct?
That is correct, yes.
And it, in the beginning, tells you how to frame your testimony in terms of inclusions or exclusions, mixtures, sex determination, et cetera.
Correct, yes.
And then there's a section called Statements Not Approved for FBI Autosomal DNA Testimony in Our Laboratory Reports.
That is correct, yes.
Okay, so if we could go to page 5 for that statement. Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct, no, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty.
That is correct, it was not.
Okay. And then the next one, not that one, one more down. Not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a 0 error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a 0 error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
You can
sorry.
take that down.
Can you clarify your question?
Yeah. When it refers to don't state that there is a zero error rate. What in general are the sources of error in DNA, in the kind of DNA testing that you do?
Human error could be an error.
Mm-hmm. Anything else?
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Now,
Human error.
To your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's on. No, not on the big screen.
Okay, so not to go onto this main big screen.
Correct, this is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4, fourth down, one more. No, next one. An examiner, does a policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted and are stated in your report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down. Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
Formal activity level is determining an activity that causes DNA to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some situations, if a piece of evidence has been buried for a long time or is in a river for a long time, it would be my expectation, based on my experience, that I probably won't get DNA off of an item that's been buried for 10 years, for example. However, I cannot give exact timing as to when DNA was deposited on an item.
And I was talking more about a situation where you actually find DNA on an object, be it a gun or anything else. You can't say when that DNA was deposited, correct?
Sure, that's correct.
And how long, in general, does DNA persist on an item? Once you've made contact, how does DNA get deposited on an item in general?
In general, DNA can be deposited a few different ways, via body fluids such as saliva or blood, or skin cells. So touching an item or wearing an item, DNA could be deposited. Once DNA is on an item, if it's subjected to ideal conditions, it's out of heat and high UV, it's not subjected to any kind of cleaning or chemicals, it can persist on an item rather indefinitely. It can degrade slowly over time, but we've certainly worked items of evidence that are 40 and 50 years old, and we've been able to recover DNA.
Now, could you explain to the court the concept of degradation of DNA samples, what that means and what it suggests with your testing?
Sure. So degradation of DNA is breaking up the DNA. So if you think of DNA like a long rope, it's essentially taking that rope and cutting it up into pieces. Seeing degradation in a sample could lend me to believe that there may be, that sample may have been subjected to cleaning or high heat, an extended period of time. So I can't tell why an item is degraded, but looking at my data, I can tell if that sample is potentially degraded or broken down.
And two of the items that you examined were referred to as items 7 and 8, correct?
That is correct, yes.
One was a towel and one was a screwdriver.
That is correct, yes.
Were both those samples degraded to a certain extent?
May I refer to my
Certainly.
data? So item 8 was the screwdriver from the perch. I would say that there was some degradation. As I look at the DNA peaks or the DNA data, in an ideal world, if there's no degradation, I would expect all the peaks to be at the same height. Here I see a ski slope type effect, meaning that the data on the left is a little bit taller than the data on the right. As far as item 7, item 7 was the tau. There was a slight amount of degradation, but not as much as item 8.
Okay. And what is the effect of degradation on production of the allele? First of all, what's an allele?
An allele is an individual's DNA type. So we inherit half of our DNA from our mom and half of our DNA from our dad. We're looking at something called short tandem repeats, or STRs. These are small segments of DNA that repeat themselves over and over again. We all have those same sections of DNA, but what might differ amongst us is how many times it repeats, and that's actually what we inherit from our parents. So for example, at one particular location, my mom may give me 14 repeats and my dad may give me 15. So when I'm looking at the DNA types, I would say that I have 2 alleles at that location, a 14 and a 15. As far as degradation goes, it could cause some of those alleles to do something called drop out, meaning when I'm looking at the DNA chart or the DNA data, I do not see information, I do not obtain numbers at that particular section of DNA.
And is it true that in the testing that you were doing in this case, STR testing, what you were looking at is the length of the, what I'll call, have you ever heard the boxcar analogy?
I have, yes.
Tell the court what that is.
So the boxcar analogy is how many times that section of DNA repeats. So that section is essentially letters. So for example, A, C, T, G. So you may have A, C, T, G repeated 10 times or 12 times. Each of those sections of H, C, T, G would be considered one boxcar.
And so when you're looking for alleles, you're essentially counting the boxcars. Could be 7 boxcars, and that person would be a 7.
That is correct, yes.
And from the mom and from the dad, he may have inherited 10 boxcars.
That is correct, yes.
And so that person at that particular location would be a 710.
Yes.
And what you're doing in your testing is comparing those numbers to what you get from a known sample to see if they match.
That is correct, yes.
Is that true?
Yes.
Now, is it true that what you mentioned the A, C, T, and G, correct?
Correct, yes.
Is it true that you are not measuring the sequence within the boxcars? You're just measuring the length of the boxcars?
That is correct. So the sequence would be equivalent to letters in a word. What I'm looking at is the number of words versus the letters that make up that word.
And we'll talk about this a little later, but people can vary not only in the length of the boxcars, but in the sequence within the boxcars, right?
And that is correct, yes.
And what your testing looks at is just the length?
Correct, yes.
Okay. Now, and is it also true that you're looking across many different locations?
Yes. So at the FBI laboratory, we use a kit called Global Filer, and this is looking at 21 different locations on a human's DNA, in addition to 3 sex-determining locations. That lets me know if an individual is biologically a male or a female.
As between two individuals, 99% of their DNA is exactly the same, right?
That is correct, and that makes sense. We're all humans. We all have arms, legs, and a head. Less than 1% of our DNA is what differs amongst us, with the exception of identical twins.
But with within that 1%, you're looking at these length differences, correct?
Correct, yes.
And you're looking at what you called short tandem repeats.
Yes.
How many, you said you looked at 25 locations?
We're looking at 21 and 3 sex type determining, so 24 total.
What are the sex determining? They're called the locus, correct?
Correct. So locus is that individual section of DNA.
Right, and they typically have names or numbers associated with them, correct?
Yes, they do.
So what are the sex determining loci?
So there is amylogenin, and that lets me know if an individual is male or female. And then there's 2 specific male sex-determining locations. One is Y-indel, and one is DYS 385. Those just let me know that those are specific to male individuals.
Okay, and then for the other locations you're looking at, those you're just looking for 2 types at each location, correct?
Correct, yes.
Okay. Now, for the samples that you looked at, the 7A and the 8A, did you get a full, what's called a full profile would be a profile where you have all 23 locations present?
That is correct. So a full profile means I have DNA at every single location. It is above our threshold, and I'm seeing 1 or 2 pieces of information at each location. For item 7, I did develop a full profile.
For item 8, you developed a full profile?
Item 8 was a partial profile, so I did not develop DNA at every single location.
Okay, so what that means in your comparisons is you have certain information in the question sample that for whatever reason doesn't appear, correct?
Correct, yes.
So you can't make a comparison at those locations?
That is correct.
All right. What makes it not appear at certain locations?
So it could be that there's degradation. So those larger locations could be broken up so that it wasn't detected during the DNA process. It could be a low-level amount of cellular material to begin with. So if I only have a few cells, I may not have enough to detect at every single location.
Okay. And for the 8-1 sample, did you measure Mr. Robinson and Mr. Twiggs's DNA at the 23 locations?
For item 8, I did not have a full profile, so I did not have data at all 23 locations to compare it to either Mr. Robinson or Mr. Twiggs.
Right, but you had full profiles for Mr. Twiggs and for Mr. Robinson, right?
For their known sample?
Yes.
Yes, so for their known sample, that was a sample that was taken directly from those individuals, and I did develop a full DNA profile.
Okay. And just to illustrate how this works, is one of the loci that you looked at called the DYS 391 loci?
Checking my socials.
Yes, it is.
And what type was Mr. Robinson at that loci?
At that location, Mr. Robinson was an 11.
And I think you said you inherit one from your mother, one from your father. But when you say he's an 11, technically he's what's called an 11-11, correct?
So for this, DYS 391 is actually that male location, so he would not have, or anybody would not have inherited anything from their mother. So at this location, I would only expect to see one piece of information, and I did see an 11 here.
Okay. And for the D3S loci, what was his type?
His type was a 17.
Now for that loci, you'd expect two types, correct?
That is correct.
And when you say he's a 17, do you mean he's actually a 17-17?
That is correct. He inherited 17 repeats of that location from mom and 17 from dad.
Other locations, for instance, the VWA, he's type 18-19, correct?
That is correct, yes.
So you're looking at those, and what the machine produces are peaks, correct?
Correct, yes. They're just spikes on a graph,
I have
similar like
no idea
spikes on a heart monitor.
What this,
And you said
all
for
this forensic
8A,
talk
you had
is.
certain
Never heard of it before.
locations where the test sample didn't have any results.
That is correct.
So at the TPOX location, Mr. Robinson is a type 8-9, correct?
That is correct.
Mr. Twiggs is a type 8-11.
That is correct.
But when you looked at the sample, 8A, it didn't have any of those types.
That is correct. So I could not compare at that location.
Now, are there certain rules for when you exclude someone? In other words, when you're comparing two samples, are there rules which say, here's where I would conclude that he could not possibly have contributed this sample?
Yes.
Your field has a lot of literature written about it, correct?
That is correct, yes.
And do you generally like to keep up with that literature?
I do, yes.
And across time, there have been several books, publications that attempt to educate you and courts and lawyers on the technical aspects of DNA testing, right?
Correct, yes.
One of the books, the early one, DNA Technology and Forensic Science by the National Research Council.
I'm familiar with that, yes.
That's an authoritative book that was really one of the first books on DNA testing.
Yes.
All right. And then by the same organization, National Research Council, the Evaluation of Forensic DNA Evidence.
Correct, yes.
Published in 1996. So you're familiar with that as well.
Yes, I am.
And then there's an author, I believe, who did his research work at the FBI named Dr. John Butler.
Yes, I'm familiar with him.
And you have studied his work both in your training and your continuing education.
That is correct, yes.
And he's got 3 current textbooks on the topic that we're talking about, right?
I'm not familiar with how many textbooks he has. I know at least the one.
Fundamentals of Forensic DNA Typing.
Yes.
Familiar with that. Forensic DNA Typing Methodology.
Yes, I'm familiar with that one as well.
And Forensic DNA Typing Interpretation.
Yes.
Everybody in your field relies on these publications and use them as teaching tools.
Yes, I would agree with that.
And then in addition to those books, there have been studies that have been done on particular topics, correct?
Yes.
This case, we're dealing with mixtures, correct?
Yes.
And mixtures present certain challenges that are not present when the samples are not mixed, correct?
Not necessarily. So first, to define a mixture, that simply means DNA from more than one individual in a sample. So if I were to take a sip from a coffee cup and my husband were to also take a sip, if I were to swab that coffee cup, I would get a mixture, his DNA and my DNA together. As far as it being difficult, you can have some mixtures where there's one contributor that donates a lot of DNA and the second contributor donates a little bit. For DNA interpretation, that is not challenging for me. Where it can become challenging is if you have 4 or 5 individuals within that sample all donating roughly around the same amount, it may be challenging for me to determine if a person is included or not.
And would you also agree that that challenge exists in situations where you have what are called low quantities of DNA?
Again, that could be possible. So I could have low quantities of multiple individuals, which is simply just saying that I can't determine which piece of DNA goes with which individual. So that's possible.
What is drop-in?
Drop-in is where you have environmental DNA that's not inherent to that sample that's detected during our DNA process. DNA testing is very sensitive, so it could be that we have a peak that's detected, like I said, from the environment.
And what is dropout?
Dropout is when you have an allele that is not detected or a piece of DNA information that is not detected. So in the DNA chart, there is no number associated with that particular location.
And degradation can cause dropout?
Yes.
So if you have a person at a particular location that is a type 1415, and because of degradation, that 15 drops out, what you're seeing on your chart is just the 14, right?
That is possible, yes.
And that presents a certain challenge, does it not? Because if the 15 is not there, you could misinterpret that as a type 1414, correct?
Not necessarily. So we have thresholds. We have something called the stochastic threshold. If that 14 is above that stochastic threshold, I'm confident, based on our validation, our testing, and my training, that the DNA type there is only a 14. If that 14 falls below that stochastic threshold, that could be indication that there is another peak. So when I'm interpreting, when I'm comparing, if that 14 is below threshold and someone is a 1415, I will not automatically exclude them.
What is stochastic effects?
Stochastic effects.
I'm going to object at this point. I think we've gone beyond the scope of preliminary hearing. I think this is getting into 702 material that's not necessary for the probable cause determination.
All right.
I think
Mr. Burt?
I think it goes directly to the reliability of the testing results that the state introduced. I think the court has to understand the limitations and the potential sources of error in order to assess whether these results are reliable.
And in regards to this line of questioning, how far are you going to go on this line of questioning?
I have this one question, and then I'm moving on.
All right, Mr. McBride.
I'll hold them to that.
All right, well, Mr. Burt, so the objection is overruled. You may proceed with that question.
You can answer.
Could you repeat your question, please?
Tell the court about stochastic effects.
Stochastic effects, when you have low-level samples during the DNA copying process, based on how the DNA is copied, you could have alleles that are copied better than other alleles.
Okay. Now, on another topic, I mentioned studies before. One of the studies that you're familiar with is called the PCAST report. Are you familiar with that report?
Yes, I am.
And tell the court what that is.
PCAST report is, PCAST stands for the President's Council of Advisors on Science and Technology. And this was a committee that was found, I believe, under the Obama administration that gave guidance on different areas of forensics.
Including how to deal with mixed samples and how to deal with samples that have low quantity of DNA.
I don't know that I would agree that it's how to deal with them. They gave some of their concerns on low-level samples and mixtures.
Right. And they also did a follow-up report to assess whether using the kind of software that you used in this case had been established as reliable, correct?
That is correct.
And what was the software that you used in this case to reach your statistical results?
The software is called StarMix, STRMIX.
And the PCAST report specifically addresses whether reliability has been established with respect to StarMix, correct?
I don't believe reliability came into question. I think PCAST thought that there needed to be additional testing as far as mixtures and low-level samples go.
Mixtures and low-level samples that had certain characteristics, right?
That is correct, yes.
Including mixtures where what's called the minor contributor was in the sample below 20%.
That is correct. So the minor contributor would be an individual that donated less DNA to that sample. So PCAST called into question mixtures of 3 or more individuals with that minor or that low-level contributor making up 20% or less.
7 and 8 samples in this case were both mixtures, correct?
Yes, that is correct.
And did you determine what the proportion of mixture was between what I'll call the major contributor and the minor contributor?
So I did not calculate that personally. Part of the StarMix software, it does a couple different things. One, it takes a mixture and it uses math and biological modeling to try to break that mixture into its individual contributors. And then it also calculates a likelihood ratio, which is the statistic that I report. During that process, it does give an estimate of the breakdown of those potential contributors.
And what was, first of all, for the 7 sample, was the minor in there at less than 20%, according to StarMix?
Yes, it was. For one of the runs, when I compared to Mr. Robinson conditioning on Mr. Twiggs, it was a 5% to 95%.
Okay. And how about for the other sample?
For item 8, one of the contributors was 11% and the other was approximately 89%.
So below 20%, right?
Correct, yes.
And the concern expressed in this report, which was written by experts in your field, correct?
No, that is not correct. The PCAST report was written by individuals that were not practitioners or any type of laboratory personnel.
Right, but they list the experts who provided input into that report, do they not?
Yes, they did.
One of them was Bruce Bedoli, correct?
Correct, yes.
Who's Bruce Bedoli?
He is a DNA expert within the field.
Well, he was the head of your unit for a number of years before you came on board, wasn't he?
He was, yes.
And he's written extensively on forensic DNA testing, has he not?
He has, yes.
The report also lists Eric Gilkerson, correct?
That name does not, I do not recall that name.
Forensic examiner for the Federal Bureau of Investigation Laboratory?
I don't recognize that name.
How about Bruce McVicker, forensic examiner, Federal Bureau of Investigation?
Objection, Your Honor. I'm going to renew my objection. I think this is beyond the scope of determining probable cause. The standards that apply here are that the court weighs the evidence in the light most favorable to the state and avoids credibility and balancing the evidence of the stage. I think we're far into 702 territory at this point.
Mr. Burton.
I'm not sure I understand the objection into 702 territory. 702 deals with reliability of evidence. That's what the court is here to determine. So again, it's directly relevant to reliability. This report criticizes, for the specific samples she's using here, the reliability of this testing. And her response was, oh, but they weren't experts. But the report indicates that there were experts who were consulted on this report. So I think it is relevant, and I think it goes to the issue of reliability, and it's the only question I have on this area as well.
Anything further, Mr. McBride, or do you wish to respond to that?
Just that 702 deals with admissibility. It does discuss reliability, but it's directly related to admissibility of the testimony at trial under the Utah Constitution and under the robust case law in this area. The court does not weigh the evidence, draws the inferences in the favor most in the light most favorable to the state. And I think we're beyond that point now. We're getting into the admissibility questions.
All right. Anything further, Mr. Burt?
No, Your Honor.
All right. Well, as this is the last question, I'm going to overrule the objection, but as a reminder to all parties that this is a probable cause standard, and as it relates to, well, I will just leave it at that.
Are you familiar with that analyst?
No, I'm not.
Okay. Just to close the loop on the PCAST report, what they said in the report was that published evidence supports the foundational validity of probabilistic genotyping with some programs of DNA mixtures of 3 individuals in which the minor contributor constitutes at least 20% of the intact DNA in the mixture, and in which the DNA amount exceeds the minimum required level for the method. Isn't that what they concluded?
That sounds accurate, yes.
And do you know why the level 20% raises reliability issues?
I do not know.
Okay. But you do know that in this case, both your samples had minor contributors below 20%.
That is true, but in this case, it was also only a mixture of 2 individuals.
All right. Now that's the next thing I was going to ask you about, which is what is NOC?
NOC stands for number of contributors.
And when you use this program, this genotyping program, StarMix, who decides what the number of contributors is?
That's my determination based on my experience and training, looking at the data. That's something I input into StarMix.
Right. And that's a complex determination, is it not?
Not necessarily.
But it can
Hang
be
on,
in some
chat.
cases, correct?
Cat's coughing up a hairball.
It could be, if there's mixtures of a lot of individuals and a lot of the peak heights, the size of the spikes are relatively the same, it could cause some trouble for me as an examiner.
All right. One of the groups that studies your field is the National Institute of Standards and Technology, correct?
That is correct, yes.
They're in the Department of Commerce?
I believe so, yes.
Federal agency?
Yes.
And they published a report in 2024 called Forensic DNA Interpretation and Human Factors, Improving Practice Through a Systems Approach. You're familiar with that publication, right?
I am, yes.
And was that publication written by scientists?
I don't recall exactly who the authors of that publication were.
Okay. Just to make sure. That the it's a long report, right?
Yes, it is.
And you've read it.
I've read highlights of it.
Is it true that one of the things that they say in that report is they have a section on the complexity of number of contributor estimations?
Objection.
Are you?
Same objection, Your Honor. This is beyond the scope of a preliminary hearing. Again, we're talking about expert reports. We're talking about scientific studies. These materials are all fine to consider at a 702 admissibility hearing. At this stage, where, again, the evidence is viewed in the light most favorable to the state, this is unhelpful to the court's determination, and therefore irrelevant to this proceeding.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, I think the report that the state put into evidence, as clarified by this witness, indicates that she reached the conclusion that Mr. Robinson and Mr. Twiggs were, quote, possible contributors to these two samples. And so the one thing the court has to weigh is what is the weight of that opinion given the science or lack thereof? And one of the important issues here is how she derived these statistical numbers. And as an offer of proof, I'll indicate to the court that the numbers derived from this software program, and that software program is dependent in large part on how many contributors the analyst puts into the input of the software. And the numbers can change if the number of contributors is changed. And in this case,
all right, guys, back.
As I'll show through the examination, this examiner originally thought there were 3 contributors. And I will show to the court why she changed her analysis, and will indicate through this publication that there has been criticism of the way in which she determined the number of contributors. So I think it's important for the court to assess whether you've got accurate numbers in front of you. The state put in these astronomical numbers and are asking the court to give weight to them. And I'm asking the court to consider how those numbers were arrived at and whether there are reliability issues with regard to those numbers.
So the concern that I have is, I turn to State v. Ramirez, 2012 UT 59 at paragraph 10. It states, furthermore, the magistrate's role does not encompass an assessment of whether such inference is more plausible
Found more DNA than one person.
An alternative that cuts in favor of the defense. That is a matter of fact-finding, which is left for the jury at trial. And so when I'm staying in my role as a magistrate, I hear what you're saying, but my concern is based off case law that dictates what I as a magistrate should be doing. If I want to stay in that lane, my fear is as we go down further down this path, which again is not precluding if this were to proceed, if there were a bind over, if there was a trial, that certainly that could be determined. But at this point, at this stage, how do you weigh this issue as I'm weighing State v. Ramirez in deciding whether we're going past the probable cause stage?
Sure, and I think the answer to that is we have to take into account the ruling that you made in this case, which is the law of this case, which is when we objected to the hearsay aspect of these DNA reports and other reports, you ruled that you are the ultimate determiner of the reliability of the hearsay evidence being admitted. And you will recall that our argument was the statute was unconstitutional because it was dictating that you find certain evidence to be reliable without considering whether it was reliable. And your ruling, as I understood it, was no, you retain the ultimate determination of whether the evidence is reliable. And that's not a credibility issue. It's, is this reliable hearsay that the state is offering? And so issues that go to whether these numbers that the state is putting in front of you are reliable, I think go directly to the substance of your ruling, which is that your role here is to determine reliability of evidence. And I'm familiar with a case that the court cites, but I think that has more to do with weighing evidence and making credibility assessments, whereas I'm focused on what the court ruled, which is we have to look at reliability here, and that's my job as a magistrate.
Mr. McBride, any final thoughts?
Yes, under Rule 1102B4, this the Exhibit 31 is considered reliable hearsay. In addition,
hearsay is not reliable. Stupid.
Credibility determinations are not proper for the court to make here for the whole reason that, studies supporting this science, studies opposing this science.
Trust me,
Testimony from
bro,
this
I knew
expert
this
or
guy.
that expert about what is reliable, what is not, what's more reliable, what's less reliable, factors that affect all those determinations. Those are all very, very complex decisions. There will be probably multiple day hearings dealing with that. And a probable cause determination is just not the place to conduct that kind of thorough, in-depth, and searching analysis. Rather, the case law, the Constitution of Utah that says the only purpose of a preliminary hearing is determining probable cause, the case law, the rules that all say the court does not weigh the evidence at this stage, but leaves that for a finder of fact, the jury.
It's like a kid trying to explain
that all supports
to
cutting
a
this
COD
line of
lobby
questioning off at this point,
how
rather
they're
than going on
cheaters.
for,
right.
into greater depth.
When bro was cheating, you know?
Well, based off what's been presented before me, I'm going to sustain in part and deny in part the objection made. I'm going to allow this question to be asked, and so that is denying, but sustain in the sense that this would be the last question, and if Mr. Burt would chooses to, may go on to a different subject or a different line of questioning.
Sure. Did that NIST report conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
Can you repeat that?
Yeah. Did the report, the NIST report that you referenced, conclude that it remains unclear if visual inspection renders consistent number of contributor estimations?
She was
across
way
analysts
too
over
happy
time?
to be going up there.
I think that goes to the DNA evidence. Again, we never truly know the number of contributors in a forensic sample. So, like I mentioned before, you could have DNA mixtures that are made up of 2, 3, 4 individuals. I have training, I have experience, I followed standard operating procedures. So I'm making the best determination based on the evidence, the DNA evidence that I have as far as number of contributors goes.
Now, if I could, I'd like to return to your case notes, and could you display for the witness page 365 of tab number 4? And while he's doing that, by the way, it's true that if you change the number of contributors, you're going to get different numbers from the software program.
It depends. So actually, each time you run the software, you will get a different number based on the math that the software system does. But there are studies and validations that show we don't expect that math to be greatly different, usually by a factor of 10. Changing the number of contributors, it depends. If you have a major contributor, someone who's made up most of that DNA profile, if I originally interpret something as 3, calculate a statistic, if that major contributor is the individual that I'm comparing to, if I change the number of contributors to 2, based on the studies and based on my own experience, it doesn't change the likelihood ratio of that major contributor by much.
But it does change it, correct?
Yes.
And you just said, I think, that even when you put in the same parameters, you don't get the same answer if you run it through STR mix more than once, right?
That is correct. Based on how StarMix utilizes math and distributions, you will never get the same answer twice, but it will be no more than a magnitude of 10.
So that test is not reproducible in the sense that you can run it a sample or your assumptions in there 10 times, you could get 10 different answers.
That is true. Again, all within the first time I run StarMix, I'm not going to get a likelihood ratio of 10, and the second time get 10 quadrillion. I might get 10 quadrillion the first time, 2 quadrillion the second time, but even if I run it 10 times, I'm still going to get around the same likelihood ratio value.
Now, could you look at tab number 4, your case notes at page 365, if you could bring that up for the witness? Let me know when you have that in front of you. I think you need to scroll up one page. There There we go. Can you identify this page from your notes?
Yes, I can. These were notes that my technical reviewer made, and my technical reviewer, they will review all of my DNA evidence. They will draw their own conclusions as far as number of contributors and comparisons, then compare it back to my conclusions.
All right, so this is regarding the 7 sample, correct?
That is correct. That is one of the samples.
And your original assessment was that there were 3 contributors to this sample, right?
That is correct, yes.
And that conclusion was reviewed by a reviewer, correct?
Correct, yes.
She read the same electropherograms or the name for the output of this technology you use, correct?
She utilized the same electropherogram, which is the chart that the DNA is on.
And does this page in front of you, is that an accurate representation?
I jumped into I jumped into Nate's chat and I said, prosecution, Your Honor, we found this evidence on a fortune cookie. That one's
relevant because the witness originally determined that there were 3 contributors, and I'd like her to explain to the court how she reached that conclusion, because I think it does go to the reliability of her testing here.
All right, so as it relates to Baker 4, and this is her personal notes from Ms. Baker as it relates to what I'm assuming is State's Exhibit 31, that these notes were prepared as part of the report in State's Exhibit 31. I will find that it is relevant and that it is admitted into evidence. As regards to publication, what is the request?
Your Honor,
Mr. Byrd?
if I may clarify, I think the testimony was that this was not her notes. That these were the notes of her technical reviewer, is what I heard.
Please correct me if I misheard that from both sides. I want to make sure. I want to make sure. Are these Ms. Baker's notes?
Could I clarify that?
Absolutely.
Ms. Baker, these are notes in your case file, correct?
These are notes in my case file, but they're not my notes.
And the way your lab works, you're not the one that does all the different steps in the testing process, correct?
That is correct.
Other analysts have input that then all goes into the case file, which you have access to and rely upon in rendering your opinions.
That is correct, yes.
All right.
And this particular page is a note written by your peer reviewer that you relied upon.
Correct. After I made my interpretations and drew conclusions, my technical reviewer then reviews the data and draws their own conclusions. So this was created after I had already drew my own conclusions.
All right, I'm just trying to put it together here. So the question I'm trying to get to, counsel, is, was this particular, I recognize it as it being prepared by someone else, but as it relates to State's Exhibit 31, was this relied upon in order for State's Exhibit 31 to be put together as the report? Because I'm trying to determine relevancy as it relates to that, and that's a crucial point I don't have the answer to just yet.
It could be the team. But I don't like that it's not her notes. I don't like that.
Let me lay a more adequate foundation. The case file notes.
Oh, dude.
Are assessed by you at every step of the analysis, correct?
Not necessarily at every step. Before I issue a report, before I write a report, I review all of the case notes. So that will be any communication log entries, any documentation from the laboratory, the biologists that perform the DNA testing. I will review all of that, write a report, and then give that to a technical reviewer. They will draw their own conclusions to determine if they agree with me. If they do, they will sign off, and then my report and my case file will go for an administrative review to make sure that the laboratory number is correct on all the pages, that if there's any crossouts, there's dates and initials and so forth. Those 2 reviews have to be done before I can actually make it a final report and case file that gets submitted and sent to the field.
And in this case, correct me if I'm wrong, but the sequence was you originally determined in sample 7, that there were 3 contributors. That conclusion got reviewed. Then you ran some further testing, and then you change your conclusion, correct?
Why don't we have anyone
and
that
before you change
actually
your
took the
conclusion,
notes?
you of course go back and look at what the reviewer said about her review.
We would have a discussion. If I say a number of contributors was 3, he or she notated that it was 2. We had that discussion. She agreed with 3. So for that step of that process, because again, we're piecemealing this. Typically in a normal case, we will work all of the evidence. I will write a report. For this situation, I had DNA evidence coming to me throughout the day, throughout the night. So I had reviewers at different steps, which is not usual for a case. Usually I have 1 reviewer. So in this case, at that particular time, I had a reviewer. Then when I was submitted additional known samples and used those for comparisons, then I did have additional conclusions and additional reviewers.
But you certainly took into account this notation on this page before you changed your conclusion, correct?
I don't know that I would agree that I took into account. We had already had that conversation, and again, once I received additional known samples and additional information from the field, I then did amend my conclusion.
And these notes are kept in the ordinary course of your business?
Yes.
And they're part of the case file that you rely upon in reaching your conclusions?
They are kept with the case file after I draw my conclusions.
So, Your Honor, I think there's a foundation for this. The state has offered all kinds of hearsay here, and certainly this is, there's no question about the reliability of the entries.
All right. Anything further from the parties before I weigh in on, make my ruling on Baker 4?
No.
The court finds that it is relevant, and as it relates to State's Exhibit 31 and Baker 4 is admitted into evidence. In regards to publication, Mr. Burt, what is your request?
That it be published.
All right, in the courtroom?
In both the courtroom and to the cameras.
All right. Any objection, Mr. McBride? All right, go ahead and publish that to all screens and may be captured by the media.
So these notations at the top there, 7-1 male, discuss 3 NOC and okay with 3. Could you translate that for us, what that means?
Sure. So when my technical reviewer took a look at the DNA evidence, she determined that male DNA was present, and she concluded that she would have called it a number of contributor of 2. She compared it to my conclusions. I said number of contributor 3, so we had a discussion as to why she thought it was 2, why I thought it was 3, and she said she agreed with me calling it 3 based on her discussion.
Okay, so was that an extended discussion you had with her, or just?
No, this was a quick discussion, and this is not unusual. We have discussions like this during the technical process quite often.
And the stamp on the bottom, approved by Tara Benson, is that the reviewer?
Yes, it is.
Talking about? All right, thank you. Now, I want to ask you to look at page 128 of that same exhibit. No. Is this an electropherogram that is a part of your case file?
Yes, it is.
And is this an accurate representation of what's depicted on this page?
I'm sorry, there's nothing on the screen. Am I?
Yeah, 128.
Yes, it is.
I move that into evidence, Your Honor. This would be Baker 4, page 128.
Oh, I thought I already admitted Baker 4. Is this a different? The previous one was Baker 4, as I understood it.
Yeah,
and
Baker 4, page 365.
Oh, okay. So
And
Baker,
so this is Baker 4, page 128.
right, so the previous admitted exhibit is Baker 4, 365. The current proposed one is Baker 4, 128.
That's correct.
All right, Mr. McBride.
If I could have just a minute to update my notes on those page numbers.
All right.
Yeah, this is
365 was the previous
this is
one,
not looking
unless I
for
heard it
good for
wrong.
the prosecution, man.
All right, and the current one is 128.
Not looking good for the prosecution. That's why they were trying to. That's why they were trying to shut
First,
it
I'll
up.
note, this is the first I'm seeing these as exhibits. Of course, I have this file, but I was unaware that we were going to be, these are going to be offered
Yeah,
as
because you were
exhibits, so
just
I'm
going on hearsay
looking to find
like
them
the
in
past
my
week or
file
so.
as we go. Second, again, I'm going to object on relevance grounds to the probable cause determination. We're going through the finite details of the analysis here. And once again, I think these are appropriate questions to raise in a 702 hearing, but with the standards that apply at the preliminary hearing that I've already discussed, I think we're beyond the scope of probable cause determination as we dive into this evidence.
All right, Mr. Burt.
Your Honor, I think this exhibit is particularly important because the court does not yet have in front of it what an electropharogram is and how it's interpreted. And this particular page will illustrate to the court how the analysts interpreted the peaks on this electropharogram to reach the conclusions that she reached, that there were 3 and not 2 contributors. And I think it will assist the court in determining exactly how this comparison process works and what the output looks like, so the court can see exactly how the interpretations are being made.
And is this the dose that were relied upon I'm viewing State's Exhibit 31 as a summary, and this more of showing the work of how the summary was reached. Am I misunderstanding how this fits in?
This fits into how the analyst originally was of the opinion that there are 3 people here and not 2. And she will go on to explain how she changed the interpretation from 3 to 2. And the point of this is to illustrate to the court that this is a subjective process to a certain extent, and that people can read these things in different ways. And so I think it will help the court understand exactly what's being compared here. You've got peaks on a line, she will say, and just to let the court know in responsive to Mr. McBride's statement that he was unaware that this is going to be an issue, he and I met with this analyst before the preliminary hearing. The analyst pointed this page out to us as being illustrative of why she originally concluded that there were 3 contributors. So this is not something that's being sprung on the state. He was a part of that conversation, and this particular page was identified by the analyst, not by me. So it is important to understand why we went from 3 to 2 and what impact that has on the numbers that the state is offering.
All right. Anything further?
No.
All right. Under Utah Rule of Evidence 1102, B4, it says scientific, laboratory, or forensic reports and records. I find that this is admissible and is admitted into evidence as Baker 4, page 128, and is a request to publish this document.
Okay, you can.
Was that a yes? Oh, okay.
Yes.
All right. So published, I'm assuming to that
Yes.
screen as well. All right.
Correct.
It may be published. Council, just as a reminder, as this is a probable cause. I understand and I appreciate you give me a pointer of where it's going, but just as a reminder, as probable cause, it is admitted, and you may discuss it, but I definitely want to keep this within the track of probable cause.
Understood.
All right.
Thank you.
Mr. Burt.
Okay. Is it true what I just told the court, that you pointed this particular page out as illustrating why you originally thought we had 3 contributors?
Yes, that is true.
So explain to the court, is this an electropherogram?
Yes, this is an electropherogram. Each of those rectangles at the top, for example, D2S441, that is that small segment of DNA that I referred to earlier. And each of those peaks has a corresponding number that is the allele, so that corresponds to the number of repeats that an individual inherited.
And this is what you ultimately, after you get this electropherogram not through running it through STR-Mix. There's a different device that you use to produce these electropherograms, right?
Correct, yes. During the DNA process, this is the last step of that process. So what it's doing is DNA is found in cells of our body. We're taking those cells, we're breaking them open with chemicals to release the DNA from those cells. We're making photocopies of those pieces of DNA so that we can essentially see them. And then the last step is to separate those pieces by size, and the ultimate output is this electropherogram.
Okay. And is it true that you set the parameters for what the machine will pop up in terms of numbering the alleles?
Personally, I do not set that up. That was done during our validation of the chemicals and the software and the instrument that we utilize, but there are parameters. So the output of the DNA lets me know, for example, the different types of alleles, but that's not a parameter I set.
I want to make sure you answered that. You set, or your lab sets, what the machine does in terms of labeling particular alleles, correct?
Yes, that's part of the whole process and the validation, yes.
So you could tell the machine, give me all the peaks at whatever level and label them as whatever the alleles are.
I see. So yes, so during our validation, we determine our thresholds, our analytical threshold, and that stochastic threshold that I mentioned before. The analytical threshold is a threshold that was determined during validation that we input into the software that I utilize that says, for example, our analytical threshold is 150. Any peak that is 150 or greater, the software system will give me that allele call or that number for that peak. Any peak that's below the 150, the software system will not give me an allele call for it.
Even though it might be a true allele.
Correct, yes.
So you could say, and you referred to a measurement, you refer to that as RFUs, right?
Yes, that is the unit.
What does that mean?
It stands for relative fluorescent unit.
So in your lab, you tell the machine, only label peaks that come above 150 RFU.
The software that utilizes the information from the machine, yes.
However, it's true, is it not, that in determining the number of contributors, you look below that 150 RFU level.
And that is true, yes.
All right, now on this is only showing 4 different locations, right?
Correct, yes.
And you see a number of peaks at each one of these locations. Some of them are labeled, some of them are not.
Correct, yes.
So tell us how you originally looked at this and said there's not 2 contributors, there's 3.
Sure. So first what I do is I count how many labels that I see, so how many of those little squares under each of those locations. So for example, at D2S441, there are 3 squares. Knowing that one piece of information comes from mom and one comes from dad, if it's a single source profile from one individual, I expect to see no more than 2 squares. Because I see 3, that gives me an indication that there's at least 2 individuals. Same thing for the next D19S433. and as well as FGA. There were 3 peaks
Imagine that.
were called. So I knew this had to be at least 2 individuals. Then what I do is I take a look at the peaks that are not called and determine, could there potentially be a third person included? So for example, at D2, the location farthest to the left, I'm asking myself, that 12 in that bottom box, is it the same contributor as, for example, the 22 under FGA all the way to the right? Because I see peaks that are not labeled, it could be that the 12 belongs to one individual and those 2 peaks that are not called belong to a second or third individual. And that at FGA, I could be seeing the 22 from that third person, but that second person has dropped out. Because I'm able to use information below the threshold and I see peaks, that gives me an indication that I can increase my number of contributors to 3, which I did in this case.
Okay, and when did you reach that conclusion, time-wise?
If I recall, it was somewhere around September 12th.
And when did you change your conclusion?
That I would have to refer.
Sure.
Now, guys, remember she said at least 2